when we broke last night, um, we had taken a half-hour public comment, and we had broken into the department's cross-examination to do that. The way that we noticed up, though, in my pre-hearing order, public comment sessions was noon and 5 yesterday. The rest of this week, it will be 9 and 1. So let me just ask if there's anyone here for the 9 a.m. public comment. Anyone in the room? Just wave your hand. No. Is there anyone on the platform here for the 9 a.m. public comment period?
I am.
There will be 7 more chances, including at 1 o'clock today. Is that someone?
Oh, there it is. Yes. I don't know.
Are you unmuted?
I am here. I don't know why I am not showing up.
Pam, can you share the name? I can't read it from here. Oh, okay. Terrific. Ms. Christodoulou, can you speak up, please, so that we can hear you?
Okay, let's make sure I'm... All right, I'm at the max. Can you hear me?
You appear to be unmuted.
I know. Let's see. Can you hear me? Let's see what's wrong. Microphone. Can you see me?
I'm sorry. They're saying they could hear her online. I'm not sure if it's an issue with us.
We just can't hear her in the room.
Pam, do you need to ask for IT help so that we can hear? Oh, he's right there. Okay, great. Thank you. Okay, we wouldn't normally. You
Can you
normally
hear
do
me
that in
yet?
hearing, but I'm happy to put their names on the transcript.
Mr. Maxwell, can you hear us? I just want to see if it's her or just the whole system.
Mother, yes, I can.
Oh, okay, I can't hear you either. Thank you.
Thank you.
Ask him if his two species.
Okay, Mr. Maxwell, I'm sorry if you wouldn't mind saying something just to make sure I could hear you.
Yes, testing. Can you hear me?
Perfect. Perfect. Thank you so much for your help. We always appreciate it. So I think we're good now, Madam Hearing Officer.
Thank you. Ms. Christodoulou, can you speak up at this point?
Can you hear me?
Yes, if you would speak just a little louder. And
Okay, thank you.
thank you.
Is that loud enough?
Yes, that's perfect. Do you
Oh,
swear
great.
or affirm to tell the truth?
I do.
And if you would please spell your name for the transcript.
Okay. Athena, Athena, Christodoulou, Christodoulou.
Thank you very much. I'll start your 3 minutes now.
Commissioners, my name's Athena Christodoulou. I'm a retired Navy commander, an environmental and energy engineer, tech entrepreneur, and Christian living in Albuquerque. My first hat is environmental engineer. And so we're going to go over what produced water is. Produced water can contain, besides oil, where it comes from, a myriad of known and unknown compounds, including known hazardous materials. And to quote Shakespeare, a rose by any other name is still a rose. In other words, you can name it anything you want, but it doesn't change its properties. To mimic the bard, I say hazardous waste by any other name is still hazardous waste. And hazardous waste still has to be handled by the polluter as hazardous waste from cradle to grave, even if diluted, i.e. produced water. The entire amount must be disposed of properly and expensively. If someone wants to make money, get into the hazardous waste disposal business. And let's call produced water what it is. Diluted hazardous waste. Make the oil and gas industry pay for the hazardous waste they produce, not the taxpayers of New Mexico in a shell game where we are always the loser. Let's remember the uranium mines and the tailings which have polluted land, water, and air, leaving us to once again pay the price with poor health and high cancer rates. Where are those companies with their bags of money? Off enjoying Mar-a-Lago and Acapulco. Oh, wait, not Acapulco. Probably not now. Not since Hurricane Otis came in November. Hurricane Otis developed from a tropical storm to a Category 5 hurricane in less than 24 hours, and it wasn't even predicted to go past Category 2. And now, something else to think of. Our plant hardiness zone maps have changed in only a decade. Those are the maps that tell us when and where we should plant certain plants. My trees are suffering. Am I going to tell them to pull up their roots and walk north to get out of the heat? And let's talk about Dubai and how pollution can spread even when we don't want it to. They got rain, enough rain to cover 2 years worth of rain in one day. That meant all that water picked up all this dirty soil, all the pollutants, and spread it around for everybody to enjoy. They weren't planning on that. So I don't trust anyone who has lied to the people of the world for decades and now our planetary systems are truly out of whack. I don't trust them. And as a Christian, I say stop lying and killing us. You murderers will stand in judgment from God for destroying our earth. Let the people of New Mexico live with clean air, land, and water. Thank you.
Thank you very much. Is there anyone else on the platform who would like to offer public comment at this public comment session? There will be 7 more opportunities. Pam, will you tell me the name? I can't read it from here.
It's Carlos Matutes. He's on
Okay,
your list.
Carlos Matute. Can you hear me, sir?
Yes, ma'am, I can.
Oh, good. And I can hear you. Do you swear or affirm to tell the truth?
Yes, I do.
And would you spell your name for the transcript?
My name is Carlos, last name Matutes.
Thank you. I'll start your 3 minutes now.
Thank you very much. My name is Carlos Matutes, and I represent Green Latinos. We are a national organization dedicated to fighting for environmental justice for Latino communities and other communities of color. I'm here today to testify on behalf of all people of New Mexico. As you all probably know, we have the largest Latino population per capita in the entire nation. That means that our community, nuestras comunidades, are being adversely affected by pollutants at a higher rate than other communities. This produced water ruling is, to put it quite frankly, a boondoggle. Produced water is nothing more than toxic waste. And let's be very clear on public record. What petroleum companies are using additions to fracking water are considered trade secrets. Not only are there no scientifically verifiable methodologies for treating this toxic waste, but there can be no scientifically verifiable methodology because we don't know exactly what is in these fracking chemicals. Essentially, we're putting in our water supply in the desert chemicals that we don't know what they're doing. We do know that we have known carcinogens like benzene in high amounts in fracking chemicals. And as you probably all know, there is no safe max or minimum amount of benzene allowable. This is a highly dangerous chemical that is in virtually every fracking compound. I ask that we refuse to consider reusing toxic chemicals, no matter how much they're diluted, until we can have a verifiable methodology for treating this toxic waste. I request that produced water not be allowed in the state of New Mexico because it is our people, our environment, our future that is at stake. Thank you.
Thank you. Is there anyone else on the platform who would like to offer public comment this morning? Please raise your hand or reach out in the chat.
Madam Hearing Officer, I see Emily Lucas that has her hand raised as well.
I'm sorry, I couldn't hear you.
I'm sorry. Emily Lucas. She also-
Emily
Lucas.
Lucas.
Hi, can you hear me?
Yes. Ms. Lucas, do you swear or affirm to tell the truth?
Yes, I do.
Thank you. And would you spell your name for the transcript, please?
Yes, my name is Emily, Emily, Lucas, Lucas.
All right. I will start your 3 minutes now.
Thank you. Good morning, Commission members. My name is Emily Lucas. I'm from Albuquerque and a member of Youth United for Climate Crisis Action. As some of you may know, studies have found that there are PFAS, also known as forever chemicals, in the blood of nearly all Americans. Additionally, research has shown that there are forever chemicals that greatly exceed safe levels in most rainwater around the world. This so-called produced water contains various chemicals that are dangerous to human health. Among them are PFAS. And it is clear that PFAS impact human health negatively. The risks include increased risk of cancers, changes to the immune system, and low birth weights, to name just a few. Expanding the use of produced water will lead to more spills and more exposure to these chemicals. We need to be removing these toxins, not opening up a new avenue for them to spread into our water and soil and ultimately into our bodies. I would like you to consider who benefits from allowing more use of these hazardous chemicals. Despite shiny language, it's clear that the oil and gas industry are the ones who stand to gain the most. And who is going to bear the costs? The public, farmers, and the workers that directly interact with the toxic chemical fluid will suffer the costs unmitigated. There are no scientific standards for safety, and there is no requirement that cleanup of a spill will be paid for by the polluter. Instead, it will most likely fall on the public. We need to limit the spills instead of increasing their occurrences, which is what will happen if quote unquote produced water is used more widely. Policy should benefit the public as a whole, not just a tiny few. And as a young person, I am very aware of the state of our environment and water and what it will look like for me when I'm 60 and for the generations that come after. Please consider the long view and what this would mean for the decades to come. We cannot sit by and watch as the place that we call home is contaminated by toxins and we will not sit by as our loved ones suffer the consequences of putting profit over people. Thank you for your time.
Thank you, Ms. Lucas. Anyone else on the platform wish to offer public comment at this time? The next public comment session is at 1 o'clock today. Anyone else? Hammer Madai, would you read me a name, please?
There are two people with cameras on. One is Jane Yee and Jeffrey Haas.
All right. Let's start with Ms. Nee. Can you unmute yourself? Let's try that. Ms. Nee, the administrator has unmuted you from this end. You may have to unmute yourself on your own machine. So. Do you see that you're being asked to unmute yourself on the machine? Is there a chat message there, Pam?
Yes, she says she doesn't have any commentary at this time.
Oh, all right. Remind me the name of the other person.
Jeffrey Haas.
Mr. Haas, did you want to offer public comment?
I don't see him on the platform any longer.
Okay. If there is anyone else on the platform who would like to offer public comment at this time, please speak up, turn on your camera, or reach out through chat. Whereas I'm going to move back to the technical case, and we will have another public comment session today at 1. Pam, let me know.
Yes, I will.
Okay, I think we'll move back to the technical case at this point. When we broke into the technical case yesterday afternoon, again, we were in the middle of questioning of the department panel. This is Dr. Hu, Ms. Murphy, Ms. Fulham, Mr. Herman, and Ms. Lucas Kamat. Thank you. Excuse me. And when we broke, Mr. Chair Thompson was wrapping up his questioning. Let me go back to you, Mr. Chair, and ask if you had additional questions of the department panel.
Thank you, Madam Hearing Officer, and thank you to the panel. I appreciate your work, and I have no further questions.
All right, thank you. Vice Chair Armstrong, do you have questions of the department panel?
Yes, thank you. Just a few. Morning, folks. You know, yesterday in your testimony, you highlighted your experience, and I was just curious if, for the record, you could tell us as a group the collective experience in years of the folks testifying on behalf of the Environment Department?
Madam Chair,
Counting.
Madam Hearing.
Madam Hearing Officer. I'll get it together. Madam Hearing Officer, Mr. Chair, Commissioner Armstrong, I believe it may be in my rebuttal testimony. I believe it's over about 100 years. I have over 25 years. 25 years.
Yeah, I have over 25 years.
I have close to 18 years.
30 years for me.
7 years.
I think that does put you over 100 on my mental calculation. So thank you for that. I think that's relevant. You all have been doing this work for a long time. You've been through these types of rulemaking processes before, and you implement these types of regulations every day. And I think that's valuable for everybody to recognize. Yes, absolutely. I got 2 of them turned on. And I'm hearing myself, but I'll try to speak louder. My next question is because I heard some comments and opening statements yesterday from other parties and in the public comment. I just want to clarify, does this proposed regulation authorize any funding?
No.
Okay, thank you. Simply put, this body doesn't have the authority to authorize any funding, correct?
I believe that you guys are authorized to manage the Clean Water Revolving Fund, which is not within the Ground or Surface Water Quality Bureau and would not be related to this activity at all. And that would be the only funding that I know that you guys have any control over whatsoever.
Thank you. In my last set of questions, a really single question that might turn into more, is picking up on Commissioner Brankard's line of questioning yesterday. This notice of intent has been on the commission's mind recently. We sent a case back to MNRD and the Oil Conservation Commission because they had gone through a notice of intent process and not a permitting process. So my curiosity is why a notice of intent and not a permit process here?
Thank you for the question, Madam Hearing Officer, Mr. Chair. The notice of intent process that we've designed in this new regulation is intended to be a new notice of intent process that shouldn't be compared to the other notice of intent processes. But they relate to each other because we used the existing notice of intent process to build this one and to understand what we needed. And we developed it in order to essentially finalize our using of the old notice of intent process improperly. We've been using it, we've been shoehorning it into our process, but it's not the right way to go about it. And with the information that we will be receiving from these notices of intent, it's designed to give us the comfort level that we are doing the right thing and that it's being protective.
So I said it might lead to a couple other questions. One that I do have based on that. Yeah. So as part of the notice of intent, I don't know what we call them, applicants, entities, are required to provide, I want to look at the language here. They're required to submit to the department all research results, including lab analyses of all water contaminants in the untreated produced water and treated produced water. Is that a level of transparency that is new or in addition to what they would currently have to provide?
Absolutely. Right now, the existing notice of intent process simply states that they must estimate the water quality that will be in their actual discharge. This new notice of intent process for produced water specifically will essentially give the citizens of New Mexico something for their money when they pay us to evaluate those projects and to determine that there's not a discharge permit required for that activity.
And so I guess back to the bigger question of, why not a permit? looking at the language that Commissioner Brankert highlighted yesterday from the Produced Water Act, it says for uses regulated by WQCC, a person requires a permit from NMED before using the produced water. In the Water Quality Act provisions that came from that Produced Water Act legislation, it talks about a range of uses and not just discharge. And so again, my question is, and I guess maybe more direct, like Commissioner Brankford was asking yesterday, not just why an NOI process and not a permit process, but it says in here that you're required to get a permit for the uses. The Water Quality Act provisions say you need to have permitting for discharge, handling, transport, storage, recycling, or treatment for the disposition being a broader term than discharge. So can you help us walk through that one more time, why we aren't legally required to have a permit process here?
So if you're looking for a legal analysis, I'll turn to my lawyer, but I can give you the department's position policy-wise and implementation-wise. We're looking at this regulation, the proposed regulation, as looking through the lens of the Water Quality Act at the Produced Water Act. And so we're fitting within the process, or we're placing the process within the idea that the Water Quality Act gives us the authority to require notices of intent submissions, and that we're doing impartial fulfillment of the Produced Water Act related to the disposition of produced water. And so we have a different interpretation of the language in the Produced Water Act than Commissioner Brankart has. We believe that the language is somewhat circular, and it only relates that those other categories of the items are covered under the Produced Water Act as they relate to the disposition of produced water.
Commissioner Armstrong, I could hopefully add a little bit of clarity to that. Now that I have the act up, I can read it. The Produced Water Act states for uses regulated by the Water Quality Control Commission. And in my interpretation of that, not being an attorney, I read that as not adding to the authority of the act itself. And then when we go to the actual Water Quality Act, it says we shall adopt regulations to be administered by the department for the discharge, handling, transport, storage, recycling, or treatment for the disposition. And so that part where it says for the disposition means that it's already within the authority of the Water Quality Act and doesn't necessarily add to other authorities. Because the act requires us to protect for ground and surface water and develop regulations, as it states in 74.6.4 as the duties and powers of the commission, is to adopt regulations or adopt standards based on scientific evidence. We do not have sufficient evidence to bring before the commission today to say that we could write conditions that would be protective of ground and surface water. So therefore, we are asking the commission to give the department the authority to implement a decision-making process so that we can review these produced water demonstration projects statewide and get information of what's going on with the research so that we can ever come to a conclusion as to whether it would be treatable or reusable. It may or may not. We just don't have that information. So I think as we've read the Water Quality Act in tandem with the Produced Water Act, it really only gives the commission the authority for the disposition, which is the intent of the act initially.
And to add on to the add-on, the question regarding whether this is a notice of intent process or a perm process, it is our contention that we are requiring the submission of information a single time up front in order to get us over the bar of determining whether a project is being protective or not. we're not requiring ongoing monitoring beyond the submission of the final research results that will give us the information that we need to further. And that was the people of the state getting the money, or getting the work product for the money that they pay.
Okay, thanks. One last question then. In that case I referenced earlier where this commission sent it back to the Oil Conservation Commission or division for final determination, we took issue with the lack of any public involvement or notice process. What does that look like in a notice of intent process?
Historically, we have posted the notices of intent and the entire project pathway onto our website, and that is the extent of the public notice process, because of the fact that we're getting them over the bar of being protective. I think there's some clear differences between the OCD case and this process. I'm tangentially familiar with that case. I've read the filings on it, and I believe that much of the issue was actually stemmed from them not creating an administrative record on their determination prior to submission, or prior to requiring a discharge permit or a notice of intent submission. We are, I think, in a different zone of regulations with requiring a category of water that's identified by the Produced Water Act as specific to us, or specific to the Water Quality Control Commission and the Environment Department.
And of course, I will add on a little. The other part of this is that we are making this NOI process for demonstration projects of produced water public through this rulemaking process. Whereas instead of in OCD, they were relying on the already established regulations in 20.6.2. So our attempt is to outline what is needed in each of these demonstration projects. Once we have that, we'll be able to provide it to the public either upon request or on our website so that it's transparent.
Thank you. That's all my questions this morning.
Thank you. Commissioner Polidoro, I think I see you on the platform, or your name on the platform. Do you have questions of the department panel? In the event he reaches out, Pam, let me know. Commissioner McWilliams, do you have questions of the department panel?
Yeah, I have a few questions. Thank you for taking those questions today. Mentioned it just recently, the duties and powers of the commission in Section 11 of the Produced Water Act, Section P, shall adopt regulations for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition and road construction maintenance, roadway ice or dust control or other construction, or in the application of treated produced water to land for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil or gas. Is it your testimony that the legislature did intend for the produced water uses and discharges outside of the oil and gas industry?
Commissioner McWilliams, thank you for the question. I am unsure what the legislature had intended, but the way that the language currently reads is for the disposition as required under the Water Quality Act. And so, again, as we've testified, we believe that it's for the disposition within the regulatory authority of the Water Quality Act and doesn't necessarily extend beyond that.
Section of the Water Quality Act states the regulations adopted by the commission may specify a standard of performance for new sources that reflects the greatest reduction in the concentration of water contaminants that the commission determines to be achievable through the application of the best available demonstrated control technology, processes, operating methods, or other alternatives. Would there not be a reason or why wouldn't you want to allow the discharge of produced water if the applicant can prove it is free of contaminants, carcinogens, PFAS, um, whether they run a full pollutant scan, um, those things that are achievable through the best demonstrated available control technology, processes, and operating methods.
Commissioner McWilliams, I'll start with this question and I will refer to our expert witnesses on the constituents in produced water. Our regulations in 20.6.2, which this is supplemental, would be supplemental to, and 20.6.4, which are water quality standards, have constituents that we would expect to see in most sources of wastewater, being domestic and industrial. However, with produced water, as we've provided in our direct testimony and in our rebuttal testimony, the constituents in produced water are highly variable and they are also unknown for the most part. We have some idea and we can treat for some of the constituents, but when you don't have source water characterization, meeting our standards in 3103, 20.6.2.3103 may not be sufficient for the protection of groundwater and human health. And this is where I'd like to hand it over to Dr. Hu to explain a little bit more about some of the known and unknown constituents and the studies that have been done and what that's highlighting for us right now.
Madam Hearing Officer, Mr. Chair, Commissioner McWilliams. As stated in my written testimony, the constituents found in produced water are diverse and variable, including elements such as oil, grease, suspended solids, dissolved solids, heavy metals, natural occurring radioactive metals, dissolved gases, microorganisms, and a wide range of known and unknown compounds. Yeah. So based on a comprehensive literature review conducted by researchers from the Environmental Defense Fund, a total of more than 1,000 chemicals have been identified in produced water from onshore oil and gas production sites in Canada, Mexico, or the United States. And they include toxic organization and inorganic compounds. The physical and chemical characteristics of produced water from both unconventional wells and conventional wells exhibit a significant variability influenced by several factors such as geographic location, geological history, the type of hydrocarbon product being produced, and well age. So it's clear produced water is not uniform even within the same basin. So produced water contains a wide range of compositions from simple to highly complex. So therefore, making conclusion about its characteristics based on one or few studies is insufficient due to its variability. So that's the reason we need more detailed and region-specific studies to learn about the characteristics of the produced water.
Yeah, I agree with you on that there is a lot of variability, but I'm wondering if the applicant, if you will, could prove maybe there's a subsection of produced water that has less variability or has less contaminants that can be proven. Why wouldn't you put the burden of proof, whether or not they could, maybe it's unattainable, but if the burden of proof was on the applicant to prove the quality and maybe even the pollutants that are in it, the incentive I think would be there for them to provide data showing why this technology would work.
So thank you for the question. I think the demonstration projects are designed to get us that information. And from an implementation standpoint, I want to go through a hypothetical scenario. If someone were to submit an application for us, the type of permit that we would draft in response to that, to get us to the point of being able to allow for a discharge, let's say we would require reverse osmosis. It's non-selective. We know what it can do. We would require them to hold that water, test it, verify that they've removed the constituents of every single one of our constituents in 3103. These are things that I've just thought about in my head while going through it. And there would be a level of verification and consideration for that water that would make it end up being $14 a gallon to treat. And we would then be said to be creating an economic burden on, it's a back and forth that we've just, it's hard to comprehend a way that we would be able to do it safely without this information from the demonstration projects.
Along those lines, do the NOIs that are submitted become public record?
Absolutely.
So I guess my concern there is that this could limit innovation because the companies that are willing to put in the research and development dollars may have nothing left for their work because it becomes public knowledge to any company that wants to use it going forward. So I feel like this might, the fact that it becomes public, I think is problematic business wise and could stifle the innovation.
Thank you for the question. It's one that we've grappled with since the very beginning. We originally, I don't want to let too much inside ball out, but we had a full rule drafted with confidential business information language in it back in 2019 when we started the process. The end result was the Water Quality Act says that data cannot be confidential. And so we have held on to that, and that we cannot promulgate regulations or that we cannot propose regulations based off of confidential information. We can require, or we can promulgate confidential business information regulations, or according to the Water Quality Act. So I feel like we are hand tied at this time, at this juncture, by the Water Quality Act to not require, to not allow for confidential data to be used in our process.
Could you not have the information be confidential to the public, but open to the department? So the department has really no. Okay, interesting.
No, sorry.
One more question is using the source of the water as a main method to classify the water as acceptable to discharge or not. Is that new? Is it developed for this specific purpose, or have you always used the source of the water to determine whether or not it was able to be discharged?
Thanks for the question. Yes. When we draft permits, we consider the source water with permit conditions specific to that type of wastewater influent. So domestic wastewater, we have standardized permit conditions that we use for those. Industrial, for radioactive liquid waste treatment facilities, we have specific ones for those. And so in effect, we do take into account the influent type coming into a treatment system. One of those other small quirks in the Water Quality Act is we don't generally have the authority to monitor influent. We are given the authority to monitor the discharge from the pipe. And there's some arguments in our regulations on whether or not we can regulate only at groundwater for the groundwater permitting. But essentially a specific regulation for a type of water is anticipated in the dairy rule, the copper rule, and now in this rule.
All right, thank you. No more questions.
All right, thank you. Commissioner Dominguez.
Thank you. I'm hearing lots. Okay, I've got a series of questions here. Some of these I'll throw out to the panel. Whoever wants to be the victim can go ahead and jump on the question. I may get to a few questions that would be specific to a person's testimony. So my series of questions may not be quite as well organized as my colleague to the right, but bear with me on this. So let's talk a little bit more about the notice of intent. So this is going to go back a little bit to the conversation about NOI versus permit. In your notice of intent, it indicates this specific information has to be submitted prior to use. So I'm reading the last of the sentence of C1. So the NOI gets prepared before they can do anything. Is that correct?
Madam Chair, I keep doing that. Madam Hearing Officer, Mr. Chair. Commissioner Dominguez, my apologies. As far as your question, correct. They would have to submit the notice of intent before they begin a demonstration project.
Okay. So I'm looking at your amended version of the rule itself. So I believe that's NMED Exhibit 175. And you incorporated suggestions made by, I believe, Amigos Bravos.
Right.
So that's specifically item A3, which was the concentration of water contaminants in the untreated produced water used in the demonstration project, etc.
That is correct.
So if they have to submit the NOI prior to use, how can they do the research to find all the contaminants if they have to submit the NOI before they do anything?
Commissioner Dominguez, when they have the water, they will do a source characterization before they, so the water exists, whether they're not pulling the water up just for the demonstration project. And it is usually a conglomerate of multiple wells that they want to use. They would have to do source characterization. So we're not asking for the effluent quality, which is the end product quality. We're asking for the influent quality, which Mr. Herman discussed the importance of needing to know what they would be treating for, what is in that source water. And so I don't believe that that would be holding up the process, and anybody who wants to treat a wastewater should know what they are treating for in order to know what types of treatment methodologies they want to research or test.
Okay. I understand where you're coming from. Just the way that this is structured, the writing of it seems somewhat circular. And there's a concern there that somebody doing a project may go, well, I can't give that information because I have to submit the NOI before I can use the actual produced water.
So in preparation for this hearing, I was reading the 1973 Barnstormers, the hearing record for the original notice of intent process. And the same a similar concern came up from the commission at that time, that how can you tell what's in your effluent if you haven't even started the discharge at that time? And we're not necessarily looking for the exact quantities and concentrations. It's a matter of what is your expectation. You know these wells are coming from these formations. You know these wells are coming from these different companies or these different processes. What are the known knowns that you have coming in? Give us the information so that we can make our decision based off of that information.
Okay, thank you. So along the same lines of NOI and versus permit. So let's assume with the scenario that a permit's not required. They proceed with a project. At the end of that, and they're required to submit the results of everything that came out of the research projects. That gets submitted to the department, correct?
Yes.
So this seems to almost get back to a permit requirement where you're asking for a follow-up result or something that you've decided. When I say you, the department has decided that does not require permit. Therefore, your regulatory authority has somewhat been set aside, yet they're required to follow up based on an NOI.
Commissioner Dominguez, I will try and answer this one. Essentially, we put in, and you're referring to the proposed language in 20.6.4.8, 400. Two. No, there's a C2. Where it states persons implementing a demonstration project or industrial projects pursuant to this section shall submit to the department all research results, including lab analysis of water contaminants in the untreated produced water and treated produced water. This is to assist, and we tried to make this clear in the regulation. This is to assist the department in developing standards and assist the commission in promulgation of regulations for use of treated produced water. This language was specifically put in to try and fill in and tie in the Produced Water Act language with the language in the Water Quality Act, because at this time we have no authority over anybody to get any information in order to promulgate these regulations. And that has put us kind of in a bind at this point. So although this part, it's not for a permitting action, it is specific to meet the requirements under the Water Quality Act, which say that we will promulgate regulations. That's what that is for. And it is not a permitting requirement. Permitting requires routine monitoring and assertions. This is just to gather information under the act.
And I'll just add to that, I think the major difference in my head between a permitting and an NOI action is a permit is a permitting submission, permit requirement. A submission required by a permit would be for compliance purposes and compliance evaluation. And this is in a different realm. This is something that is not going to be utilized for compliance. It's going to be utilized for regulation development.
Thank you for that answer. That gave me another question.
Oh, goody.
So, under that scenario, if no permits required, they do the research project, and they do not submit the results to you, what then is your compliance tool?
Mm-hmm.
Because it's not a permit. Are you going to take away their NOI?
So no, thank you for that question. And I've thought about this. The Water Quality Act gives us the authority to find them in violation of a permit condition, the Water Quality Act, or the regulations. that would be a violation of the regulations, and I could enforce upon them with a notice of violation or an administrative compliance order.
Okay, thank you for that answer. The fee portion and the financial assurance portion related to the NOI, when would those two aspects kick in? Would those kick in when a permit's required? Or if an NOI is just approved?
Commissioner Dominguez, you're referring to in the section where it says financial insurance in place to cover the cost of cleanup remediation in the event of a failure during operation.
Correct.
That's essentially spills happen. And under our current regulations 20.6.2.1203, we do have requirements to report a spill. Part of this NOI process is that they're demonstrating that it will not impact ground or surface water because it will not touch ground or the surface. However, spills happen. And so the cost of cleanup for something that we don't know the contaminants to and the extent that it could cause injury, we have asked that the commission consider this part of this submission to include that financial assurance, because there's been a lot of public comment about who's going to pick up the cost if something does spill. So we can assure that based on their actions that it won't reach ground or surface water. We can't guarantee spills. And so this gives the assurance that the entity that wants to do the demonstration project has the financial backing to clean up a spill in the event of a release, an unintended release.
Okay, thank you for that. The next part of that question was going to be, since some of the research that's been done is based out of our universities. Have you talked to universities about financial assurance and how a public institution will handle the financial assurance aspect?
Thank you for the question. Having been deeply involved in the Los Alamos National Labs financial assurance negotiations, we have not specifically spoken to the NMSU, UNM, or any of those groups, but I believe that we have the creativity to make sure that we are fulfilling this requirement of the NOI process and working with these institutions to ensure that they are able to do it within their bounds. With the DOE and DOD sites, we have changed the name of it from financial assurance to financial responsibility, because they can only request budget from Congress. So in this case, I would see that they would need to go to their board of regents to ensure that they have that type of assurance in place, or that they have some sort of mechanism to make sure that there's a budget allocation process for them in place. So I believe we have the methods and means to make that happen.
Okay, thank you. And believe me, this line of questioning is more geared towards trying to get you guys the tools that you're needed, because obviously there's not the information to set standards, or at least for a lot of constituents. You need the data out of it in order to take that next step, or so forth. So the research is important, and we understand that. To follow up on a line of questionings from Commissioner McWilliams, I'm going to circle back to the proprietary aspect. Being tied to a university system as I currently am, I understand many times researchers at a university setting still have eyes set on patent opportunities. And obviously for the private sector, that's key for them. If this rule gets structured where some of those opportunities are lost, I have a concern that the research will then be pushed out of state. This commission and the department then have no authorities. The research will get done. You will get zero results out of it, and thus we don't benefit whatsoever out of it. And it's a concern that I have that we're in the testimony. It's been talked about this rule will hopefully enhance research and so forth. I may be on the other side of the fence having the concern that it may push it underground. And that's more of a probably a comment than a question, but if you've got a follow-up comment, feel free.
Commissioner Dominguez, I think it's an important question, and it does follow up on the concerns Commissioner McWilliams brought up. And I'm going to try and elaborate a little bit more. As a state entity, being responsible and servants to the public, being transparent with data and information that could impact ground or surface water is what we do. However, we do recognize that there are a lot of proprietary chemicals that are used in non-conventional, unconventional wells, the ones that use fracking fluids. And that, based on Ms. Murphy's testimony, is the predominant source of excess produced water that's not already recycled in the oil and gas field. So we're in kind of a rock and a hard place when it comes to trying to implement research while still protecting potential proprietary or confidentiality with businesses looking to treat this. First and foremost, our job as the department is to protect ground and surface water. I see this in other states, and I will have Ms. Murphy speak a little bit more on the other states, because that has been brought up that other states allow for produced water reuse. And I will say, after reviewing her testimony, there are a lot of limitations on that, because likewise, they have to protect their resources as well and human health. Even in Texas, which does allow for, or has put out guidance for the reuse on projects for land disposal or land applications, sorry. They have an initial application process to do these projects that will cost thousands of dollars just to apply, because we're trying to strike the balance between research and then being overly burdensome. And Texas has taken the approach that they will allow you to do these demonstration projects for a very limited amount of time, but you have to sample for an extensive amount of constituents. And I believe NMED entered that as an exhibit as to the process that Texas takes. All the states are struggling. Most of the states that do allow for reuse of produced water is either coal bed methane water, which has a lower TDS, less constituents that are of concern, and non-fracked water. And at this point, before I get myself in trouble on things I did not testify to, I will actually give it to Ms. Murphy to elaborate a little bit more on that.
Good morning. I just have one thing to add, and it also comes back to Commissioner McWilliams' question. And in my testimony, I said, I was asked, does the proposed rule prescribe what treatment process a demonstration project should use? And so we're less interested in all the deep specifics of the process. we're more interested to know that at the beginning of the project, the water is thoroughly characterized. It's run through the treatment process, and then it's thoroughly characterized at the end. And we do have a best available technology in the Produced Water Research Consortium's guideline for sampling and analysis. And that is the NPDES Plus list, whole effluent toxicology testing and non-targeted analysis. So it's less important to us to have the specific confidential business data on the treatment process.
Thank you. Let's shift gears a little bit and get into some more specifics that maybe are a little more clear cut. So under your definition of wastewater, the last step or the last sentence of that definition indicates that dairy wastewater is not included in the definition of wastewater, correct?
Correct.
But in your definition of agricultural application, we're back to A1, agricultural application. Included in that is operation or maintenance of feedlots or animal feeding operations. Is a dairy not classified as an AFO?
Commissioner Dominguez, this gives me the opportunity to reiterate the importance of source water as a wastewater that is treated for use in an application or the discharge. So the wastewater is the source water, and so dairy wastewater is not included. However, agricultural application is a subpart or subcategory. Thank you. For the discharges. So someone could take domestic wastewater, treat it to a particular, and right now it's just a case-by-case basis in our discharge permits. We do have situations, but they could take that treated wastewater and use it in an agricultural application. So they could use it at a dairy or a concentrated animal feed operation. So that really highlights the need for separating and defining for implementation purposes, which this rule we hope will help us with, between a wastewater, which is the source that is going to be treated, and the application, which is where it is discharged.
Okay, thank you for that clarification. I was just wanting them to get it clear in my mind. Those almost seem circular within the definitions or exemptions. But thank you for that one. A quick question on flood irrigation application. Within that, you refer to low flow emitters. Help me understand how you're classifying low flow emitters, because in my career, low flow emitters more closely associate with drip irrigation than it does flood irrigation. So please expound upon that.
Commissioner Dominguez, that's a really good question, and I'll hand it over to Mr. Herman to elaborate further.
So it's definitely a adjacent issue. The idea being, when you're looking at the reuse of domestic wastewater, which these were somewhat drafted with the mind in our minds, that it's a matter of the contact of the water and where the water contacts and for what time frame that the water contacts the vegetation. So flood irrigation is closer, even though quantity is not an aspect that we're looking at. It's closer to drip irrigation than spray irrigation, which would aerosolize or have a different exposure route that we'd be concerned with. So it's more about the exposure routes that we classify them as.
Understand that from given the change with the spray irrigation. It's something that some thought may need to be given to if and when flood irrigation application ever occurs, the person doing some things may have questions as far as how they can be in compliance. But that's helpful from that standpoint. I think a number of these questions are probably for Ms. Fulham. Around your testimony about two things: definitions in general and constructing the rule itself. So let's start with, if a term is defined in the statute, is it necessary to repeat it as a definition in a rule?
Commissioner Dominguez, in some instances, when the definition in the act is comprehensive and addresses all the components that are needed for implementation without interpretation, my job is to try and reduce the amount of interpretation and provide clarity to the regulated community and the public. And I'll point out the Produced Water Act in particular, because produced water in the act is very general, and the technical staff that we have here today have had to work through nuances which seem very obvious to perhaps the general public or to in passing. But the idea of flowback water, of the constituents in the produced water, is very relevant to being able to implement this rule, because we have heard in and out through technical conversations of whether that a certain component would even apply as being produced water or its effect. And when we're talking about produced water, and again, as Ms. Murphy says and talks about in her testimony, the location and the type of water that we're dealing with is unconventional, fracked, produced water that does have different components to it. So in the Produced Water Act, it's very general. However, for implementation purposes, we want to be explicitly clear as to what is contained. So occasionally we will take the language of an act and add to it for implementation purposes to provide consistent and clear implementation. Sorry.
Okay, thank you. And you must have been reading my mind, looking at the term produced water, which is now utilized in both the statute and the proposed rule. Which, let's say something goes to court, if this is a legal question, let Mr. Knight answer it. If there's, which definition takes precedence?
I will start, and then I'm gonna let Andrew, Mr. Knight, take over. The way being very specific to produced water, because that is one of the definitions that's very clearly in the act. and in our proposed regulations. We took the definition of produced water. We did not take away from the definition in the act. We just added clarity onto it. And so I would say that I'll let Mr. Knight, we tried to do it in a way that the act is overarching, but this provides the clarity for implementation.
Is this on? Madam Hearing Officer, Mr. Chairman, Commissioner Dominguez, my words are not testimony, as I am not a witness, and I would just with that caveat say that for purposes in speaking in general terms, for purposes of implementing and enforcing this rule, we can define a term within the rule, and that's what it means when we're implementing and enforcing that rule. And if you're implementing and enforcing the statute, then the definition in the statute controls. And that is, this is not the only case in New Mexico administrative law where that occurs.
Thank you, Mr. Knight. I'll follow up then with another question. Is it not, I don't want to say standard practice, but is it not the court standing that if there's a conflict between statute and rules, statute overrides rules, correct?
Madam Hearing Officer, Mr. Chairman, Commissioner Dominguez, as a general rule, that is true, but as with everything in law, there are exceptions.
Thank you. I'm not that I'm anticipating a court case, but I'm trying to make sure the commission has to take everything into consideration here. So Ms. Fulham, I had a lot of testimony and additional testimony regarding the definitions that are included here that are not used or only used for other definitions. And maybe we'll focus more on those that are not used in the rule at all. So we'll start with the question of nothing precludes the department, as this rule has been stated, it's an iterative process that you guys are anticipating revising down the road as more of the pieces come together. Nothing would preclude the department of adding new definitions at that point in time as they become applicable to an amended rule. Is that a fair statement?
Commissioner Dominguez, yes.
And I understand the department's vision of trying to front load this rule with as much as can assist, not just currently, but as the process moves forward. One of my concerns is with any rule that it be as meaningful to the regulated community as well as the general public. I had multiple people in my agency review this rule because my first review, I was confused, so I just pawned it off on other folks. Every person came back with the same comments about, I'm trying to find out where food crop application used because I found the definition, therefore I'm assuming it's used. And I believe, not just from some of the public comments, but other parties' technical testimony, there's some issues there. I have a concern that we get misinterpretation, more so from the general public, that people think produced water can be used to produce food crops in this state because they've seen a term. As a regulatory agency, I know you guys have a view of it that may be different than the general public. And I would encourage you to look at some of those terms that could be misinterpreted. It gives me pause. So, I know you testified that State Record Center Administrative Law Division reviewed it for style and format. Would you agree with me that that's their rule? That's their role, is to review for style and format more so than for content?
Commissioner Dominguez, yes. The Administrative Law Division's role is to ensure that it's consistent with the regulations for developing New Mexico Administrative Code. And part of that would be whether it meets the legislative style format, the relevant portions of that.
Okay. And in your testimony, you spoke about that the State Rules Act and the state rule on rulemaking 1.24.10, I believe, did not specifically state that definitions that weren't used in a rule can't be, or something along those lines, that it was not clear structured in the State Rules Act or 1.24.10.
I apologize. Can you repeat that again?
Is that, so your testimony was somewhat along the lines that there wasn't clear statutory or in-MAC language, whether a definition that's not used in a rule could or could not be in the rule.
Commissioner Dominguez, yes, I referred to the regulation for New Mexico Administrative Code, which you're correct, in my testimony, it's 1.24.10. And I believe it may be section or subsection 12.
12.
So I've gone through that time and time again, because this is, I think, my 7th rulemaking. And I wanted to make sure I understand the concern, and we had weighed it pretty heavily when we were developing, particularly the definitions for applications. And we did refer to this New Mexico Administrative Code regulation I do work with state records regularly to ensure that what we're doing is not outside of the style and format that's required under NMAC, and they really are my go-to for meeting those requirements. And so there is nothing in the regulation that prohibits or discusses whether or not a definition has to be in the rule itself. I would also like to add that the implementation of these applications is not necessarily for future implementation. It's for current implementation of our discharge permits. I manage 95 plus discharge permits. I have 4 applications sitting on my desk for new discharges. Domestic wastewater reuse occurs in the state of in New Mexico, and I believe it's in my direct testimony as to an estimated amount of volume that I can look it up. It's millions of gallons a day of domestic reuse that's going out onto golf courses, parks, schools. Some entire communities use all outdoor watering with domestic wastewater reuse. These terms are very specific to current implementation of discharge permits and to help these regulated communities understand, based on risk, what kind of conditions are in their permits. Currently, everything goes through me and I try and keep it aligned. Public doesn't have a say as to what that is. That's why these applications in particular may not be referenced in the rule, but they are critical for our implementation for protection of groundwater. Probably went a little over on that one.
No, that helps provide perspective of where you guys are coming from. It's not necessarily just focused on produced water, correct?
That is correct.
And I think that's where I'll let the regulated community speak for them, but you hear comments from the general public that are focused on produced water. Your rule, when you came out with that, broadened to address water reuse. And there may be a disconnect with the general public between water reuse as a whole and produced water. And that may be problematic for all of us.
Yeah, I would like to reiterate, this is a water reuse rule supplemental to assist our permits, not a produced water rule.
Thank you. And I believe most of us up here understand that. I'm not for sure that the general public gets that grasp on it. Now, reflecting back to the 95 permits that you spoke of that are probably permitted under what, 20.6.2?
Correct.
If a discharge is permitted under a particular rule, would it not be more beneficial for that regulated community that's operating under, let's say, 20.6.2, for that needed definition to be placed in 20.6.2 versus a separate rule? Granted, it's a supplemental rule, but I'm viewing it from the regulated community standpoint that they're not having to do this, figure out how they have to comply.
Commissioner Dominguez, we did consider whether we should include this language, including the produced water, because of the Produced Water Act and Water Quality Act, whether we should try to come to the commission with an amended version of 20.6.2 NMAC. However, if you've looked at 20.6.2, it covers a broad range of activities to protect ground and surface water. And working with the regulated community for over, I think about 20, yeah, well over 20 years now, that can cause problems both for the regulator as well as for the person who has to adhere to those regulations. Having a supplemental rule that's specific to water reuse is much more concise and direct for that regulated community. Being able to point to these definitions, and when we we build out the other sections of it, when that's mature enough, that will be so critical for helping in implementation and compliance. One of my issues as a regulator is trying to show people where this rule exists and why it exists, and fumbling through 20.6.2, which covers everything from permitting to federal NPDES permits to abatement. It's long, it's complex, and it would just add to more confusion, in my personal opinion, working with the communities, than to have one regulation based on the area of interest that they have for the particular wastewater type that they have, which poses a, a similar risk to others of their type.
If I could just add on to that, the arguments regarding including definitions in a regulation that don't exist in the regulation would still be valid in 20.6.2. We were trying to choose between the difficult and the ultimately insanely difficult. We chose the easier of the two.
Yeah, granted, I understand no one wants to open 20.6.2 back or something along those lines. So I understand that aspect. Also in your testimony, you reflected on the legislative drafting manual. And when there is not clarity in statute or rules for many things, I know before this commission, there's times that councils will say, well, lack of clarity, we looked at the Administrative Procedures Act, which is not part of our role, but they look for it to guide. I think the legislative drafting manual is exactly that, guidance, and the lack of clarity within a rule or act. It's a guidance to go to. Be a little no different than utilizing the Uniform Statutes and Rules Construction Act that gives guidance on things, and in particular within it, the principle of construction section states a statute or rule is constructed to give effect to its entire content. Getting back to, if we've got definitions that don't apply in that rule but apply somewhere else, if we're almost skirting the intent of the Uniform Statutes and Rules Construction Act. Those items give me pause, and something I'm going to have to look at real close before we move forward with parts of this. And with that, I will give you a breather with my line of questioning. I thank the panel for indulging my questions. Thank you, Madam Chair.
Thank you, Commissioner Dominguez. Let's take a 10-minute break and we'll come back to more commission questions. All right, Commissioner McWilliams, I understand you have another question of the panel.
Yes, sorry. I thought of another question after Commissioner Dominguez questioning, and I just wanted to ask a question, one quick question. I know the Produced Water Act was enacted in 2019, which was 5 years ago. And I was wondering if a company or a university were to do a demonstration project that provided a level of comfort, a full characterization of the source fluid and a full characterization of the effluent created. How long do you guys anticipate would it take for one of those demonstration projects to become actual, promulgate rules for it and be able to use for discharge? Do we think it'd be another 5 years, or, any idea on what would we expect to be a result of one of those successful demonstration projects?
Thank you for the question, Commissioner McWilliams. I do want to clarify that a single demonstration project, as based on Ms. Murphy and Dr. Hu's testimony, is unlikely to be comprehensive enough to characterize the water in the Permian Basin sufficiently to know what the constituents are, all the treatment processes that would have to be undertaken, and what the consistent effluent quality could be. And so I will reiterate that we need many demonstration projects, and the extent that entities are willing to test and explore that, we want to encourage. We also don't want to be prescriptive to the point in which we are hindering any innovation or treatment methodologies that we don't have the answers. And so part of this rule in that NOI process with the demonstration projects is to bring in a considerable amount of information of the various types of treatments and what they can remove and what's in the characterization. As far as the rulemaking process goes, as I've said, this is my 7th rulemaking that I've participated in. And in general, a rulemaking should be expected from the time we have a good idea of what the language in the rule, what we're aiming for. It can take up to 4 to 6 years. And because there is an extensive amount of work that goes into the drafting, into the advisory committees, which is critical for these particular rules in reuse, and then the stakeholder outreach, tribal outreach, public outreach, and then having the time for all interested parties to read, review, and provide testimony, it adds up. So a rulemaking process is not something that can be done in a year, 2 years, as we've been working very actively on this particular rule, was still fairly expedited. And so I would say that when we got to that point, the rulemaking process in and of itself would take 4 to 6 years.
Okay, that's helpful. How many demonstration projects would be, required in order to prove a technology?
Thank you, Commissioner. I believe, and I know that you're thinking of the San Juan Basin, and that is a vastly different water than the Delaware Basin. And so, again, we have a best available technology for sampling and analysis, and that's from the consortium. And we just need people to begin. We have so little data. And so it could be that it's water, the produced water is thoroughly characterized in the San Juan Basin before the Delaware Basin, but we just need projects to begin and give us a level of comfort. And we'll probably need hundreds of samples.
If I could maybe try to get a little bit closer to the core of your
Yeah, hold on
question.
just
Sure,
one
sorry.
second. Just to clarify, I actually don't think it's applicable in the San Juan Basin. We produce such little amounts of produced water. I don't think that this Produced Water Act and the subsequent rules really will apply to the San Juan Basin. So this is more just for the rule itself, not
Okay.
my questioning is not related to the San Juan Basin. Now go ahead, Mr. Herman.
Sorry. I think the core of your question is how much work needs to be done before we have enough information. And it's difficult to pinpoint a number, but if someone were to do a comprehensive study in the Permian Basin or in the Delaware Basin, where they took 1,000 samples from 1,000 different wells and tested all of them on different technologies and did it all monochromatically across the board, it could be that one study. There's not really a finish line that we have in mind at this time. And to get back to Ms. Fulham's response, we've done a lot of the front end work on the produced water rule by doing this, and we have a lot of the chess pieces in place. We have staff that are onboarded that are specific to produced water. And I think I may be more optimistic than Ms. Fulham. I know we have, right now, we are working on IPR and DPR regulations concurrently as we're going through this process. I don't sleep very much at this point as a result of those things. And I think that there's some concurrent efforts that are going on right now that would also benefit future rulemaking processes. And since 2019, we've been anticipating the arrival of large quantities of data. And we're in the position that we're in now with the rule that we're proposing as a result of that lack of arrival of that data and information.
Okay. Thank you.
Okay. Is that all, Commissioner McWilliams? All right. Commissioner Fry?
Thank you, Madam Hearing Officer. And I want to thank all of you for, it's obvious you've put in a lot of time into these rules and into your testimony. And I'm very grateful for all the material you're providing us. And I want to thank Commissioner McWilliams for feeding right into my questions. So she kind of got at, the process, how long, for me, it's the timing in this question. And she got at the question of how long we might get to a place where technology can be approved for this application. The other element of that is what's the timeline for establishing standards that these applications can be measured against?
Commissioner Fry, I will start off and probably hand off so everybody can provide a little bit more input. As far as the Water Quality Act, and as a scientist, in order to develop standards, the Water Quality Act requires us to have scientifically defensible data in which those standards are applied on. And when we're talking about standards, we're talking about the protection of human health as it pertains to ground and surface water. And so there has to be sufficient information that's defensible, that has the quality assurance mechanisms to ensure that bias is reduced, there's repeatability. These are called data quality indicators. And in order to establish those data quality indicators to a level that's robust enough in order to implement or propose a particular water quality standard for a toxic pollutant or a constituent of concern that could cause harm to human health, we have to understand first the toxicology to understand the contaminants, and we have to be able to defend that. The concern that we have with produced water at this point is that there are a lot of unknown constituents. Some may be harmful, some may not, some may be benign, but without knowing, it is difficult to say that it would be protective. And so the volume and the amount of information that is needed in order to develop particular standards particular to the constituents in produced water may take some time. And again, this rule is not to be overly prescriptive. It's almost like a ability to call for data so that it can support this. And we have worked with the New Mexico Produced Water Research Consortium for the past 5 years now in order to try and facilitate these types of demonstration projects. At this point, and as you can see on our website that has all of the demonstration projects that have been conducted as we know them in the state of New Mexico, there is exceptionally limited data. And this rule is to help facilitate the submission of that data to NMED to make the determination that it would be scientifically defensible and therefore mature enough to bring before the commission. So I don't have a date or a number because scientifically defensible is dependent on the rigor and what your end goal is.
So a decade, 2 decades?
I would hope not. We've really worked with the consortium to help this process along. Part of the problem is getting that information back out. And what does that information do? What is it telling us? A lot of these demonstration projects only look at a portion of either a treatment process or the impacts to plants, you know. And so this is really to help the department and the state and citizens be able to have some reliability that these research projects are actually producing data. And we believe that all our work over the past 5 years has led us to knowing what those gaps are and why this language is important to fill those gaps while still protecting ground and surface water by preventing discharges. So this is trying to strike that happy balance between what we're going to need to develop standards to be protective, while at the same time protecting the limited water we already have. Didn't give you a direct answer.
All right, thank you. So I'll dive into the whole NOI questions. So clearly we're seeing a lot of strong public reaction. So with that in mind, how stringent is the NMED review of notice of intents, and what amount of follow-up is, I mean, I know it's not gonna be like permits, so you don't probably have a really good schedule, but I'm just, you know, wondering about how the assurance goes that the project's not gonna introduce more problems than it's trying to address.
Thank you for the question. I think it might be helpful for me to walk you through how we've processed NOIs currently. With the submission of a notice of intent for a produced water project, Kathleen will receive it and notify the team, her management chain, Jen, and then me. And if there's a surface water component, we'll include Surface Water Quality Bureau. And we'll meet and review. So we'll all review the notice of intent, and then we'll meet together to discuss any issues that we've identified with it. Oftentimes we will meet with the submitter multiple times to discuss issues that we have determined to be problematic, or essentially issues that would require a discharge permit and therefore would not be allowed. It usually takes a couple of weeks for us to get to that first contact point with the regulated community or with the entity. And then if need be, we will respond to them formally with a letter stating that we cannot go forward until they provide us with this updated information. A lot of times in these processes, we have discussed secondary containment. We've discussed their process definitions, the missing information, the lack of information, the lack of clarity or lack of specificity in their plans or in their actual submission. And then we'll await a subsequent submission from them, a revised notice of intent. One of the things that we have been stringent on is that the notice of intent must be notarized to ensure that they're not just submitting us a whole bunch of mumbo jumbo or, you know, empty promises. At that point, when we respond to them with a notice of, with a discharge permit not required letter, that is our hands-off point. We still retain under the Water Quality Act the authority to inspect any facility that we choose to, and we can follow up if we are provided any information or if we suspect any deviation. And our no discharge permit required letter specifically states that if they are not doing the project in the manner in which they submitted the notice of intent in, that they are subject to enforcement under the Water Quality Act. And that we will absolutely enforce upon them for that.
That's perfect. Thank you. How much back and forth would be common on one of these?
There is a fair amount of back and forth, and we've requested additional information, and sometimes it takes a couple weeks to respond, and sometimes they request another meeting and we explain. So we have actually had meetings, it seems like, with most of the people. So there is a fair amount of interaction.
Okay. So a couple of the community commenters mentioned how their communities were affected by testing in the past. How much consideration is given to reviewing these?
Thanks for the question. I'm not aware of any projects that we have processed a notice of intent for that has resulted in any negative effects on communities, mostly because none of those projects have actually gone forward. Prior to the notice of intent process, there was some confusion, some misinformation in northwestern New Mexico at a site that we did investigate with OCD, with the Energy, Minerals, Natural Resources Department. There was a report that treated produced water had been discharged to the ground surface for growing plants. We accompanied on the, I think it was me and Kathleen went up to the site with OCD staff. They pulled samples of the soil, tested the samples, and it was determined that no discharge of treated produced water had occurred. And that is my understanding that that is the only instance where a potentially questionable action had occurred outside of OCD's jurisdiction.
Yeah, and I'll just clarify, I think one of the commenters was not commenting on produced water, but maybe some other testing. So, okay, thank you. That's helpful. Okay, let's see here. So within requirements for NOIs, let me see here. There was reference to health. I think it was regarding health and safety, and I'm sorry I don't have it right in front of me. Oh yeah. It's number 10 under C1A. The health and safety considerations that minimize the risk of human exposure to produced water via any exposure pathway, which I'm assuming refers to a lab bench or, well, to any of the demonstrations to the workers on that project. And I'm just wondering if it would be useful to be more specific, to include SOPs and specifically state the kind of documentation they might want to have on those.
Commissioner Fry, I think I can help answer that. In the requirements in the notices of intent, there are a couple of areas in which we refer or punt to other entities that would have the regulatory authority. And so it wasn't for trying to be ambiguous, but it may be above and beyond the Water Quality Act specifically to cite out. And I am not an expert in DOT. I'm not an expert in OSHA. So in essence, we want the entities conducting these demonstration projects to be transparent about their plans. We can respond as far as whether or not there is no discharge and therefore not subject to permitting. But we could not provide, we went back and forth when we were drafting this rule numerous times, and adding more specificity could imply that the other applicable rules that we aren't aware of wouldn't apply. And so we purposefully left the language regarding other state and federal regulations and the health and safety general, because under the act, we didn't have the authority, and I didn't want to overspeak or underspeak as to who might.
Yeah, and that makes sense. I knew my question was a little off.
It's a good question though, because it dabbles on the outskirts of things.
Right, right. So, let me see here. Oh yeah, how much follow-up then could there potentially be on the project? So you mentioned if there's concerns that, there would be a release or anything like that, how much follow-up actually happens besides the requirement for what they give you at the end of the project?
We thank you for the question. The department, I don't want to say the department, the Groundwater Quality Bureau's implementation of regulations is heavily reliant upon self-reporting as well as citizen reporting. And we do often, that is our only sources of information beyond monitoring reports for permits. So I would anticipate that we would generally not follow up unless we had a reason to. Just the honest answer.
Yeah. Okay. All right, that's helpful. All right, so let's I think I'm almost done here, and I want to move past the NOI questions. So in let's see, so 20.6.8.400 A 1 through 4. Each one of those 1 through 4 gives 2 sentences that seem to be repeated in each one. And then in 4, when you're talking about treated produced water discharged to groundwater, you have additional language about where you're adding a clause without development and adoption of standards, and then there's a few more sentences. Why specifically that one, and why not the other 3?
Thanks for thank you for the question, Mr. Fry. The dance that's occurring in those 4 sections is the federal state regulatory world that we're living within currently. We have a state discharge permitting program, and we have confidence in saying that we can that in the future we will have a state permitting program for groundwater discharge permits. And so this is keeping our statements and our regulations within the known realm of regulatory authorities. Did that answer your question?
Let me see if I get what you're saying. So, number 4 relates to groundwater. Number 3 relates to groundwater. And 1 and 2 to surface water. So you're saying there's already regulations in place, whereas for groundwater, there's not?
Actually,
Sorry.
the opposite of that.
Yeah, okay.
So the currently the state does not have primacy over surface water discharges, and therefore we left those caveats out of the surface water delineations. I'm trying to not step on your toes here. Sorry.
Let me switch off and just address, so Madam Hearing Officer, Mr. Chair, Commissioner Fry, for the surface water, the reason we have the prohibition is, as Mr. Herman stated, we do not have primacy under the Clean Water Act. And so we have to do 401 certifications of MPDS permits, which are issued by EPA. And so the prohibition there is to allow a denial and to provide the Surface Water Quality Bureau, when we write our 401 certifications, to have something in statute that supports that denial. Because in a 401 certification, I have to have a regulatory, the department has to have a regulatory basis for any condition or any denial. And so that's why there's a difference between surface water and groundwater, because surface water, it's all federal Clean Water Act.
And so right now for groundwater, everything's in-house and we have control and we have the powers associated with it. For surface waters, a portion of it is definitely still in-house. A portion of it's not in-house, and that may change in the near to long-term future. And therefore, it was necessary for us to treat them differently, essentially.
And can I, of course, add to that too? The structure of the rule. This has been something that was discussed in the advisory committee. It's been discussed internally among us. There are 4 subsections, and 2 are for untreated produced water, 1 for surface, 1 for ground. The other are for treated produced water, 1 for surface water, 1 for ground. In addition to the 2 regulatory federal and state delineations, that was important to keep separate. We also kept it separate, so we could have just put, we were asked to consider untreated produced water as a whole for ground and surface water. That poses problems with the 2 federal and state regulatory authorities. And as somebody who implements and points to regulations on a daily basis and has to write notices of violation, having a citation to the very specific part that needs to be complied with or is in violation of is a lot more helpful to have it split out. Otherwise we get interpretation, or does it include, was there a comma before this? This makes that absolutely clear. So even if we don't have future regulations, we have a place to cite very specifically for treated or untreated, for ground and for surface.
Yeah, and I was thinking that it seemed kind of obvious, the difference between the untreated and treated, but yeah, thanks for that clarification, because I don't read regulations every day. Thank you. That's all of my questions.
All right, thank you. Commissioner Zemlich.
Thank you. And I would just like to echo Commissioner Fry's comments about how much appreciate the work that you clearly put into this. And surprisingly, I still have questions even after all of the excellent questions of the other commissioners. So it sounds like currently, if I'm understanding the NOI process, there's this back and forth, there's requirements, there is the discretion of the agency to deny the NOI. Is that correct? Project?
So thank you for the question, Commissioner Zemlich. At this time, we have not come to that point. Every single entity that has submitted an NOI has worked with us and has acquiesced to our requests and said and submitted revised notices of intent that would allow us to, that have met the threshold for us to say no discharge permit required. But in the event that someone were to not take that path, then that's a very good question. What would happen at that point would most likely be that we would deny that notice of intent. I think that's the best way to say it. Yeah, that's a very good question that I'm not sure the department has really explored that dead end. I mean, in the 1201 notice of intent process, we would send them a discharge permit required letter. Okay, so let's take that path. Discharge permit required letter goes out. our regulations then say that they cannot receive a discharge permit for this activity until standards are promulgated. And therefore they would be in a holding pattern until those standards are promulgated.
So to follow up, for example, if the site that you mentioned earlier, this Canales site, if you had gone out and determined that there had been a discharge, would that be a basis for denying future NOIs from that said applicant?
Commissioner Zemlick, I think I can answer that. Under the Water Quality Act, it does state that we can deny a permit if somebody has violated the regulations. If the regulations were in place and said that they needed a permit or that they weren't permitted to discharge, that would be a violation, and we would consider that and deny a notice of intent in the future.
Okay, thank you.
Well, maybe not deny the notice of intent, but
it's
not permit the demonstration project.
I mean, it's tricky because of the permit NOI issue. So I'm still also trying to wrap my head around that and sort of follow up, because when you have these projects that are essentially relying on agencies, operators that are regulated by different agencies, the question is, for example, if you had an NOI that was submitted with plans to use certain, based on the Produced Water Act, you have this chain of custody that is of the water, depending on the operator, the transporter. Is there a mechanism in place to understand if any of those, let's say, transporters who are kind of more under the radar of the Oil Conservation Division, for you to know if there's any existing violations or compliance issues on which to base your decision on the application?
So thank you for the question. And I want to revise, Jenna, I want to do this. I don't think that we would deny the notice of intent based on that, because the statute in the Water Quality Act specifically says that we would only be able to deny a permit based off of the previous 10 years of actions. And I don't know that we would hold an operator responsible for previous actions if we were then going to follow that up with a response that we do not have regulatory authority over their project by giving them a no discharge permit required letter. And to answer your direct question that you just had, we have this similar problem with septic haulers. Septic haulers are regulated by the liquid waste program in the department through the liquid waste regulations that are promulgated under the Environmental Improvement Board, not the commission. And we work with those groups to stay aware and try to be as proactive as we possibly can. But under the Water Quality Act, we don't generally assert any authority over those types of activities. We do very often refer issues. So if we become aware of something, then, or that someone's participating in a project that we are overseeing, or that we have a plan for transportation that's been submitted with an NOI that identifies a hauler that's a known issue, then we would refer over to OCD or to someone at a different in a different bureau to ensure that they are aware that this person is active and is participating. But we would not take any direct action against that person or that entity.
Okay, and sort of to follow that up, along with the public perception issue, and also a question in my mind is this ability to have these demonstration projects and it's not well constrained. And so looking at the existing applications for pilot bench scale projects, it looks like the majority of them were at facilities like Bergendorf or University Lab. And I think the problem arises when you are going to, bench scale testing at a well pad or potentially in some other location. Has there been any consideration by the agency to kind of constrain the facility type that's approvable?
Commissioners, I'm like, oh, thank you for the question. As far as the demonstration projects that we've seen to date, there's been a mix of bench scale, which is the ones that are conducted in a closed facility laboratory type of venue, and the pilot projects. So we used to call everything pilot projects. And this rule helps us define and delineate between those that are occurring in a closed facility and those that are occurring at a larger kind of field kind of project. We have both. We have both pilot projects and bench scale projects. We are probably more aware of all of the pilot projects, which are those that occur in the field, than those that are occurring currently in as bench scale projects. This would iron out that little nuance of everybody at least letting us know that these are occurring and where they're occurring and what kind of information they're looking for. So it is mixed and we get both.
Yeah, and I left out the Bergendorf and recycling facilities. It seems like those are the predominant ones, and it just seems like the requirements in place at both of those types of facilities is very different than, say, a well pad, or I guess you could probably see where I'm going with this, is that those are fairly well regulated, well constrained, known places, whereas the ability to do it at a remote location nearby a well pad is problematic. If you are, to follow up on what you said, your reliance on, sort of citizen science and catching problems after they occur, rather than sort of trying to constrain these activities in places that are more protective of, should that occur, there are things in place to mitigate it.
I will. Yeah. So we do have we have a matrix in our existing guidance document for what was previously pilot projects, where we determine whether it's going to be OCD's regulatory authority, NMED's regulatory authority, or a combination of both. And that guides us on how we proceed forward. If it's OCD's jurisdiction, we have an easy answer to that. If it's combined, more complicated. I will say also that our 1201 or 20.6.2 1201 spill regulations still cover all of these projects, and so not reporting to us a failure of the system is a violation. But again, we still consider that to be self-reporting, and your concern is very valid that if it's a NMED jurisdiction project that occurs in the middle of nowhere, 3 hours from civilization on an oil pad, how will we ever hear about it? And I think that's a common risk with most of the activities. It's just exasperated in this situation. Did I answer your question?
Yes, I think so.
I do have something to add. For example, if it's on a well pad, they have to file sundry with the OCD, and in that case also, for example, if it's on a well pad, I believe they had to file a sundry with the OCD, and then that was also on BLM land, and so that had to be reviewed by BLM too. So there seemed to be a couple layers of review.
Okay, thank you. So a lot of mention of standards and data, and I took a look at WaterStar, and I've seen this data evolve over the last decade and a half, maybe. And I was a little underwhelmed by what's there. I understand the businesses wanting to protect proprietary information, but it seems like at a township range level, you should be able to report more than what currently exists in the USGS database. And this is kind of speaks to a couple of things, like the timelines that Commissioner McWilliams mentioned, and the need for this information. Will this rule and will the reporting requirements be enforceable for quality, and how do you envision that being disseminated?
Commissioner Zemlik, I'll start and then I will probably hand it over to Ms. Murphy. This rule requires the demonstration projects, whether they be bench scale or they be pilot projects, to submit their data at the conclusion of their demonstration project as they outlined in their NOI. That data, if it were to be codified, or that requirement, if it were to be codified, would be enforceable. And that will help us get past this bump, if you would say. We have, and I'll have Ms. Murphy talk about the demonstration projects that have been submitted to date and the lack of follow through on those end reports, and using the guidance that the New Mexico Produced Water Research Consortium worked very hard to put in place. And so it is the hope that codification of this rule would allow us to have that data so that we can start developing those regulations as the Water Quality Act requires. I would like Ms. Murphy to talk about the substance of the 7 demonstration projects that have been provided to NMED to date and where they are, just real briefly, of where they are in the process.
So there are 7 demonstration projects, and we're not necessarily clear how active they are, or if they're active. And so the bigger issue here is we're not in charge of WaterStar. That's the consortium. And there is some data that could be put into WaterStar, and that would be useful. And the data that's in there right now is mostly the USGS produced waters and the GOTEC, and that's field data. And so we want it to begin. We have, I think, 3 to 4 data sets, and they're not exhaustive. And we would like to see them put in WaterStar, but we're not in charge of WaterStar.
Can I ask a clarifying question? Are you asking about historically or implementation? The data, about the data.
Implementation, really, because it looked to me like it was repackaged existing legacy data rather than new information. And as far as implementation, is it necessary? If it's enforceable through this rule that this data is reported, that does answer that question. And follow-up question would be, what are additional incentives to populating that database so that it's a little bit more robust, because that seems to be the hurdle for many of us in understanding how you could even project rulemaking in the future without that information.
thank you for the question. And the department has grappled with um, databases over the last 20 years and water data as we currently are participating in any aspect that we can with the Water Data Act and making sure that we're compliant and sharing everything. And I will say that it was, as far as I've been involved with discussions, the intention was to make that data absolutely public in any way that we can. And that would most likely include GIS layers on our NMED mapper, as well as making sure that it gets shared into the WaterStar database. I think the department's intention is to be as transparent and as open and as public about this process as we possibly can be. But we don't have anything cemented in place as the method for that.
Okay, thank you. And another question about the data. So reading through all of the exhibits, and I don't know if it was Ms. Murphy's written testimony or if it was just reading about WaterStar, and then some testimony earlier that so for any potential reuse, this data would have to all be public. That's correct?
That is correct.
Okay, but currently WaterStar is set up like in a tiered system where really all of the data is really would be only available to regulators and maybe academia under some circumstances.
There's 4 tiers of data, and the first 2 are public, and I listed in there, and it's some of the more basic data. And so tier 1 and 2 will be available to the public, and tier 3 and 4 are available to research and academia. And that is, and that's listed in my testimony. And if you'd like me to find it and read it, that's fine too. But that's tiers 3 and 4 are like radium, proprietary chemicals, a lot of other compounds. And that tier system is set up by the consortium. It's not set up by us.
And the department would not utilize WaterStar as our only methodology. We would share it with that. I just don't anticipate that being even our primary place to store the data. That hopefully our new permitting database would allow us to move through the NOI process and have these somehow entered into there. And so it'd be in a format that could be utilized by anyone who is wanting to utilize it or to view it.
And Ms. Murphy, this question is directed to you. Do you know how well that tier 4 data is, how well populated that is currently?
It's not.
It's not.
Not even from the horizontal wells, there's been no data submitted. And so the data that's in there is legacy data. You're right. It's from the USGS Produced Waters database or the New Mexico Tech Octane. So there is no data in there that's in the 4-tiered system.
Okay, thank you. And I think this is my last question. I reviewed the guidelines from the Produced Water Research Consortium and the existing demonstration projects, and it looks like many of them have accompanying documentation from the consortium. But the review process, as it happens with the consortium, there's not a robust sort of review, and I don't by panelists or information on who was part of the process, how long it took, if there were comments, and I wonder if if the agency has considered, and maybe this is a question for Mr. Hightower, having that information available so that the public can review if there were any concerns by the consortium. I know the comments from the agency are generally in there, written ones.
We had the same concerns. What process do proponents that want to create a demonstration project, what do they go through with a consortium? And is it geared towards research? Does it have a good end product? Are they going to be taking samples appropriately? Are they processing those samples appropriately? So we have those same concerns, but as the department, we would accept a demonstration project regardless of affiliation with the consortium. And so we have somewhat let go of that. Our process would be the NOI process for anyone that is in or is not in a consortium. And so I do think that your question is most likely better answered by Mr. Hightower.
So to follow up on that, and maybe this is a question for Dr. Hu, is in those demonstration projects, do you find that you have the sufficient information on the treatment processes proposed in all cases, or have there been back and forth with applicants? I'm sort of getting at the proprietary nature of some of these projects. In your experience reviewing these, has that information been sufficient for any determinations that you would make?
Thanks, Commissioner. Yeah, I didn't participate in any demonstration project in the consortium, but I did some research. Yes. Yes, thanks, Commissioner. I did not participate in any producer water demonstration project in the consortium, but I did some producer water research during my PhD. So I cannot make a conclusion to say which treatment technologies is effective for producer water from unconventional well. There are a lot of challenges associated with current treatment technologies for the producer water from unconventional wells. That's my answer.
Thank you.
And I would add, the company makes the determination. They propose. We're not there to give input on what treatments they use. We're just there to say, we would like you to thoroughly characterize the raw produced water, run it through your treatment, and then test the efficacy of the treatment by thoroughly characterizing the treated produced water.
And of the 7 kind of active, to some extent, projects that are currently happening, are those 2 things, those 2 characterizations? I know they have to submit it at the end, but are you familiar with what the status is on any of them?
So they say in their application that they will test according to the consortium guidelines, and the consortium is mostly in charge of bringing those projects and setting them up and talking to people and telling them what's required. I mean, we have to keep a little bit of a wall between, we're the regulators. We don't tell people what to do.
Right. I just mean if any of the projects, if they have concluded, if that pre and post quality data has been consistently reported to you.
So the only project that we have that has been completed is the Canales project that was not completed under a notice of intent process. That was previous to the current way we're doing things. They did do pre and post. we have not received the official final report with that data in our hot little hands as of yet. And we do have concerns about chain of custody on the samples, as well as some other aspects of it. So I think the direct answer to your question is no.
Okay, thank you.
Hello. Thank you. So let me ask if the commissioners in the room, some of whom asked questions yesterday and some today, that includes Commissioner Vigil, Commissioner Brankard, Commissioner Patton, Chair Thompson, Vice Chair Armstrong, Commissioners McWilliams, Dominguez, Fry, and Zemlich, whether those of you present have other questions. Chair Thompson.
Yeah. Thank you, Madam Hearing Officer, and the panel as well. We've sort of forgotten that this is a water reuse reg, and I'd like to focus on municipal. I prefer the term municipal water as opposed to domestic. I think of domestic as what's coming from a household, whereas a domestic is municipal is coming from the entire sewer shed, which may include, well, will include lots of non-household waste. But it seems to me that there is a very strong need for municipal wastewater reuse regs, and there have been at least one DPR project that has been constructed at Cloudcroft. There are a number of others that have been proposed and seem to me have a likely chance of going through. We've talked about 95 reuse projects. These are all, I think, for irrigation and non-potable use. The department has done at least 2 studies. They funded one for an external organization, the National Water Research Institute out of California. And then there was an internal review panel that worked on this 12, 15 years ago. Domestic or municipal wastewater reuse is an important part of the 50-year water plan. Other states, notably California, have very well-developed DPR regulations. I want to know, why isn't that included in this proposed rule? First of all, let me ask a simple question. Do you all agree with my assertion that it is a very important aspect of our water cycle and that we do need wastewater reuse regs?
I agree.
And so now let me ask the response. Why isn't that part of this rule?
Chair Thompson, I believe I address at least some of this in both my direct and then my rebuttal testimony. There were some questions from other parties to this matter regarding having an all-comprehensive reuse rule, and why did we do this in a broken up method? And recalling from the top of my head how my testimony responded, there's several reasons. And the first is the fact that our domestic, and I'm going to continue to use domestic simply because
That's
for prominent, and we don't just have municipalities, we also have smaller facilities that are strictly domestic. So I kind of lean towards that. There is a recognition that there are other sources in a larger municipality, though. As far as domestic wastewater reuse goes, we have the ability and we have been permitting it under 20.6.2 NMAC. And so each individual applicant who wants to treat domestic wastewater has been characterized to be domestic wastewater or predominantly domestic with pretreatment stuff. They can come in for an application and we can issue a discharge permit. And we have been doing that for well over 20 years now. The fact of the matter is this will not directly impact doing the rule now versus doing the rule in a couple of years for the domestic wastewater portion of this will not directly impact the permittees the same way that the produced water portion of this does. And so we can keep our domestic wastewater, and to some extent, we have a few industrial wastewater sources that treat and reuse. We can keep those under the current guidelines, which are for domestic wastewater reuse. That's all they cover is domestic wastewater reuse under our 2007 guidelines. However, for produced water, as everybody has testified here today, the notice of intent process, as it's written in 20.6.2, says that an entity, if they want to discharge, needs to submit a notice of intent. We are asking that the commission consider this rule, that all demonstration projects with produced water do submit a notice of intent so that we can start gathering the information needed to determine whether this wastewater can be characterized, if it can be treated, and if there are any applicable reuses for it. So there's that nuance with it. That is time sensitive. There are demonstration projects going on, and I have staff that review these demonstration project NOIs and spend a good amount of their time with the back and forth trying to get the information we need to make these determinations based on a rule that doesn't necessarily require it to be submitted. So if somebody were doing a non-discharge of produced water and they read the current rule, it doesn't require them to submit to us. We work with the consortium and we encourage them to give us the notice of intent. But that's where the time sensitivity is and the information that's needed. The NOI process that we've outlined here for produced water are the elements that we run into most, and the amount that we spend time with these demonstration project entities. And really, it's not fair to the entity to keep going back and forth and asking for this piece of information to confirm this and to redesign that. We're hoping that this makes that process smooth, streamlined, consistent, and encourages the research to occur. Whereas right now, we're really just trying to fit it into existing regulations that weren't never intended to manage a waste stream of this type.
Thank you. And I appreciate the timeliness or the time sensitivity of a reg for produce water, but department's been working on, first of all, let me ask, are the 2007 guidelines, it's been a long time since I looked at them. They were only for non-potable reuse.
Correct.
So when communities like Albuquerque, the Albuquerque-Bernalillo County Water Utility Authority is envisioning a DPR project, but without regulations,
we're at a loss.
Have no guidance on what needs to be designed, and it. So I think there's timeliness for this. Let me ask another question, and this panel may not know, but has the Cloudcroft DPR program been permitted to go into operation?
Okay, Commissioner, thank you, Chair Thompson. So I want to add some elucidation to the previous question as well as answer your question directly, if that's okay.
Sure.
Currently, we're on the fast track for DPR regulations. We have previously lacked the resources to undertake it as a regulatory development project. We received special funding from the legislature to advance reuse in New Mexico, and we have put a portion of that money towards a contract with ERG to develop those regulations. And we've been meeting with them weekly, and we're somewhat part of the way through the process. We've scoped out the Arizona regulations on DPR, the Colorado regulations on DPR, and the California regulations, and we've started picking and choosing on where we want to land on those, on our regulations. I have been given a mandate by my management to have that done by the end of the year, which is fairly quick. So I wanted to set your mind at ease. That's in the process. And we are currently working on it, and we're going to include in that above ground non-potable reuse regulations that will also codify the guidance document from 2007 into regulation. I think I've forgotten your second question.
So that is only for non-potable though.
So no, that is going to be direct, indirect potable reuse as well as non-potable reuse. It'll be shoved into this supplemental rule, and it will accompany the produced water section of this rule in perpetuity, hopefully. And so Cloudcroft specifically recently, from my understanding, has wavered on their intentions. There's a cross connection in the department between the Drinking Water Bureau and Groundwater Quality Bureau and Surface Water Quality Bureau, between who has authority, what it transfers authority. And then a recent federal decision essentially made Cloudcroft's NPDES permit go away because they're in a closed basin. And therefore, the Groundwater Quality Bureau has picked up the permitting process. And so we are in the process of permitting them for a groundwater discharge permit. And I believe that they are not intending to do DPR at this time due to size and constraints on the site, as well as some of the requirements that were placed upon them by the Drinking Water Bureau. Right now, I will say that our motivating factor for DPR is the city of Las Vegas, who, after the recent fires, realized that their water supply was very limited in those instances and therefore are working to diversify their water portfolio in creative ways. And the feasibility study portion of this regulation is really intended to give them the comfort that they need in order to accomplish the studies that they need to do to figure out whether they want to do ozone, biologically activated carbon, or IPR versus DPR, or if they will have to go to reverse osmosis.
Thank you. That's encouraging. Yeah, I'll just repeat myself by saying I think these regulations are as timely as the produce water regulations, and I think they probably affect a lot more people. So I'm going to hold your feet to the fire. We'll expect to see something by the end of the year. Thank you.
Okay. Other commissioners in the room? Any additional questions? Commissioner Sky?
Thank you. I think coming from a university background, having been on safety committees, having a lab where safety is a constant concern, I think you can understand where I'm coming from with these questions about the handling of the materials, in particular in university laboratories, especially knowing that, you know, we need more data, and encouraging all universities in the state and colleges to participate in this kind of research is important, not just for adding to the data, but creating a workforce that's going to continue to address this. So if you receive a DOI from a university that doesn't have the benefit of, you know, the larger research universities of having good support staff that help them know, okay, these are the regulations you have to think about. Is there a way that, this is gray area again, I'm a little at a loss to how to ask this question, but like say there's a university, say Eastern New Mexico University or CNM or Santa Fe Community College, they want to do this kind of research. Is there a way for you guys to, with the DOIs, to really empower them to do this work?
Thank you, Commissioner Fry. I wanted to ask a clarifying question. Do you mean NOI instead of DOI?
Oh, I'm sorry, NOI.
Okay.
Yes.
Madam Hearing Officer, Mr. Chair, and Commissioner Fry, in regards to helping with, can you state the question? Because now that I got clarification, I forgot what the question is.
Yeah, and I'll add a little bit to it too. So I've seen enough in my career that I know that how we receive the materials, how they're transported to get to us, how we dispose of them, it's very important questions for these researchers to ask. In the NOI process, how can you best help these universities that don't have the benefit of the larger universities?
So I think one of the benefits in NMED is that there are different agencies that have different regulations. And so while sometimes that means we're siloed, it also means we talk to each other a lot. And so in regards to, transportation, we ask them that they need to have some type of, plan for the handling. And so, like for worker safety, the Occupational Health and Safety Bureau has an entire voluntary compliance program that we can refer someone to. And that's what they do all day. They go around the state to different industries, agencies, and walk them through how they stand up an appropriate health and safety program to protect the workers. In regards to some of the transportation, like we have the Radiation Control Bureau that can walk them through things. Um, we have people across the agency that we can put them in contact to walk them through, like, do you need a permit? Do you need this? Here we have guidance documents. So that's one of the things we can offer.
And I'll just use an example from our current permitting process. We often go to communities to the wastewater treatment plant, and they express to us a lack of funding. There's no mandate in our regulations that we have to refer them to the Construction Programs Bureau and the Clean Water Revolving Act, but we want them to succeed. And so we take the time to either set up a conference call or provide them with information necessary so that they can go and either get a grant or get a loan from the Construction Programs Bureau. So I think the official answer to your question is we don't have the authority to require them to do that, but we have the intention and the forethought. If we go out to a site for remediation of soil and we see that they've excavated well below 6 feet and there's people just working in there willy-nilly, we will either refer them directly to OSHA or we will do the referral ourselves and make sure that OSHA is aware of the issue. So I think we automatically already do what your question is asking. It's just not an official capacity. We just see it as our jobs anyway.
That's kind of what I assumed, but it's nice to hear you guys talk about that. Thank you.
Right. It's noon, and if we're going to take an hour for lunch, we need to do that now because we have public comment notice stop at 1. Let me talk about that for a moment. We do have at least 7 or 8 commenters already signed up for the 1 o'clock public comment session. And then I would like council and parties to know that there are a couple of motions that just need to be ruled on before the parties cross-examine the department panel. So we will take that up and I will ask you for your positions. Again, that comes after public comment. And then we'll begin the party cross-examination of the department panel. And although there was a request to maybe move that table, I have a better idea. I'm going to go sit up by the chair and ask cross-examiners to sit at this end of the dais. Otherwise, the panel is facing directly away from me and the court reporter, and that doesn't work. So let's come back at 1 and we'll take things in that order. It is 1 o'clock. My name is Felicia Orth, a hearing officer appointed to conduct the hearing in WQCC 2384. This is the 4th opportunity to offer public comment. There are 10 such opportunities this week. Just a few rules. Please collect your thoughts because I'm only going to invite you to offer verbal comment once. I will be using a stopwatch to time your comment and will ask you to keep that under 3 minutes. If you have more to say, and a lot of people do, then can be said in 3 minutes. You may submit written public comment through the end of the week to Pam Jones. All of her information is on the WQCC webpage. I do have to swear everyone in briefly before they comment, and I will ask everyone to spell their name for the transcripts. And by the way, if you're in the room, would you please reach for your devices and turn them off? So we have folks both in the room and online. I will call you in the order in which I became aware that you wanted to offer comment. So let's see, in the room we have John McPhee. Ms. McPhee, if you would take that table. You do need to pull the microphone close to you in order for everyone to hear you. Do you swear or affirm that you will tell the truth? Thank you. And if you would spell your name for the transcript. Terrific. I will start your 3 minutes now.
Oh, thank you. Oh, okay. I'm loud. That's loud. I started in the environment department 25 years ago. I was a recycling coordinator, not of water, and loved it. Went over to the health department, where I was the consumer product safety commissioner for 23 years. I was also the environmental health specialist for the health department, specific to harm to preventing harm to children. And and then my family are the Eddies of Eddy County, and founded Carlsbad. So every aspect of this issue affects me or affect what I did and is important to me. Basically, to be succinct, given the amount of testimony where you're going to hear, I just support the views of everyone that was in the front page article this morning in the New Mexican. How do we regulate something that we don't know? We don't know what the composition of those chemicals are. They estimated, again, that there's in different sites they're finding is some variety of 1,200 chemicals. I'm sure we do not have the filtration technology to deal with that level of chemical contamination. I think we need to go back to the drawing board. I think we put the burden on you guys, the Water Quality Commission, and on the Environment Department. I think this now maybe a step to go to a much larger evaluation because of all the issues we've had with methane, water quality in general, water volume, a lack thereof. And I'll pass around the book. There's a book written about my great-grandfather and his brother went down there to create irrigated land, and then as a byproduct built Carlsbad. It was originally Eddyville. The book illustrates what a nightmare it was, primarily because there's such a labyrinth of caves underneath the surface, which really complicates the matter of surface versus groundwater. That's the main thing. My great-grandfather and his brother actually failed miserably. It was J.J. Hagerman came afterwards because of specifically the complexity of the water situation in Eddy County and Chaves County. It really, I think we need to back up and do a much larger evaluation of the whole kind of biosphere of it. Hopefully now we will make more progress with methane, which of course it makes the problem much more acute, specifically because water volume has disappeared. My other family are the McPhees of McPhee Dam and Lake up in San Juan County. And it was very nice that they named the lake after us, but the lake is gone. There's no water. Again, because of methane, we've seen, lack of moisture. Thanks so much and appreciate all your work. This is a very difficult problem.
Thank you, Mr. McPhee. Stephen Aldridge. he perhaps on the platform? Mr. Aldridge?
Yes, ma'am.
Ah, I can hear you nice and loud. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. And if you would spell your name for the transcript.
STEPHENALDRIDGE.
Thank you. I'll start your 3 minutes now.
Thank you. Good afternoon, Madam Examiner, Mr. Chairman, members of the Commission. I'm Stephen Aldridge. I'm the mayor of the city of Jow. Currently in year 2 of my second term as mayor. I'm a retired educator with 20 years in the classroom. Thank you for the opportunity to address you today. To be clear, I address you today representing my friends, neighbors, and family who call this small rural community home. For those of you that don't know, the city of Jow is located in the epicenter of the oil and gas fracking play in the very southeastern corner of our beautiful state. During the course of the past 6 years, this community has taken every step possible to protect our sole source of fresh sweet water in the Jow Underground Basin. While the city of Jow, by ordinance, does not sell fresh water to the oil and gas industry, we have found ways to collaborate with the oil and gas industry, and to also engage in litigation when necessary to protect the interests of this community. This includes 4 litigations with water entities serving the oil and gas industry. It's been a journey of education into water law in the state of New Mexico and the issues involving produced water. Admittingly, the learning curve was steep early on. It became evident that we needed to know more about the produced water side of the equation, and in 2019, I attended my first of a number of produced water conferences held in the area. I made contact with the New Mexico Produced Water Research Consortium. I engaged members of the oil and gas industry and water industry in both New Mexico and Texas. I let it be known if there was a discussion about water, fresh or produced, the city of Jow wanted a seat at the table. The city of Jow let it be known during face-to-face meeting with Secretary Kinney that the city of Jow had and will continue to engage members of the water recycle, water reuse, and water purification industry from this country and abroad. We have had face-to-face and virtual meetings with groups from the Scandinavian region, Germany, South America, Latin America, the United States, and both New Mexico and Texas. We've received and reviewed the results of what is currently being done and available in those different areas, and what we've learned is contrary to what we have heard in this hearing. The science and technology is there. Through any number of the myriad system and membranes, whether pressured, heated, unheated, or cavitated, the science and technology to take produced water and systematically turn it into water for safe use outside of the industry is here and available. What we ask is that you help us to continue and conserve our fresh water and allow us to plan for future economic diversification beyond the oil and gas industry. With ever evolving technologies, this will create new business opportunities and business development that will further benefit all of New Mexico. To accomplish this, we ask that you take the time to produce rules of high standards for reuse with closely monitored regulations that allow us to utilize all the resources we have, including produced water. Again, thank you for your time this afternoon.
Thank you, Mayor Aldridge. Mandy Sackett? Mandy Sackett on the platform.
Hello, I'm online, yeah.
Oh, hello.
Hi.
Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell your name for the transcript.
Mandy Sackett.
Thank you. I'll start your 3 minutes now.
Okay. Hello, my name is Mandy Sackett. I'm a recent transplant to Taos County from Southern California, and though I'm new, I care very deeply already about protecting New Mexico's sacred places, ecosystems, and people. I moved here to escape the hustle and bustle of SoCal and also to heal a chronic condition, looking for clean air and clean water, and I found it up in Taos County. In a few short months, I've reversed an autoimmune condition and I'm finally thriving again. But it's clear to me that not everyone in New Mexico has my privilege to clean well water and fresh air. My concern with the proposed reuse of produced water is that this experimental water source will impact frontline communities more than anyone else. People living near industry where the water is produced, I think, could potentially be impacted more than anyone else. And I'm also very concerned that there has not been a full life cycle analysis of the benefits. I worked in California analyzing desalination projects, and I can tell you that water filtration and reverse osmosis is extremely energy intensive and costly. I was a part of a small team of advocates that got the proposed Poseidon Huntington Beach desalination plant denied because of its enormous impacts. Since the Carlsbad desalination plant was built in San Diego County, which is the nation's largest plant, the county has entered a major water affordability crisis, which is a violation of the human right to clean, affordable water. The answer to dealing with New Mexico's water supply needs is not to purchase experimental produced water that may or may not harm people with some of the most toxic substances on Earth. The answer is to stop using so much water for fracking and oil drilling, phase it out, prohibit new leases. It's time we move on. This is a handout to oil and gas to use public funds for this purpose. To pass it off as anything other than a handout it feels offensive and it's greenwashing. So please do not move forward with this plan yet. Go back to the drawing board, consider what's truly beneficial for New Mexicans, tribal nations, and the ecosystem. Thank you.
Thank you, Ms. Sackett. Nodaya Brent, I believe on the platform.
Can you hear me?
Yes.
Okay, my name is Nadia, and the first name is Nodiah, and the last name Brent.
Thank you for the correct pronunciation. Do you swear or affirm to tell the truth?
Yes.
All right, I'll start your 3 minutes now.
Okay. I want to say how thrilled I am to be here, and everybody has so much value to offer. I'm glad to live in a country that still has opportunities like this. We all know that New Mexico is in a severe state of drought. We know that water is the most important resource we have, and fossil fuels are one of the most deadly. We know that once an aquifer is gone, it's gone. We know that the Permian Basin is the #1 driver for worldwide climate change at this time. And this means that our extractive activities are harming other people and their children all over the world through climate-related emergencies, droughts, floods, severe weather events, etc. How can we possibly justify that? The technology is available for a just transition. Regressive lawmakers are unmoved. The original inhabitants of these lands are disproportionately affected by oil and gas extraction. Their sacred sites are up for desecration. How could we possibly justify that? One speaker said that foregoing fracking water reuse would cripple our economy, that Texas would get the opportunities that we might miss to invest in produced water. But the fact is that Texas is no longer able to contend with its own frack water. Could it be that Texas is grooming us with the governor's complicity to process their frack wastewater? How could we possibly justify that? The same speaker said that we have abundant naturally brackish water that has no discernible use and that we should harness it for oil and gas. Since when do humans understand the complex and intricate relationships between seemingly useless resources and the lands in which they are situated? The last time I checked, we had a whole lot to learn on that subject. This ill-considered proposal is guaranteed to hinder future economic developments that would really make long-term sense for New Mexicans. The natural beauty in our state is a magnet for tourists. Building new visitor infrastructure would be a boon for tourists and locals alike. Poisoning our waters and wildlife and cultivating wildfires will put an end to that. Next time we have a wildfire, visit the downtown area of Santa Fe. You will see what I mean. It quickly turns into a ghost town. Our sunshine and wind can set us up for clean energy exports. Why aren't we putting more intelligence and resources there? Where are the visionary politicians who could support the agriculture sector and ranchers, creating sweeping initiatives to help farmers and ranchers transform the soil into carbon sinks? If oil and gas money is so essential for New Mexico, why are our schools consistently ranked among the lowest in the nation? Do any of you know any school teachers? They have a lot to say on that subject. I am here to let the Water Quality Board know that we are looking to you to be bona fide water protectors, to strictly prohibit reuse into ground and surface water and anywhere else, including off the oil fields. And to
Please
go
wrap
forward-
up.
Sorry?
Please wrap up.
Okay. And to go forward with emergency measures to clean and protect what little water we have left. Do we want to cast our votes for death or for life? Thank you.
Thank you, Ms. Brennan. Miguel Pacheco? Is Miguel Pacheco on the platform? No. Sophia Martinez? Ms. Martinez, are you on the platform?
Yes.
Terrific. I can hear you. Do you swear or affirm to tell the truth?
Yes, I do.
Would you spell your name for the transcript, please?
Sophia, Sofia, Martinez, Martinez.
Thank you. I'll start your 3 minutes.
Commissioners, Chair, and community present there. My name is Sofia Martinez. I'm co-coordinator of Los Jardines Institute in Albuquerque and president of the Concerned Citizens of Wagon Mountain, Moore County. I'm a lifelong resident of New Mexico. I was raised in northern New Mexico to a farming and ranching family. We were taught the value of water and to never waste this valuable resource. I want to ask the commission members to basically vote against this idea of producing water, which in itself is a fiction, and to remind them that their responsibility is to protect the quality of our water here in New Mexico for the people who have for decades worked to keep our water safe and pristine. Yet over and over, our state and federal government has approved dirty and polluting industry without the proper safeguards, nor with a vision towards the future of climate change, a crisis that is primarily caused by the industry that is most responsible for the poisoning of our scarce water resources for corporate profit and individual career and political advancement, and that is the oil and gas industry here in New Mexico. We asked the commission to say no to the idea of produced water. Again, this is fiction. It only protects the bad actors in the fossil fuel industry. We unfortunately do not have trust that our government will protect our water or our health here in New Mexico. We are not opposed to science and the science of thinking about cleaning up wastewater. However, that should not be on our dime. That needs to be on the industry dime, on their site, and we don't need to have it reused. We want our officials to move forward in protecting our clean water as it is right now. It is our most precious resource in New Mexico. We need to stop the use of our water for profit and then allow wastewater for our produce or even for our produce. We do not want to water our produce with reused poisonous water. Already, New Mexico has severe issues with health issues that have to do with the bad decisions that we have made for New Mexico that our government, state and federal officials have basically promoted, all basically using us as people of color in the state, because we are the majority in the state, right? We are the majority, we are minority majority in this state, and we have constantly been used as guinea pigs, whether it be for the nuclear industry, for dumping of nuclear waste, and for the poisoning of our water, our precious resource, for an industry that basically our state can't seem to get away from, right? We do not want our kids and our institutions to be supported by a dirty industry such as oil and gas. We need to really look at other budgetary ideas and theories. That's where our scientific power needs to be placed in terms of how we can basically begin to support ourselves without promoting the oil and gas industry. We
Would
do
you
not
please
want
wrap
the
up?
guinea pigs. Yes, we do not want to be the guinea pigs for hydrogen, which again, our own state government is promoting at the core of the fact that the legislature itself and our population do not want to have anything to do with hydrogen. There is no such thing as clean hydrogen, clean nuclear,
Ms.
or
Martinez?
definitely clean fossil fuels. Thank you very much.
Thank you. Adam Wood.
Hi, folks. My name's Adam Woods.
Hello. Do you swear or affirm to tell the truth? Can you hear me? Mr. Woods? Oh. We'll hope that he gets back on. Mr. Woods, I will take your comment, but for right now, I'm going to move to the other commenter I have indicating an interest, Ann McCarthy. Ms. McCarthy on the platform. Right. Ask her to unmute, please. Oh, there's Adam Woods again. Mr. Woods?
Hi, folks. Sorry about that.
Okay.
Can you hear me?
Yes, and you can leave your camera off if it's interfering with your bandwidth.
It seems to be working now, so I'll give it a try.
All right. Do you swear or affirm to tell the truth?
I do.
And if you would spell your name for the transcript.
Adam, A-D-A-M, Woods, W-O-O-D-S.
All right. I will start your 3 minutes now.
Thank you. My name is Adam Woods. I'm an environmental science educator in Albuquerque, South Valley at Harrison Middle School. I've recently started a program with the students where we go out, we monitor the ecosystem behind the school, we monitor the water, we talk about the ecosystem, the environment, the plants and animals that live there and rely on each other and depend on each other to live. And I've been hearing this idea of using what you guys are calling produced water, but let's be honest. Calling it produced water is misleading at best. I think that it's honestly just a lie to call it that. We know what it is. It's poisoned, contaminated water. We don't need that in our state, primarily because water is such a precious resource in New Mexico. There's so limited amount of water. It's not like once you poison water that you can clean it up. We know that here in Albuquerque because Kirtland Air Force Base spilled 24 million gallons of jet fuel into our drinking water, and that we can't fix that. That's never going to go away. It's almost remarkable that people can even still live in this city with that, and very few people are aware of it. New Mexico has always been an environmental sacrifice zone going back to the 1940s. First, they dropped a nuclear bomb on us, the Church Rock spill on the Navajo Nation. My school that I work at is only a few miles away from what's called the Mixed Waste Landfill, which is the largest nuclear landfill on the continent. My thinking here is just, you guys know better. We all know better. Water is life. It's as simple as that. And once you poison water, there's no getting it back. Once you ruin the environment, there's no getting it back. Once a species goes extinct, it's not coming back. So that's what I teach my students. I teach them to be stewards of their environment. I teach them to take care of the environment for future generations. And I don't know if I see my own government doing that. So I would like to see some decisions that are made that are in the best interest of the people and the environment of the state of New Mexico. And what else I would like to see is our elected officials making common sense decisions about how to protect citizens that live here, who choose to live here. I'm going to go back to work. I'm going to talk to my kids about water. I'm going to let them know what decision you guys make because that affects them. So I'm going to let them know about, what it is that you all decide here today about how to treat our most precious resource, the one thing that enables us all to live here. I'm going to talk to my students about it. I want to see you all make the right decision. That's all I have to say.
Thank you, Mr. Woods. Let's go to Ann McCarthy.
Thank you. My name is Ann McCartney.
Thank you.
ANN, capital MCCARTNEY.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
Thank you. Thank you for this opportunity to make a statement and to weigh in on this very important rule. I'm the co-chair of New Mexico Interfaith Power and Light, which is a faith-based climate protecting group. You've heard from many of the speakers while I've been on to this afternoon at 1 about how precious water is. And I just want to underscore that we're talking about water, and water is water, and the chemicals and sludge and discharge from produced water is only nominally water. And what we need to do here is be very, very clear that there needs to be a prohibition for the release of treated or untreated water, the discharge of it into groundwater or surface water. As you all know, we're already in a climate crisis, and we're already facing extreme depletion of our water resources in the state of New Mexico. So that's why this is so critical. Even though the push may be, hey, we can use this water in some other way, the prohibition is just absolutely needed for the discharge of produced water into our existing water systems. There are many things about the rule that need to be addressed that are not in line with really protecting water. And I will just name a couple of them. The authorization for reuse of produced water in industrial projects should be removed. We really have concerns from New Mexico Interfaith Power and Light that would just allow the reuse of the water in a way that supports the oil and gas industry, which already has had some really detrimental impacts on our climate. And the second thing is that the unnecessary definitions in the rule really create a lot of confusion about what the future use or amendment to this rule might be leading us to. The fact that it's mentioned about agriculture and crops is really, really problematic. So all those unnecessary definitions need to be removed. And there are other pieces of this rule that really bear either removal or your very considered deliberation as a group. And I appreciate the time to talk to you. This is a critical moment when we don't want to let produced water into our water systems, and we don't want to allow the oil and gas industry to somehow manipulate our rulemaking and our use of water. So I appreciate your time. Thank you.
Thank you, Ms. McCartney. Let me ask if there's anyone else in the room who'd like to offer public comment who's not done that yet. And let me ask if there's anyone on the platform who is here to offer public comment and has not yet offered it. There are 7 more opportunities, 9 and 1, or 6 more opportunities, 9 and 1 each of the next 3 days. Okay, terrific. We are going to go back to the technical case then. Again, the next public comment opportunity is 9 a.m. tomorrow morning. Reach out to Pam Jones or Madai Corral to have your name listed. Sorry? No. We're just doing 2 a day, 9 and 1. All right. Let's see, motions. Let's turn our attention to motions. Commissioners, I would not normally be doing this. with all y'all watching during the hearing. Because for non-dispositive motions, I tend to handle those offline, ideally with a written order. But the pace of this proceeding and the number of parties and the number of motions they filed, each of which then called for some responses and replies coming in throughout the weekend and up through tonight. I know there'll be another one. But I was asked, let's see, by Ms. Nanasi to specifically address one of the motions because it affects how she will be conducting or whether she'll be conducting cross of the department panel. And this was a motion filed on May 6th, which is important in my opinion, requesting that the commission issue an order necessary and relevant to fully inform the commission. And essentially it's a request that will issue an order inviting Dr. Pei Xu, and if I'm mispronouncing that, I'm sorry. Dr. Pei Xu, who is a chief scientist at the consortium, to come and present technical testimony. Responses were made by Mr. Maxwell and by Ms. Fox on behalf of Amigos Bravos and the Sierra Club. I don't think, was there a reply? I don't know that there was a reply. Ms. Nanasi, was there? No, there was no reply. Okay. So let me ask if there's any other party who had a particular position on the motion who wanted to offer that at this point. I've identified the motion and responses that I had. You don't have to take a position on every motion, obviously. All right. Oh, Mr. Hightower. You have to come to a microphone.
So I'm Mike Hightower. I've worked with Dr. Xu to be able to be here to give testimony, whether she's here in person or by the video. So I did submit that on May 6th or before May 6th, that she would be here in case people wanted to question issues around constituents in the produced water, sampling of the produced water, non-target analysis, target analysis, many of the things that were talked about in the last 2 days. She would be able to be here and participate in that. So it is fine with us. She expected to be here. And so we have no problem with her being here to answer any questions that anyone may have.
All right, thank you, Mr. Hightower. Let me note that the related motion, and that's exactly where I was going, was a motion filed by Amigos Bravos and Sierra Club to strike Mr. Hightower's rebuttal. The entirety of his rebuttal appears on half a page and essentially does not set out testimony. It essentially asks that Dr. Xu and Dr. Zhang be allowed to appear before the commission to answer questions. So I think, and I went a little ways in our pre-hearing conference last Wednesday when we had almost all the parties on the platform to discuss pre-hearing motions. The commission does not have subpoena power, and that's one matter, one issue. It's not the sort of proceeding in which we subpoena witnesses, regardless of whether they might have helpful information. So then the question becomes, what does it look like to request or demand someone's or solicit someone's testimony before the commission when we don't have subpoena power outside of that. And I thought that the response by Amigos Bravos and Sierra Club really went to the challenges, and I think more than challenges, the barriers really to requesting that testimony. Among other things, the request was made May 6th, which was well into the hearing process. Commission doesn't have authority in the Water Quality Act to request testimony. If a party wants to present testimony, they can actually make contact with those witnesses and follow the regular rules with the notices of intent to present technical testimony. I understand there's a lot of interest in the potential testimony of others related to the consortium, particularly where the department may or may not have aligned itself with or agree with. I don't want to put anyone's words in your mouth. In any event, where there's some daylight between the petitioner and the scientific research group, but I'm not going to ask Dr. Xu to testify or Dr. Zhang, no matter what form that would take. As to the rebuttal NOI, Mr. Hightower, I try my best to facilitate participation in these proceedings, especially rulemaking proceedings, for folks to participate pro se. That is, to not feel as though they have to hire a lawyer to participate effectively in a rulemaking. Having said that, when the failure to follow rules that are set out in the Commission's rulemaking procedures would be prejudicial to the other parties, and in particular the petitioners, who would not have had a chance to prepare cross-examination questions or anything else, rebuttal testimony of their own in response to testimony that is not here. Right? We don't have Dr. Xu's testimony. We don't have Dr. Zhang's testimony. And it's just too late in the process to invite people who have not been noticed up properly in an NOI to offer technical testimony. So thank you for thinking to offer them. Thank you for thinking, Ms. Nanasi, that their testimony might be useful to the commission. But ultimately, I have to stick a little closer to the rules, or the whole thing becomes a free-for-all pretty quickly, actually. So the motion to order Dr. Xu to testify is denied, and Mr. Hightower's rebuttal NOI, which isn't really a rebuttal NOI, is struck. Mr. Wexler.
Yes, may I ask for clarification on that ruling? And my clarification is this. I'm a little bit surprised to hear that. My understanding in these proceedings is to create as complete a record as possible for the benefit of the Water Quality Control Commission, to ensure that that commission can make an informed decision. We've already heard from the chair the importance of Dr. Xu. She's been at the center of developing the understanding in New Mexico having to do with produced water. How about if I turn it on? Again, one of the most knowledgeable in the country, in the world, on that issue. I understand the point about rebuttal, but I would point out that in the original NOI filed by Mr. Hightower, if you turn to the actual notice of intent, that's Exhibit 1. We can see here that it says in support of oral presentation on this rule. It identifies the rule. It then identifies the hearing date, the dates here, and then the docket number. It then indicates who it's representing, the court consortium, and it goes on to identify Mr. Mike Hightower, Dr. Pei Zhu, and Dr. Yanyan Zhang. It then provides the qualifications for each one of them. In other words, it provides all of the information that's required by an NOI. It then goes on to say the supporting technical data and information, and it provides all of the information and data that each of them is testifying to. And so to the extent that you're suggesting it would be prejudice to the other parties, they've certainly had sufficient notice as to her testimony there. And so I would ask that she be allowed to be here. She's obviously interested in being here and to testify to those subjects that are contained in that NOI. Thank
All
you.
right, so Mr. Wexler, I asked before I went into my ruling for the position of anyone who had not filed a
I
written
thought it was on the first
response.
motion.
Now you're just challenging the ruling.
Well, I
Number
understood it to
one.
be only on the first motion.
Okay, number one. Number two, I did not strike Mr. Hightower's original NOI, and I agree with you. I looked at it several times that it sets out most of the elements of a direct NOI. The thing it's missing is Dr. Shu's testimony.
It's part of Exhibit 1. It includes her name. It indicates that all of them are providing that testimony. So the clarification that I'm seeking is, I understand you're going to strike her rebuttal testimony. The clarification that I think is warranted is that she ought to be able to appear and testify to this testimony that's that she's a co-author to.
So do you believe that I read it incorrectly, that the testimony that was part of the direct NOI was Mr. Hightower's direct testimony?
I do. I think that the correct reading is that the notice of intent, Exhibit 1, is from all of the authors there. That's my understanding. Mr. Hightower certainly could clarify.
Okay, and how does that square with the clarification that he offered yesterday on my question, that he does not represent the consortium? That is not the NOI of the consortium. That is an NOI on his personal behalf.
I think that this goes to whether the commission is going to be overly formalistic with non-lawyers. I mean, here's a non-lawyer presenting what he understands, what they understand to be the testimony of all four of them. I mean, because he was the one who actually submitted it, even though all four of the authors were intending to provide that testimony. Are we really going to say that the commission should be denied the ability of Dr. Zhu to testify? And that seems contrary to me to the rules.
All right. For now, that ruling stands because I strongly believe that the testimony offered in that NOI, which is filed on his own behalf, not the consortium's behalf, was his testimony, not Dr. Shu's.
Understood.
Thank you very much. Any other comments before we return to the technical evidence? I can't rule on the NMOGA exhibit exclusion till I have a response from, a reply from Ms. Fox. So we'll take that up on a later date. Thank you, Mr. Wexler, for taking that spot there. Commissioners, if you need to move this way, there's plenty of room. But we do need to have the cross-examiner there. When we broke, the commission was wrapping up its questioning. I did ask Pam to reach out to the commissioners on the platform, Commissioner Polodogu and Commissioner Rosatos, to see if they had any questions of the department panel. I'll pause a moment in the event either of you has changed your mind and has a question of the department panel. Commissioner Rosatos?
Hi, good afternoon, Madam Hearing Officer. I do not have any questions. Thank you.
All right, thank you. All right. So we are going to turn then to the cross-examination by the parties. Again, this is conducted in reverse order of the presentations. So we'll begin with NMOGA and Mr. Wexler.
How does that sound for a sound check? Okay, not too good. Thank you, Madam Hearing Officer, members of the commission. Hello to the panel. Thank you for being here. I'm going to start with the need for water in New Mexico. Can you hear me? So Ms. Fulham, in your testimony, you discuss water consumption, water needs, the impact of climate change. Is that right?
Madam Hearing Officer, keep looking this way. Mr. Chair, Commissioners, yes. Yeah. It's picking up oddly. This will be interesting.
And so I think you agree with me that there's a shortage of freshwater supplies in New Mexico. Is that right?
I would state that there's a limited supply of fresh water in New Mexico.
And also groundwater.
Correct.
In fact, we've seen significant declines in groundwater levels across the state. Is that right?
I don't believe I testified to the levels of groundwater.
Are you aware that there has been a decline in groundwater levels across the state?
Madam Hearing Officer, I would object. That is beyond the scope of her direct testimony.
So she testifies to NMED Exhibit 42. We can take a look at it if we want. Page 1, second paragraphs indicates that there's been, quote, severe declines in groundwater levels have occurred in some parts of the state. She's also talking more generally about the needs of fresh water in New Mexico and the shortage that exists.
So remind me of your question.
My question was, there have been declines in groundwater levels across the state.
To the extent that's consistent with the testimony you've given, go ahead.
I think that all that I could offer to that is that there are some aquifers within the state that have been showing trends. I do not manage or review that data, so I can only speak to the extent that I have in my direct testimony.
The department hasn't considered whether or not there's a groundwater shortage as part of considering reuse rules?
The Groundwater Quality Bureau works with water quality more so than the water quantity. So I would not be able to speak on behalf of what would probably be a question for the Office of the State Engineer.
Understood. My only question was, that's not something you considered. Is that right?
We consider water quality.
And not the decline in groundwater levels.
That's not what we regulate.
There's also been a drought in recent years in New Mexico. Is that right?
To the best of my personal knowledge, yes.
Increasing demands in New Mexico from a growing population?
Likely, yes.
And endangered species?
I can't speak to endangered species.
Increasing demands from industry?
I can't speak to increasing demands or quantity.
Increasing demands from tribal claims to water rights?
Again, I believe these are outside the scope of my direct testimony.
Those increasing demands are not something that the New Mexico Environment Department considered in proposing these rules?
Not to the extent that we considered water quality protection under the Water Quality Act.
I'd like to get you to look at NMED Exhibit 185. This is an exhibit, I believe it was Dr. Hu testified to. You have that before you.
Excuse me, Exhibit 185?
185 should be called the 50-year Water Action Plan.
Correct.
You have that before you?
Yes.
And if you take a look at page 5, it's page 5 of the PDF. It says page 3 in the lower left-hand corner.
Ah, okay.
And it's 4727. And we can see here that at the top, it indicates that New Mexico will have approximately
25% less water available in rivers and aquifers in the future, right?
I believe I might be on the wrong page.
At
Are
the
you
bo-
meaning? Oh, okay. I see. I see.
Yeah, upper left-hand corner.
It's a long page.
It is. You see that?
Yes.
And you have no reason to disagree with that.
I have no reason to disagree with that.
The governor's 50-year action plan then goes on just below there to say, without action, New Mexico will not have enough water to meet our needs. You see that?
I see that.
Do you agree?
I don't disagree.
So Dr. Who testified yesterday that the proposed prohibition on produced water is not inconsistent with this plan, but I want to take a look at a couple of things here. And it's specifically the thing that Dr. Who called out yesterday, and that is action B. And so let's take a look at actions B1 and B2. So on the lower hand left-hand corner, it's page 12. If you're using the PDF, it's page 14.
The one with new water supply.
It indicates action B1, action B2. You see that?
Get in there.
You understand this to be several actions that the governor intends to take to try and address this water shortage that she's identified. Is that right?
Yes.
And here, so let's look first at B1. It indicates that the intent is to convert brackish groundwater and oil and gas sector wastewater to valuable resources. Did I read that right?
That's what I'm reading.
And you understand that to be one of the governor's intended actions?
Yes.
At B2 in the second column here, and here the governor is intending to implement comprehensive water reuse rules for potable and non-potable reuse of treated wastewater. You see that?
I see that.
That's another of the governor's intended action plans.
Correct.
If you look under immediate next steps, you see there it says by 2024, adopt preliminary water reuse rules. And do you understand that to be talking about the rules that we're actually here to be talking about?
I believe so, yes.
And it goes on to create a consistent and science-based regulatory program for treatment and reuse of produced water outside of the oil and gas sector. You see that?
Correct.
But the first amended rules proposed by NMED, they don't allow for reuse of produced water. Is that right?
That is correct.
I get the problem of, and it gets squeaky. So I don't know how y'all are doing it, but I'll do my best. In fact, the rules contemplate a prohibition on all discharge permits for treated produced water, right?
The rule restricts the use of produced water to only demonstration projects.
So as I understand it, the rule would not allow for a discharge permit for treated produced water. Am I misunderstanding?
You're correct.
If I heard correctly earlier today, it could take 4 years, or at one point I heard a decade before the department felt was in a position to bring a new rule. Is that right?
I believe my testimony stated it could take 4 years to go through the rulemaking process. I believe it was a commissioner that provided the 10-year.
4 years, and during that time, there would be no discharge permits for treated produced water. Is that correct?
That is correct.
I'm going to show you a news release from your office. As well as a request for information. And I'll represent that consistent with our pre-hearing order. We put these in the Dropbox. They've been labeled as NMOGA Exhibit 137 and 138. So the first one is 137, and we can see here it's entitled Environment Department Issues Request for Information to Develop Strategic Water Supply. Do you see that?
I see that.
What's the strategic water supply?
I don't believe that it's in my testimony, nor do I have the authority to speak on that strategic water supply.
You're not aware of the strategic water supply?
I did not say that.
If you look down at the 1, 2, 3, 4, 5, 6th paragraph there, here we can see it says, through a 500 million investment stemming from severance taxes collected by the state from extractive industries, New Mexico will make an advanced market commitment to purchase treated brackish and treated produced water through contacts later this year. You see that?
I read that
Were you aware of this news release?
vaguely. I was not directly notified of it.
Were you aware of the intent of the Environment Department to be purchasing treated produced water through contracts later this year?
I believe that's not in my testimony, nor do I have, it's not what I do, so it's not within my job description. I don't
So-
have any involvement in this.
So that position of the Environment Department, and I'll just ask you to assume that's a position of the Environment Department, that wasn't something that you considered as you proposed and then amended the rules?
You asking about me personally?
Any of the panel?
I will speak for myself. The rule was actually developed and it was put out for public notice prior to the strategic water and prior to this news release of January 19th, 2024. We had a draft rule and we had been working with the New Mexico Produced Water Research Consortium and had met with the public, tribes, and oil and gas regarding this restrictive rule as far back as 2019. The strategic water initiative that is being put out by the governor is outside the scope of this rule.
So I'm trying to understand that answer because we'll get a chance to look at what was intended with the rule and whatnot with the original and then the amended in just a moment. But my question to you is just when you, and I understand you were involved in drafting this rule, right?
That's correct.
In the whole process leading up to proposing it.
From April 2023 to now, yes.
And so from what I gathered from your answer, and I'm asking if I'm wrong, you didn't actually consider then the Environment Department's intent with regard to the strategic water supply.
I guess I might ask you to rephrase that.
Happy to. I took you to, we had this discussion about the Environment Department had issued this news release intending to spend $500 million to purchase treated produced water through contracts later this year, meaning 2024. And my question to you is, that intent of the Environment Department is not something that you considered as part of your proposing and then amending the rules?
We have been directed to propose regulations protective of ground and surface water that are external to this initiative. And the $500 million, one, it is well above my pay grade. And I don't know that it's the Environment Department that's buying it versus New Mexico that's buying this water.
It is an Environment Department news release. So in that regard, if you could look at the other document I handed you, which was NMOGA Exhibit 138. And here this is entitled Request for Information for Strategic Water Supply. And again, I'll just read a small part. Page 2 under the heading 1 says, as envisioned, the state of New Mexico will purchase treated brackish water and treated produced water under a contract agreement with individual vendors. Initially, the state of New Mexico will utilize the contract agreements with individual vendors to facilitate expanded industrial uses of the treated water. You see that?
I see that.
And this is an RFI from your department.
Our department, yes.
But you aren't involved in that, it sounds like.
I am not involved in that.
And actually the rules that you're proposing here in terms of later this year expanding industrial uses of treated produced water, your rules would prevent that from happening, right?
Not necessarily.
I think we agreed that earlier that you can't have a discharge permit for treated produced water under your proposed rules, right?
That is correct. That does not mean that there's not a use for produced water. You just cannot touch the ground or surface waters.
So any uses, industrial uses where there's a potential for a discharge, right? Isn't that the position of the department?
Yes.
Would need a discharge permit, right?
Yes.
And so all of those industrial uses, those could not be actualized under your rule?
Industrial applications are prohibited under the proposed rule. Industrial projects, which are non-discharging, going through the notice of intent process, could be determined to not need a discharge permit and therefore be used.
If I could get you to look at, this is NMED Exhibit 45. And again, I don't mean to monopolize you, Ms. Fulham. Any of the panel is welcome to answer these questions. But earlier, or actually, I think it was yesterday, one of the commissioners was talking about a summary of the reuse discharge permits. And here's a list, right, in Exhibit 45. Is that right?
Correct.
And for each of these discharge permits, the applicant obtained them pursuant to the commission rules, right?
Correct.
Filed an NOI. Is that a no, yes? I'm not sure.
That is not always the case. They can go directly to apply for a discharge permit. So everybody that you see on this list has filed a discharge permit application.
Fair enough. So they filed that discharge permit application pursuant to 20.6.2.3103. Is that the 3106, I think is the number.
I'd have to pull up the right if you want.
If you want to look at it, it's your exhibit 27.
I know the regulations and the exhibit. If you would like me to cite that, I need.
It's okay. We all know what we're talking about. And as part of that, the department determined that the discharge permits that we're seeing here would meet existing water quality standards, right?
Correct.
And be protective of human health and environment.
Correct.
And then there's a bunch of monitoring requirements to ensure that that continues to be true, right?
Correct.
Yesterday, you agreed with the chair. There's a number of unknown constituents in municipal effluent, right?
I don't believe that was my testimony.
You don't agree that that was your testimony?
No, I believe that was Mr. Herman's.
Well, Mr. Herman, do you recall saying that?
So I don't think that I testified that there was unknown constituents in municipal wastewater, but that we had a much greater understanding of the constituents that are in municipal wastewater.
Are there unknown constituents in municipal wastewater?
I think there's the potential for unknown.
You just don't know.
I don't know what I don't know.
So they're unknown unknowns, to use your language, right?
There is a world of characterization that we have a far higher level of certainty when it comes to domestic wastewater.
Let me put it this way. Are you prepared to testify here today to the commission that the department knows all of the constituents of municipal effluent?
No.
One other thing that was referred to earlier today, that's NMED Exhibit 82. And I think, Ms. Fulham, that you were probably the one to testify to this. That is, as I understand that this is a summary of the reuse of those various discharge permits. Is that right?
Correct.
Yeah. And so we can see on here the number of users, the number of acres, how exactly that's being used in terms of rangeland, landscape, et cetera, right?
Correct.
Let me get you to look at NMED Exhibit 76.
Let me get that up.
You have that?
Yes.
On the second page, and I understand this is actually up on your web page, is that right?
Correct.
And here under the overall heading is New Mexico water reuse, right?
Correct.
And then on page 2, we can see benefits. Is that right?
Yes.
And those are identifying some of the benefits of reuse.
Correct.
Can you explain to me the support ecosystems benefit?
I don't believe I talked to it directly in my testimony, but it's essentially what it says. Riverbank ecosystems and habitats need enough water to flow to support wildlife, water quality, and overall ecosystem health. Water reuse can potentially reduce stress on water flow, especially in waterways with canals and dams.
The next benefit is support economic growth. You see that?
I see that.
You understand that reuse of water has the benefit of supporting economic growth?
Yes.
At some point in your testimony, and I can give you the exact page and line if you want it, but Ms. Fulham, you discussed the potential for brackish water to be reused. Do you recall that?
I recall that in my direct written testimony, yes.
Hey, to your knowledge, can brackish water be treated to satisfy existing water quality standards?
I don't know personally. I have not looked into brackish water.
Does any of the panel know?
I believe that there's been a much greater body of research that has been publicly available for a greater amount of time that we have access to. So we can say with a greater level of certainty that brackish water is treatable. And from personal experience in the field, desalination is possible of even seawater for drinking water.
What percentage of produced water in general is brackish water?
I don't believe the two are conflated to be in the same category.
There's no brackish water in produced water?
I don't know if I'm allowed to call that a trick question, but I just
What do you see as the distinction?
I see the distinction as what occurred to that water prior to its existence on the surface when we're dealing with it. There's no hard and fast rule or definition that I adhere to that defines a TDS level as to where brackish water starts, produced water starts, and where brackish water ends. There's generalizations, and there may be overlap in those, but it's more speaking to the source.
If I may add to this, I believe you're discussing information that was used in Ms. Murphy's direct testimony. So
It's actually yours at lines. You have it at 25, page 25, lines 7 through 8. But if Ms. Murphy wants to talk about that, I'm happy to.
yeah, I do talk about the sources of water in New Mexico and the different aquifers and those that are brackish, but I don't delve into components of brackish versus produced water. And that's why I think you're.
Do you have a different understanding than Mr. Herman about the distinction between brackish and produced water?
I would agree with Mr. Herman.
If you look at another exhibit of yours, this is exhibit 52. And I think this was a slide deck that you all gave as part of your public presentation about these rules. Let me know when you have that up.
I have that up.
Yeah, and you have a couple slides there about produced water. They start basically, let's see, there's slides 4, 5, etc. But if you look at slide 5 there, this says produced water overview, what's in it. You see that?
I do.
Yeah, so the first thing is you're showing there 90.61% is water. Is that right?
That's what the slide says, yes.
And then 8.95% is sand.
Correct.
And then the other percent that we're talking about is 0.44%. Is that right?
That's what the slide says.
And then you've identified a number of constituents there on the side: salt, soil residues, sand, mud, metals, etc. Right?
That's what the slide says.
Are there water quality standards for some of those constituents?
For some of those, yes.
For which ones?
For metal, there are some. Are you asking about groundwater or surface water standards?
Let's stick with groundwater.
Okay. There are some for metals. Don't have any for bacteria, and we don't have standards for all of the solvents, surfactants, acids, and waxes, or the biocides.
And also TDS, right? Or salts.
Correct.
Now, we heard, I think several of you testify. I can point you to specific testimony if it's helpful, but several of you testified that there's a fair amount of variability in the types of produced water and contaminants found in those wastewater types. Is that right?
That's correct.
And in fact, produced water can vary, you think, based on the geologic formation or source. Is that right?
I'll defer to Ms. Murphy on that.
Did you hear the question?
I didn't. I'm
Yeah.
sorry.
So my question is, Produced water can vary depending on the geologic formation source, right?
Yes.
And the source location and the
And-
age of the wells,
Yes.
depth of the wells.
Yes.
We heard testimony yesterday about undisclosed compounds that are part of hydrologic fracking. But if we're looking at this slide, we can see that y'all represented that state law requires companies to disclose chemicals used in hydraulic fracturing by filing with Frac Focus Registry, right?
Right.
And yes, I think earlier today, Ms. Murphy, you testified regarding the consortium data portal, right?
The WaterStar water
Right.
data portal. Yes.
And I just wanted to point out where that testimony was for the commission. This is at page 25 of your testimony. So your exhibit is exhibit 4, I believe, in MED 4. And then it's page 25, lines 5 through, looks like 5 through 17 is there. You're talking about the various tiers of the New Mexico produced water.
And I think it starts on page 24.
I see, yeah.
A discussion of the water data portal.
Yeah, fair enough. I didn't mean to exclude that. I just meant to say that the discussion of the tiers is there.
Lines 3 through 21.
Okay. And so you talked about tiers 1 and 2, and the concept for tier 4 is actually it will include the hydraulic fracturing constituents, right? And that would be available to the regulators.
Right. And those are for researchers and regulators, and tiers 1 and 2 are for the public.
Understood. Is there a similar data portal for municipal or domestic effluent in New Mexico?
There is not.
Okay, we had some discussion about the New Mexico Produced Water Consortium. I want to get you guys to take a look at one of the NMOGA exhibits. This is NMOGA Exhibit 18. And you can tell me when you find that.
I'm sorry, could you repeat the exhibit number?
I can. NMOGA Exhibit 18. This is just a way for us to be talking about the consortium. Do you have that before you? And is this a document that you've seen before? This is called Goals and Objectives of the Consortium.
Yes.
You can see there that on page 2, the authors are Mike Hightower, who we will hear from, right?
Yes.
And Pei Zhu, the PhD research director of the consortium, is that right?
Yes.
Who I now understand will be excluded and not allowed to offer her testimony. And apologize because I'm missing my. Let's grab something. Sorry for the delay. I had a small technical issue. If you look down at page 4 of this document under the heading Research Directions and Priorities, you have that?
Yes.
And here you can see the second sentence says the consortium will utilize the Groundwater Protection Council produced water research roadmap recommendations, et cetera, to help focus and accelerate produced water characterization and treatment research and development. You see that?
Yes.
And then it has a number of specific data and knowledge gaps that it'll be fulfilling. Is that right?
Yes.
And you understand the consortium is working on all of those things.
Yes.
If you look at NMED Exhibit 55, you have that in front of you.
It's coming up.
You recognize this documents?
Yes.
Yeah, these are the various MOUs that NMED signed with the consortium, right?
And is this the 22? I'm sorry, I can't see the date.
You know, actually, you have all of them there, so we can walk through them if you want. I think the one on the first page,
It's
if
the
you look at,
2019 that we're looking
yeah,
at.
so that's the first one. And so if we look down on under purpose, again, we can see what it says is, in order to better understand the scientific and technical challenges and opportunities surrounding produced water, the department seeks to collaborate with NMSU for oversight of the project to fill scientific and research gaps related to produced water. You see that?
Yes.
And this was entered, as I think we just talked about, initially in 2019, right?
Yes.
And then attached to that is a description here. And this starts on PDF page 5. You see that?
Yes.
And here we see that it says, with the passage of the Produced Water Act, New Mexico is poised to ensure a national leadership role for identifying emerging transdisciplinary research to fill scientific and technological gaps to efficiently aid the establishment of future regulatory and policy frameworks for produced water treatment and use outside the oil and gas industry. You see that?
Yes.
You think that New Mexico is poised to ensure that leadership role, national leadership role?
Objection. Again, that's beyond the scope of their direct testimony. It's not.
Yes. The question is just, I mean, I'm asking them about an MOU that the department has that they testified to. And the question is just, is this something that they understand to be the role of the consortium? That is having this national leadership role, establishment of future regulatory and policy frameworks, et cetera. That's my question. They did testify to the MOU, and this is their exhibit. I don't think they can run away from it. It's certainly relevant here, and I'll remind you that the only limitation in the rules is relevance. That's correct. Yeah.
Sure.
Okay. I'll respond in the fact that as an attachment to the MOU, the document is labeled and drafted by the New Mexico Produced Water Research Consortium, and it does state that. And I don't believe that I have the capacity to evaluate the state's position on a national level.
Fair enough. Let's look at the scope of the work further down. It indicates, and this is bolded under scope of work. You see that?
Yes.
And it says that the consortium will focus on developing a framework for emerging science and technologies, filling the knowledge gaps necessary for regulatory agencies to then establish science-based rules related to the management and treatment of produced water. Did you understand that to be one of the focuses of the consortium?
Yes.
Let's move on to the next MOU, which starts at page 7. And on the first page there of that MOU, it's under the whereas, it says that NMED and NMSU share the common objective of utilizing the labor and insights of NMSU fellows to assist in carrying out NMED's regulatory work. You see that?
Yes.
And that work is related to management of produced water, right?
Yes.
And so then it says that you entered in the ED entered into this MOU to support the development of strong protective science-based policies and regulations in the most cost-effective and administratively effective, efficient manner, right?
Yes.
And we'll just look then at the date of this particular. It looks like this one was 2020. Is that right? I'm looking at page 11.
Yes.
Yeah. And then again, there's another MOU. This starts on page 12. And again, you understand this to be yet another MOU between the consortium and the Environment Department, or between NMSU and the Environment Department.
Yes.
And again, it mentions here on page 13 under B1B that the Water Quality Control Commission must adopt regulations, right? You see that?
Yes.
And under C, it talks about to better understand scientific and technical challenges, there's going to be this continued collaboration with the consortium, right?
Yep. Yes.
And then let's just confirm when this was signed. So this one was signed November of 2022, right?
Yes.
All right, let's turn to the subject of how the proposed rules were developed. So I think Ms. Philum, in your testimony, you described the process for developing the proposed rules, right?
That is correct.
Now, we were just looking at the role of the consortium and the MOUs that the Environment Department had with the consortium. Did you consult with the consortium when you were developing the rules?
Yes.
And did the consortium support the rules?
Yes.
And do you have any documents suggesting that?
I do not have any exhibits that were submitted on the notes from the consortium meetings we attended, in which the discussion of the produced water component of this rule was brought
And
up.
when you say the consortium supported the rules, do you mean the originally filed rules on December 27th, 2023?
I'm going to make a more general statement that the concept of a restrictive rule has always been in the working process with the consortium.
You think, notwithstanding Mr. Hightower's testimony, you think that the consortium supported a prohibition of on discharge permits for treated produced water?
I don't believe that there's been information that was submitted to us to consider particular criteria, nor has the consortium put in objection during the, I don't know, 5 years of consortium meetings regarding the direction of this rule.
The director of the consortium submitted testimony, correct?
He did.
And what was his testimony with regard to the amendments?
Objection, that testimony was not submitted on behalf of the consortium. Mr. Hightower stated he is representing himself.
That's correct. And it's an important distinction.
And
Mr.
not one
Rizzo.
that all I said was the director of the consortium submitted testimony. Is that right?
Okay. All right.
Yes.
And what do you understand his testimony to be with regard to the First Amendment?
The testimony that he provided, I'm just summarizing it very generally, is that there is a lot of research out there and that they may be able to treat it and that more research is needed. That's just a real brief he filed it. So, I mean,
We can take a look at his testimony and see exactly. We'll ask him.
Right. Hold on. Just a reminder for everyone, we are getting some complaints from the participants on the platform that folks are not don't have the microphone close enough to them for them to be able to hear. Please just pull them a little closer.
So you talked about the various role, like in the way in which those rules were produced. So you had a produced water advisory committee, right?
correct,
It met twice in 2023, right?
correct,
There was tribal engagement,
correct,
stakeholder engagement,
correct.
and then I think you said that the rule was actually drafted by a team of scientists and managers with over 80 years of experience. Is that the team that we have here?
Correct.
Any others?
Before I came to the New Mexico Environment, before I came back to Groundwater Quality Bureau, there was a rough draft that was in our files, and that's what I started with my team. So essentially, it was Miss Murphy, Dr. Who, myself, and Mr. Herman.
Was the consortium involved in drafting the rules?
Directly, no.
Did you formally consult with OCD, the Oil Conservation Division leadership, about the proposed rule?
Can you repeat that?
Yeah, my question is if you consulted with OCD, the Oil Conservation Division, about the proposed rule.
I believe that there have been communications with OCD. I have not personally made those communications.
Did they provide any written suggestions?
Mr. Griswold from the Oil Conservation Division submitted public comment during the comment period.
And is that all? Do you know?
We have had conversations with them previously, specifically about the bright lines that we were trying to figure out where they existed for jurisdictional issues, on where produced water leaves their jurisdiction, enters our jurisdiction, and whether or not it goes back into their jurisdiction at any point.
Ultimately, the proposed rules were submitted on December 27th, 2023. Is that right?
Correct.
Correct.
And before that petition was submitted, I assume that the rule was carefully reviewed by the team?
Correct.
Did the secretary have to sign off on the petition?
I do not know.
As part of that petition, the New Mexico Environment Department produced its statement of reasons, right?
Correct.
Do you know what the purpose of that statement of reasons is?
It's to aid the commission in determining whether a hearing should be granted.
And to understand why the petition should be granted, is that right?
Correct.
All right, let's take a look at the proposed regulation as it was submitted on the 27th. And this is already of record in this case. So this is the original petition for rulemaking and statement of reasons.
Would you mind providing me with the exhibit number?
It's not an exhibit, it's just submitted as part of the case. I'll give you a copy.
Are you referring to? Oh, okay.
It's the original document that was filed with the Water Quality Control Commission initiating this proceeding. Oh, okay. So it is an exhibit 71.
Thank you.
Thank you. So if we look at the original proposed rule 20.6.8.400.A2 and A4.
Getting there. Okay.
And here, I'll look at A4. It says, well, it says treated produced water discharged to groundwater. No person shall cause or allow treated produced water to discharge so that it may move directly or indirectly into groundwater unless the discharger has obtained a discharge permit approved by the department, right?
Correct.
In other words, if you do get a discharge permit approved by the department, then you can discharge, right?
That's what that statement says.
And that provision was changed on March 20th, right?
That's correct.
And so here I'll give you, I don't know the exhibit number, maybe Liz knows. The First Amendment petition and statement of reasons. I'll also give you another copy.
I have the first amended petition. Yes.
Oh, exhibit 1.
Mm-hmm.
Sorry, I don't know if I'm allowed to, but I'd like to go back to your previous question.
Of course.
And just point out that the very next section does have an indication that demonstration projects and industrial project applications determined by the department to require a discharge permit, will not discharge in a manner that may directly or indirectly affect ground or surface waters are subject to the following requirements.
Right, for demonstration projects.
Yes,
Yeah.
and industrial applications.
Understood.
Okay.
Yeah, I mean, I'm not sure. I don't understand how that changes the original part.
Okay.
And we'll have a chance to look at the statement of reasons too. But let's first look at the changes you made. And it's easiest to look at the red line. And we can see here that what you did in both subsection A2 and subsection A4, you struck the language that said, unless the discharger has obtained a discharge permit approved by the department, right?
I actually don't have the red line strikeout as our exhibit, so I will need your version. Thank you.
Let me know when you see that.
Okay. A4, you said?
That's it. You can see it in A2 and A4. You struck the language unless the discharger has obtained a discharge permit.
Correct.
Approved by the department. Now, earlier today, yesterday, in your testimony at page 15, you suggested it was never the intent to allow discharges of treated produced water. But let's look back at that original petition and statement of reasons. And let me know when you have that before you. Yeah.
Yeah, I have that.
And if we look at paragraph 12 of the statement of reasons, it says, Part 8 provides that no person shall cause or allow treated produced water to discharge so that it may move directly or indirectly into groundwater or surface waters of the state, unless that person has obtained a discharge permit from the department, right?
Correct.
Again, the understanding of that is if they do have a discharge permit from the department, then they are allowed to discharge, right?
I believe that there's another part to this rule that had the prohibition or the restrictions.
Let me just ask you this.
Yeah.
Did I read paragraph 12 correctly?
Yes, you read paragraph 12 as it was submitted.
So what provision would you point me to that says that you couldn't get a discharge permit
I would have
of the original rule?
I'm reading through the statement of reasons again. It's been a while. I'm going to refer to paragraph 16, but
Oh, of this statement of reasons?
Yes.
Under
but-
the statutory criteria for adoption,
No, paragraph 16.
which is under,
It
Okay,
is under
I
the
see
statement of reasons. This in part captures some of it where it says Part 8 prohibits any person from conducting a demonstration project or industrial application involving treated produced water unless and until the department has received a notice of intent and made a determination that no permit is required because there will be no discharges that can move directly or indirectly into groundwater or surface water of the state.
and so your contention is paragraph 16 modifies paragraph 12? Because paragraph 16 seems to be talking about demonstration projects, right?
Correct, because demonstration projects were the only projects that were going to be authorized.
Well, that's not what the language of A2 says.
Thus, us submitting the first amended version.
Let's look at A4. And so you're
Of
saying
which version?
of the original, I mean, it doesn't, of the original language.
So NMED Exhibit 71.
Yeah, so A4 indicates that you have treated produced water discharged to groundwater, right? That's the heading. that correct?
Excuse me.
The heading is treated produced water discharged to groundwater.
Correct.
And then we just went over the first sentence, which indicates, I think you agree that if you have a discharge permit, you're allowed to discharge.
Caveat that the next section of authorized uses and applications specifically states demonstration projects and industrial projects are the only things that would be authorized. And I can read that. Demonstration projects and industrial applications determined by the department not to require a discharge permit because the demonstration project or industrial application will not discharge in a manner that may directly or indirectly affect ground or surface water are subject to the following requirements. So the authorized uses is under subsection B, not subsection A.
And your testimony is that language and the statement of reasons, paragraph 12, those were just mistakes?
Statement, paragraph 12 is not a mistake. And
Okay.
the only element that we felt needed to be clarified, because we have definitions for what an application is, it gave the misconception that industrial applications as defined would be permitted. But that is not what the rule was supposed to say.
So this is confusing because I thought the rule was that even under the First Amendment, that you cannot have a discharge permit even for a demonstration project. Am I wrong about that?
You're correct. There is no discharge permit for demonstration projects.
There's no, under the First Amendment rule, there's no discharge permit for any treated produced water.
That's correct. This
and yet the language that was struck said, unless the discharger has obtained a discharge permit.
Correct. There are no discharge permits for non-discharging demonstration projects.
But there's no discharge permits for demonstration projects, period.
I think this is a circular argument. The definition of a demonstration project is to be non-discharging, therefore a discharge permit is not required.
Okay. Let me ask you this. Did anything, were there any new papers, any new information that you received between December 27th, 2023 and March? When did you submit the later one? March 20th or something?
Oh, March 20th?
Yeah. Was there any new information that you received?
Other than speaking internally or from, I guess, clarify what kind of
Yeah,
information?
new papers, new data, new things that the department considered.
I believe, are you asking if we were fed information to change the rule?
I'm just asking if there was something new that you considered.
We considered that we had provided a definition for application and we misused that term in that section and needed to clarify that immediately. And that's what we worked on.
After all those years, all that process, all the double check, you just made a mistake.
Yes.
Made a mistake in the statement of reasons as well.
The statement of reasons was drafted by our attorney based on the information we gave him in the rule. And yes, there are typographic errors, and that's why it's a public iterative process. And that was one of the things we caught in the process.
If I understand correctly, the department is hoping the industry will continue to work on demonstration projects. Is that right?
If the industry is interested in reusing produced water outside oil and gas, I would hope so, yes.
Does the department want industry to actually continue to do demonstration projects?
I personally don't have an opinion on that.
You don't care?
I didn't say I didn't care. I just don't have an opinion.
Do you recognize that it's important not to stifle research and innovation in the area of?
I do.
There needs to be a section that was at 20.6.8.400.d. But you can see in your NMED Exhibit 175, this section was a section reserved for effluent quality for produced water, right?
Correct.
But in the latest iteration, you removed even the reference to that section.
Correct.
And so if there's a prohibition on discharges, why do you think that the industry will be interested in demonstration projects?
I believe it's my understanding that industry has excess produced water that they have a need to do something with. One of the options could benefit the state of New Mexico if they could clean it to be used for beneficial purposes. Essentially, the Groundwater Quality Bureau doesn't dictate people's interests, and we work to try and encourage research and technology, especially for protecting ground and surface waters. So it's my assumption that the industry has an interest in reusing produced water outside of oil and gas. I'm not certain. I'm not an expert on that subject.
Will you acknowledge the possibility that your proposed rule will actually discourage research in New Mexico on produced water?
When we drafted the rule, and when I draft all rules, we always take into consideration the industry that would be impacted. And part of the Water Quality Act supports that we engage with the industry that will be impacted. And that's why, in particular, we developed the Produced Water Advisory Committee.
I guess I'm not clear. Do you think your rule is going to encourage innovation and research in reuse of treated produced water?
Yes.
What's the basis for that?
Because we've now laid out a clear and concise process in order for them to come and propose a research project instead of other states, which would require you to do a full application with a full suite of up to $10,000 worth of initial sampling before you could even get started. So I think this actually does support demonstration projects and gives the leverage and the flexibility for industry to come up with treatment processes that they feel would work for them.
Would it concern you if you learned that industry feels the opposite and that they will not do demonstration projects?
I would be concerned because we've been working with industry for 5 years now.
Do you think the commission should be concerned if that were true?
I think it's something that is part of the Water Quality Act that they're required to consider.
Let's turn to the authority for the rules. Now, you recognize the department must ensure the rules being petitioned before the commission are within the authority of the act, right?
Correct.
That's your language. That's why it sounded like I was reading. In other words, to be valid, your proposed rules have to be authorized by the Water Quality Act or the Produced Water Act.
Would you state that again?
Yeah, in other words, if the rules are not authorized or they're contrary to the Water Quality Act or the Produced Water Act, then the commission couldn't adopt them, right?
Under the Water Quality Act.
They could adopt rules that are inconsistent with the Water Quality Act?
No, they could not adopt rules inconsistent with the Water
Yeah,
Quality Act.
maybe it'll help us to just look at the Water Quality Act, I think is your exhibit 14.
You want the entire act or can you provide a citation?
Yeah, I want the entire act to begin with. I'll give you a specific citation. So let's look at 7464C. Let me know when you have that up. 7464C is in cat.
Yes.
And we can see there that actually the commission it specifies shall not adopt or promulgate a standard or regulation that exceeds a grant of rulemaking authority listed in the statutory section of the Water Quality Act. You see that?
Yes.
And now you identified in your testimony some of the duties and the powers. So let's review the powers that I think you identify, and we can start with 7464D. So you suggest that one justification for the prohibition on discharges of treated produced water is that no party has provided sufficient information, right?
Are you talking about my testimony?
All of your testimony, generally.
Yeah, collaboratively, yes.
Yeah, I mean, I can read. So, for example, this was Ms. Lucas Kamat's testimony. She says, quote, "At this time, the department has not been provided the necessary research and data to propose produced water effluent quality standards. You understand that none of those other parties are proposing to change the existing rules, right?
Objection vague. Could he clarify?
The petition it's the Environment Department that's petitioning, right?
Correct.
And these other parties that you say didn't provide sufficient information, they are not seeking to change the existing Water Quality Control Commission rules, right?
They're not petitioning. It's the department that's petitioning for a rule.
That's right. In other words, those parties you say that didn't provide information, they're not here asking the commission to change the rules.
Objection. I think that misstates their the testimony and their answer.
Is the question, no other party is before the commission petitioning for a change in the rules at this point?
That's a question that I'm happy with that phrasing of it. Sure.
Okay. You want to confirm that?
Nobody has petitioned for
And
rules.
And so the department has the burden, in this case, to provide the evidence necessary to support its proposed changes, right?
Correct.
And here the department is advocating for a prohibition on discharge permits for treated produced water.
Correct.
What credible scientific data or other evidence would you point to for the proposition that produced water cannot be treated to satisfy existing water quality standards?
At this point, the department is not proposing for standards which require that scientific defensible evidence. We're proposing for a regulation so that there can be demonstration projects to provide that data so that at some point we can know whether there's treatment or not. So we're asking for a regulation, not for standards. And there is a specific difference between the two.
If you're asking for a regulation to be changed, you don't think you need to put in evidence to support that affirmative change?
We are proposing for a regulation and we do have evidence on that.
So what's your evidence? What evidence would you point to for this idea that produced water cannot be treated to satisfy existing water quality standards?
I would refer to our direct and rebuttal testimony in exhibits 1 through 208.
You can't point me to something specific. It's just generally in there.
It is very specific based on all of our testimony. And I would beg the commission to not have me read all of our testimony in exhibits.
I wouldn't want that either.
Mr. Wexler, we've been going nearly 2 hours. Would you find a good stopping point for a break?
Sure, this is a great stopping point.
All right, let's take 15 minutes. On this break, by the way, I'm going to ask Mr. Hightower if he needs an accommodation for his testimony. Anyone who wants to be part of that conversation, come on up.
Hey, this is Mr. Maxwell, and I can't hear anything that's being discussed. I'm definitely interested too.
All right. Wow. This is Felicia, Mr. Maxwell. Oh, okay.
I can hear you.
Okay. I was just noting we are making an accommodation for one of Ms. Fox's witnesses tomorrow morning. That's Dr. Lewis. We're making an accommodation for one of Ms. Nanasi's witnesses for Friday. That's the only day he can testify. Dr. Vengosh, thank you. And yesterday on one of the breaks, Mr. Hightower indicated that he was juggling a lot and had travel this week. And so I just sooner rather than later wanted to know what accommodation you might desire.
I'd like to be able to testify tomorrow, and I can do it as late as you want, 9 o'clock at night. I really don't care.
I wish we could stay till 9 o'clock at night. Y'all are being, y'all are being protected from my worst impulses.
I'm gonna stay out of this.
No. So this would be my proposal, that since we're already breaking into wherever we are for Dr. Lewis, that Mr. Hightower follow Dr. Lewis. And that way, what do you think of that?
Tomorrow.
We're-
So public comment
public comment,
Then
Dr. Lewis, and then,
You think you'll finish it?
depends on you all, but yes. Yeah, okay. And will they be crossed as a panel? No, okay, all right. No, that's fine, that's fine. How does that sound? Because we're already taking a serious break overnight in whatever's happening tonight at 5:30. And then public comment represents a break. Dr. Lewis represents a break. And you represent a break. So I just thought we'd pile up the breaks.
So then what you're talking about is like basically having NMED go on Thursday again?
No, they would follow Mr. Hightower.
I'm sorry, are you doing Disneyland after Lewis or you're just doing Lewis?
Well, so if they're not being crossed as a panel, we might want to return to NMED.
That's fine.
Okay.
Mr. Salem has conflicts on. It's
No, you're good. I can hear.
see, tomorrow's Wednesday.
Correct.
He has conflicts for his. I think that it's Thursday afternoon.
Okay. Okay. So just
Yeah.
keep that in mind. Just keep that in mind.
Good job.
Because I know we're piling up breaks, but maybe we don't have to do it just yet. And the department is here
Style
week,
more.
Okay.
And just like.
as the lounge performers used to say.
They don't have to.
Okay. Okay.
Lounge
Thank you.
Where do you hang out after
Oh.
these things?
Have you ever been to Meow Wolf for a punk rock concert? I
Oh.
go all the time.
Really? Okay.
Yeah. Yeah.
So if Mr. Hightower go tonight, did we resolve the other
Yeah,
people
we did.
that he has on his NOI?
Yeah.
They're not coming.
Yeah.
Okay.
One camel nose under the tent, not three. I'm sorry.
So we don't have to worry about the others. So then. Okay, I'm sorry. So tomorrow morning, after public comment, we go to Lewis.
Correct. Then we go to Hightower. And then I am assuming cross of the department might not be quite done. So we'll just go back to cross of the department.
2.5 hours today, so. Okay.
We've got
We have a lot of projects.
select water.
Right.
and Got like 3 hours. So.
Okay.
Okay.
Assured we won't finish.
All right. So we're all good? Any other
So,
accommodations?
Tomorrow, Lewis, Hightower, back to NMED.
Correct. After public
After
comment.
yeah, right.
One quick question.
Yeah.
You're gonna ask me any easy
I am
questions?
presuming.
No, sir.
Based on.
I'm not gonna ask you any questions.
We're probably not going to finish this week. Is it?
We may well not. And I'll tell you what happens if that happens. We pull out our calendars and I start marching through the weeks one at a time until I don't hear any objections.
No, I just wanted to see if the intent was to continue with next week.
Oh, I'm going to Detroit to see my son get married.
Good to know.
Sorry, I just can tell I'm delighted. I love Ms. Gwendolyn. Okay. Anything else?
Can we still have a bit of a break?
Yes, yes. Yeah.
So then, Mr. Stanley, stay. We anticipated it today or tomorrow.
Yeah. We may be able to get it to him tomorrow afternoon.
Okay.
I mean, that would be great.
Yeah, okay.
Okay.
After
But
NMED.
if not,
Yeah.
he does have conflict Thursday afternoon.
Thursday afternoon. I'll write that down.
Okay.
Okay. So, Mr. Maxwell, did you hear it? Did you hear most of that?
Your Honor, yes.
Okay.
Thank you.
Sure. We are back after a short break in the cross-examination of the department panel by counsel for NMOGA. Let me just say, for the benefit of anyone who is considering their schedule based on what's happening in the case, regardless of where we are at approximately 5:25 tonight, that's how long we'll go in the department's cross. Tomorrow morning at 9, we begin with public comment. I anticipate about a half hour of that. We will then move not back to the department if they're not done, but to Dr. Lewis, which is a Sierra Club Amigos Bravos witness, and complete his cross. And then we're going to go to Mr. Hightower, and we'll hear his testimony and complete his cross. And only then will we go back to the department cross in the event we haven't finished tonight. We do our best to accommodate witnesses who have travel plans, and that's what we're doing. So thank you for that, Mr. Wexler.
Thank you. And can I actually ask one quick question about the
Sure.
order of cross for Mr. Hightower? If I understood your rationale for having NMOGA go first, it's because it's most opposed, for example, to the Environment Department's position. But for Mr. Hightower, we're most aligned. So we would like to know if we can go last on cross for Mr. Hightower.
I'd like to stick with our basic order, but let me reflect on that.
Certainly.
Okay,
Thank you.
please go ahead.
Before the break, I had asked you if what credible evidence there was for the proposition that produced water cannot be treated to satisfy existing water quality standards. And you said all of the evidence, all of the various testimony. I have a similar question, and that is, what credible evidence would you point to for the proposition that a different water quality standard is necessary for produced water? Is your answer the same?
I believe that I would refer more specifically to at least my direct testimony and in further detail to Ms. Murphy and Dr. Hu's testimony as far as the source water characterization for produced water.
So just everything in those 6 testimonies.
I'm going to defer to that, yes.
If we look at 74-6-4D, so that's the statute for the adoption of water quality standards, right?
Correct.
And I understood you earlier to say you're not relying on that provision for your proposed regulations. Is that right?
That is correct.
I do think it's relevant, though, to look at the definitions. And so if I could get you, please, to turn to 74-6-2. And first I want to look at B, and then I want to look at C. Let me know. Okay. So B is for water contaminant, right?
Correct.
And it's basically any substance that could alter, if discharged or spilled, the physical, chemical, biological, or radiological qualities of water, right?
Correct.
But I think we have to read it in connection with water pollution. So then water pollution means introducing or permitting the introduction into water, either directly or indirectly, of one or more water contaminants in such quantity and of such duration as may with reasonable probability injure human health, animal or plant life, or property, or to unreasonably interfere with the public welfare or the use of property. Did I read that right?
Correct.
Is there a water well, we talked earlier that the constituents of produced water vary greatly, right?
Correct.
Is there a water contaminant in produced water that is present in such quantity and duration as may injure human health or the environment?
Yes.
Which one?
There is a multitude of them, but I will defer to our expert witnesses on the knowns and unknowns.
Okay, so Ms. Murphy or Dr. Hu, which constituent is present in all produced water that is present in such quantity and duration as may injure human health or the environment?
You know, I would ask, how come the produced water Okay, I would just say that the Produced Water Research Consortium came up with a list, which is called the NPDES Plus list, whole effluent toxicology testing and non-targeted analysis to find out what constituents are in produced water, and that is the best available technology.
I'm sorry, and I just want to point out that your
Wait,
question
I'm sorry,
changed.
Mr. Herman, before I need to understand that answer. And so I will certainly come back to you. I don't want to exclude you, but can you help me understand what you just said, Ms. Murphy? Because I think I asked what constituents, and you're pointing me to some document from the consortium, is that right?
To give you the constituents in produced water.
Is that a document that's in the record?
Yes.
Oh, can you give me an exhibit number?
Just for sake of time, it looks like Wild Earth Guardians Exhibit 4 has that. I believe NMED also did, but I'm not finding the
Wild
citation.
Wild Earth Guardians Exhibit 4, is that what you said?
Correct.
And that's the document that identifies the constituents that are water pollutants?
I will have to look through the whole document.
I have it in there.
It's my understanding that page 14 of the PDF has table 1, analytes, containers, preservations, and holding time.
Anything else?
I believe that there is another list, but I am not pulling it up at this moment. It's through the consortium, so it wouldn't be necessarily part of our exhibits.
Okay, that's helpful. I'm sorry, Mr. Herman, I cut you off.
I just wanted to point out that your question changed between the one that Jennifer was answering and Kathleen was answering, and that you included the word all produced water. Are you looking for constituents that are found in produced water? Or are you looking for a constituent that is found in all produced water?
I am looking for that constituent that's found in all produced water. So should I still look to Wild Earth Guardian 4, page 14, table 1?
I'd like to add on to Ms. Murphy's response. Part of Dr. Hu and Ms. Murphy's testimony is that produced water has not been characterized to give us a constituent that's found in all produced water. And so I think that that is just really, it's premature at this point to ask that from our witnesses.
But if it's not, I mean, I'm asking you to identify the contaminants that are present in such quantity and duration as may reasonably cause injury to human health and the environment. In other words, why produced water is pollution, water pollution. And so part of what I hear you saying is, well, we just don't know.
I would point to the multitude of exhibits, both by NMOGA, by NMED, some of what was provided by Mr. Hightower to all the parties essentially, of the research that is out there and the conclusions in each of those papers that talks about the uncertainties of the study and the constituents that are in that produced water. So I believe that your question regarding water contaminants, there are water contaminants that are known in produced water, and all the research that we've been able to evaluate for this rulemaking indicates that they would be contaminants.
I will give you that chance. I'm going to put those papers in front of you. So let me just ask this. Will you agree with me that all produced water does not have the same water contaminants?
I'm going to refer to Dr. Hu on that question.
I do not have a conclusion for this.
You don't know.
I don't know.
Let's look now at 7464E. And if I understood you correctly, this is the provision of the Water Quality Act on which you are relying. Is that right?
Can you give me the citation again?
Yes, 7464E is an elephant.
You said E?
E as an elephant or echo, sometimes they say.
Got it.
Is this the provision or one of the provisions you're relying on?
It is one of the provisions.
What are the others?
There's also the provision in C.
C.
Oh, not C.
Are you talking about P as in potato?
No. Let me find that other one. Yeah, let's start with E. And if I remember the other citations, I'll
fine.
let you know.
All right. So E, so it says that the Water Quality Control Commission shall promulgate and publish regulations to prevent or abate water pollution in the state, right?
Correct.
And so the first part of this is you have to define water pollution or what pollutant you're attempting to regulate, right?
Correct.
Okay, and here I'm still a little unclear on what contaminant it is. Are you just saying the water pollution is all produced water or some contaminants? This is the part that you lose me on.
So your question
is, what water pollution are you relying on here? Like what contaminants constitute water pollution that these rules are directed at?
As provided in Dr. Who's testimony, there is a multitude of constituents that are considered water pollutants and that we would have to prevent water pollution in the regulations.
Dr. Who just told me that he didn't know whether all produced water had the same contaminants.
That is different than stating that there's no contaminants in produced water that we would have to prevent.
Well, okay, let me just ask you, you tell me what water pollution is the proposed rule directed at?
I guess I need you to restate that.
Subsection E says that the Water Quality Control Commission can publish regulations to prevent or abate water pollution. You with me so far?
Correct.
What water pollution are the proposed rules directed at?
They're directed to, and I'm going to go back to the definition so that we're all
Sure.
on the same page. So it is a water contaminant.
Well, I'm sorry, what is a water contaminant?
So water pollution, as defined,
Oh, understood.
yes, is a water contaminant that in such quantity and of such duration. So this goes similar back to the dose makes the poison. Knowing that produced water has a multitude of known and unknown water contaminants that may or may not cause injury to human health, animal or plant life or property, or unreasonably interfere with the public welfare or the use of property.
But again, so what water contaminants? Just all the contaminants in produced water?
Correct.
All contaminants in produced water are present in produced water in such quantity and of such duration as they may with reasonable probability injure human health and the environment?
I don't believe that it's been proven that it's not. And in order to prevent, that's where the rule comes in.
But we talked about, you're proposing a rule here, so you have to identify the water pollution.
I actually have to identify it if I was talking about setting standards that would be protective of human health.
Except that 7464E says that you have to be adopting a regulation to prevent or abate water pollution. So you have to be able to provide evidence as to what that water pollution is.
I believe the exhibits that NMED has submitted and the testimony by all parties has identified that there are water contaminants in produced water.
Okay, what are they? I mean, this is the whole round and round we're going. I just am asking what those are.
I'm not at liberty to read through all the studies, and I don't have a comprehensive list for you right now.
We have been presented evidence that shows that every single sample of produced water that we have received has water contaminants that fit this definition. We have not received any evidence to show the contrary.
Can you point me to those documents that says that about the produced water?
Yeah.
So there is a study by Canales.
Is it an exhibit?
It is on our webpage, that's for sure. And that is their initial, is it?
Mhm.
The MOGA 110.
The MOGA 110, okay.
Canales' initial characterization of raw produced water, and they sampled to drinking water standards. And that is on our webpage. And then there is, they've sampled and tested according to the produced water guidelines on their treated produced water. That is a consortium data that we haven't received. And then there is the Jiang study, and they have a—
Do you have an exhibit number on that one? I think that is an exhibit.
Yes. Let's see. On 140. And that has I have an Excel table of that, and there is the data from that document.
I'm sorry, I missed the exhibit number.
140.
140, thank you. NMED 140?
Yes.
Thank you. Okay. So those are the things I should look to understand what pollution we're talking about. So if we go back to E, 7464E, so you scroll down a little bit, it says regulations may specify a standard of performance for new sources that reflects the greatest reduction in the concentration of water contaminants that the Commission determines to be achievable through applicable of the best available demonstrated control technology, processes, operating methods, or other alternatives, including where practicable, a standard permitting no discharge of pollutants. You see that?
You said 74E
That's
or
7464E.
Yes.
So are the regulations that you're proposing, do you consider them to be a standard of performance?
No.
No, that phrase says may. And no, we would not consider it a standard of performance.
Okay. Well, it's somewhere, and I think it maybe Ms. Fulham, in your testimony, you do refer back to this this language that says, including where practicable, a standard permitting no discharges of pollutants. You see that? Do you rely on that provision?
Yes.
Okay, so then my question still, if
see.
if I understood you correctly, we don't consider this to be a standard of performance. Is that right?
It may not be considered a standard of performance. We have
Okay.
the right to specify if whether it is.
Well, I'm asking today, do you consider it to be a standard of performance?
I don't know the definition of a standard of performance in this context.
Okay. And then it goes on to say the concentration of water contaminants that the commission determines to be achievable for application of the best demonstrated control technology. So we had this discussion already about contaminants. I don't want to revisit that. But then we go on and has the department provided any evidence about the best available demonstrated control technology?
I'd like to think about this before I just jump right in.
Please.
So control technologies, as this pertains to the act, I'm reading it that it is the control of contaminants into ground and surface water. And the best available control technology based on the information that's been provided to the department to date is that would not allow for the discharge of pollutants.
You
With
don't
that being
understand.
said, this isn't in my direct testimony, this specifically. So
No, but your testimony does talk about the authorization for the rules, right?
yes, it does.
So
Actually, I think it's Mr. Herman's testimony. I'm talking
either
about
one of you
authorization.
wants to
Yeah.
answer the question. I'm happy to.
I would respond in saying that we use different parts of the Water Quality Act to justify the promulgation of different portions. So if you could be more specific to which part of the regulation, or are you just talking in generally?
I'm just talking I asked at the beginning, is this a provision on which you're relying on to support the regulation? And the answer I got was yes. And so I'm trying to understand how it fits, because I'll be honest, I don't see it fitting.
There's another portion of the water quality. If for NOI projects, we require the submission of information in order to make a determination, and that relies upon a different section within the Water Quality Act.
Okay, so that goes for the getting information from the NOIs.
Correct.
And so what about, I'm trying to understand where the authority for the prohibition on discharges of treated produced water comes from.
Yeah, so we're relying upon the first sentence in that provision singly shall adopt, promulgate, and publish regulations to prevent or abate water pollution. We've gone through the water pollution part in great detail in the state or in any specific geographic area. And it goes through some septic and sludge language, and then hard stops with a period.
So you're reading, you understand that this later part of that same paragraph is completely unrelated to the first sentence?
I'm saying that even the next sentence, which is specific to the disposal of septic and sludge, seems to take the paragraph in a different direction and should be read independently of the others.
Let's look at subsection P. So this is 7464P. So it's a little bit further down.
Correct.
And here it's telling the Water Quality Control Commission that it shall adopt regulations to be administered by the Department of Environment for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition in road construction, maintenance, roadway ice or dust control, or other construction, or in the application of treated produced water to land or activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas. You see that?
Yep.
Yes.
Yes.
Are you relying on this provision?
In part.
In part. Okay. So let's see. So this tells us that the commission can adopt regulations for the discharge of produced water, right?
Objection, that word discharge does not appear, I believe, in section P.
Shall adopt regulations to be administered by the Department of Environment for the discharge.
I withdraw.
Yeah, our interpretation of
Continue your question.
Well, that's my question, actually. I mean, that's the first part. The current regulations do not allow for discharge, right?
May I read the sentence in its entirety?
Oh, please.
It says, shall not adopt regulations to be administered by the Department of the Environment for the discharge, handling, transport, storage, recycling, or treatment, or the disposition of treated produced water. The order and the language that comes after the word discharge is relevant to this case.
Okay, well, let's take it one at a time. I mean, the rule that you are proposing does not allow discharge, right?
This is for the disposition of treated produced water.
Well, I'll get to that. Let's do it. I'm just in the order of the statute. It doesn't allow for discharge, right?
yes.
In relation to disposition, correct?
Okay. And then it says handling, transport, storage. Does the rule contemplate handling, transport, storage?
The disposition of treated produced water in relation to handling, transport, and storage, it does not.
Does the rule allow for recycling of produced water?
In accordance with the Produced Water Act, yes, because that is part of recycling is actually defined as the use of produced water within the oil and gas
That's true.
field. And so recycling is handled under a different provision.
Yeah, that's going to be like 70-13-3 or something like that. So now let's get to your language. So then it says or, right? You see the or there?
Or, yes,
Yeah.
I see.
Then it says treatment for the disposition of treated produced water, right?
The order and whether the for the disposition of treated produced water applies to all of the previous list. It's discharge for the disposition of treated produced water, handling for the disposition of treated produced water.
So you would say, well, if I read, I mean, let me just try what I think you're saying, and that is you can pass regulations for the discharge for the disposition of treated produced water. Is that what you're saying?
For discharges disposing of the treated produced water, yes.
Okay, but you're not allowing that.
Because based on what we just went through with water pollutants and promulgating regulations to prevent water pollution, we do not have the evidence that would allow this.
Okay, I'm going to circle back around because I understand this to be part of the statute you're relying on. It then says, I mean, let's just look at the rest of the statute and then I'll come back. And there it says, well, your proposed rule would not allow for disposition in road construction maintenance, right?
Correct.
Or roadway ice or dust control.
Correct.
Or other construction.
Correct.
And it would not allow for the application of treated produced water to land.
Correct.
Okay. In this statute, do you think gives you the ability to prohibit discharges of treated produced water?
Based on the requirement that we must prevent water pollution.
Well, that's not in this provision, is it?
It is part of the act, and we're not.
Okay, you're just going back.
Doesn't circumvent the intent of the act.
You're going back to 7464E.
Correct.
I see. Do you rely in any part on the Produced Water Act for your regulation?
Only for the part that talks about how the Water Quality Control Commission will permit.
Okay, well, I guess because that's your answer, I have to go look at it. Okay, it's 19 is the Produced Water Act. And I think you're talking about sections, it's not the last section, it's sections 70-13-4D. Is that correct?
Yes.
Okay. This reads, for uses regulated by the Water Quality Control Commission pursuant to the Water Quality Act, a person may obtain a permit from the Department or Environment before using the produced water, recycled or treated water, or treated product or any byproduct of the produced water. That's, I read that sort of correct, right?
Mostly.
Mostly, yeah. Fair. Okay, but here, what you're saying is a party cannot obtain a permit, right?
Correct.
Okay. Which again, that's not what the language says. It says shall obtain a permit from the department.
Based for uses regulated by the Water Quality Control Commission pursuant to the Water Quality Act. The Water Quality Act clearly states that its intent is to prevent water pollution. Therefore, if it is a contaminant that would cause water pollution, it can't be permitted under the Water Quality Act. We don't take the act one section and that's the entire act. So that's where this comes into play under the Water Quality Act.
In your rebuttal testimony, if you want to look at it, it's at page 299, lines 9 through 13. And you kind of, you mentioned this several times, but you have this testimony in which you say that subsection P that we just looked at requires the WQCC to adopt regulations to be administered by the department for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water. Right? That's your testimony.
I believe so. Can you tell me the page again?
I can. I think I have page 2, lines 9 through 13. So this is NMED 176. Yeah.
Which lines again? Sorry.
It looks like it's line, the sentence starts at line 9 and the sentence finishes on line 13.
Okay, I'm here. Oops, sorry.
You see that?
Yes.
I picked up that language that require the water quality control. You see that? And so that was your testimony, right?
Correct.
You'll agree with me, I think. Well, let's look at the regulations that you're modifying here, this 20.6.2. And that I think is your exhibit 27.
Exhibit 27, you said?
Right. It's NMED exhibit 27. And then if you look at section 3101 of that, you see that?
I'm getting there. It's a little far down.
It looks like it's on page 20 of the PDF.
$3101?
Right.
Yes.
So I just want to confirm, I mean, here, this is the start of sort of the water quality standards, right?
Correct.
And it tells us that the purpose is to protect all groundwater of the state of New Mexico, which has an existing concentration of 10,000 milligrams per liter or less TDS for present and potential future use as domestic and agricultural water supply, right?
Correct.
I just want to confirm, there are currently no specific effluent quality standards for produced water, right?
Correct.
And you're not proposing one.
Correct.
I understand that the department anticipates proposing a standard for produced water in the future.
As I stated in my oral testimony yesterday, that still remains to be seen.
It remains to be seen.
Yes.
You're not committing to that.
I can't commit without data.
Okay. Now, you say in your testimony that the mechanisms in 20.6.2 allow you to review a discharge plan as submitted by the person, review and issue a discharge permit with conditions to ensure it is protective, right?
Correct.
If you back up, you can see, I mean, the notice of intent provision here is in this statute at 20.6.2.1201, right?
I don't know that it's in this.
Well, it should be on PDF page 7, in there, this is where you do a notice of intent to discharge, right?
Yes.
And then you go back to those water quality standards, and I'm just walking through here. Well, let's look at 3103. These are the standards for groundwater. Let me know when you get there.
I'm getting there.
All right. So
It's a long roll.
it's a long
and
regulation, 20.6.2.
I'm almost there.
3103. Oh, you're not
Yes,
there yet.
I am.
Those are the standards for human health standards, right?
Correct.
And one, you have the numeric standards, and there's a whole bunch of them, right?
Correct.
And then 2 is standards for toxic pollutants, right?
Correct.
And then we also have 3, which is standards for non-aqueous phase liquids.
Correct.
And then we can see there's also standards for other standards for domestic water supply. That's in subsection B, right?
Correct.
And then we can also see that there's standards for irrigation use in subsection C, right?
Correct.
And these are actually reviewed on a periodic basis. They're required to be reviewed on a periodic basis, right?
No.
There's no opportunity to review and propose new standards.
I will state that under 20.1.6 NMAC, which is the Water Quality Control Commission's regulations, anyone can petition the commission to amend these. So they are amended as needed as petitioners feel appropriate.
Yesterday, your council referred to these standards as wonderful. Do you share his enthusiasm?
Yes.
20.6.2.3104, so I'm moving to the next subsection, tells you that a discharge permit is required, right?
Correct.
And it tells you when, if there's a discharge, that it may move directly or indirectly into groundwater, etc., right?
Correct.
And then we go to 20.6.2.3106. This is the application for discharge permits, right?
Correct.
And I want to go down to D, and it tells you what needs to go in a discharge plan, right?
Mm-hmm.
And so as part of your application, for one, D1, the very first thing you have to include the quantity, quality, and flow characteristics of the discharge, right?
Correct.
So in other words, someone comes to you and says, hey, I've got this discharge, and you're going to say, well, you need to quantify it to have the quality and the flow characteristics, right?
Correct.
And then there's a whole bunch of those other things. I want to go to D7, and it says the department can actually require any additional information that may be necessary to demonstrate that the discharge permit will not result in the concentrations in excess of the standards in 3103, right?
Correct.
Which is to say you can do a bunch of other things. You can require additional information to be submitted as part of a discharge.
So long as it will not result in concentrations in excess of the standards in 3103 NMAC.
Okay. And then the next provision actually tells you there's a whole bunch of monitoring, reporting, and other requirements, right?
Correct.
And this is to make sure, like, okay, you have your discharge permit, let's make sure it's safe, right? And so you're requiring all this monitoring and reporting to make sure it's not unsafe, right?
I would rephrase the word from safe
To what?
to meeting the standards in 3103.
Okay. Meeting we saw what the purpose of the standards is to protect groundwater for present and future use, right?
Correct.
Okay. Now, Mr. Ehrman, in your testimony, and this is your rebuttal, page 9, lines 1 through 3. So this is what NMED 177. And lines 1 through 3, you say, Mr. John D'Antonio is correct that it is very likely that produced water can be treated to such an extent that the water quality standards found at 20.6.2.3103 NMAC are met. And so that no toxic pollutants as defined in 20.6.7T NMAC are present. Did I read that correctly?
Can you provide the line and page number again? We didn't have it open in time.
I'm sorry. I will read it again. It's
The line number and page
yeah,
number.
page 9, lines 1 through 3. I should have waited. I apologize. You say, Mr. John D'Antonio is correct that it's very likely that produced water can be treated to such an extent that the water quality standards found at 20.6.2.3103 NMAC are met, and so that no toxic pollutants as defined in 20.6.7T NMAC are present, right? Did I read that correctly?
Yes.
So if we look back at your direct testimony, then I'll actually let you get there first. And this is at page 34. So this is NMED Exhibit 3, page 34, towards the end of your testimony. And I'm looking at lines, and generally I'm looking at lines 9 through 18. And picking up at line 15 there, you say that the prohibition on discharges of treated produced water is necessary because otherwise, quote, the department would have to grapple with processing that application and either developing a draft discharge permit that is protective under the existing 20.6.2 NMAC permitting regulations, or deny the application, which would likely draw a challenge from the applicant. Did I read that right?
Yes.
Isn't that exact thing what the Water Quality Act contemplates, that NMED will process and evaluate applications for discharge permits?
Yes.
Okay, Ms. Lucas Kamat, I want to talk just a little bit about the certification process. And I'm looking first at your direct at lines, page 10, lines 5 through 8. By the way, did I pronounce your name right?
It's close enough.
We'll try me. I'll try and be better.
Lucas Kama?
Lucas Kamat?
Yeah.
Like
it's
with
like
a
a
silent
TH.
T?
Yeah. Like
Lucas
Lucas
Kamath. Lucas Kamath.
Similar.
I'll do my best. I apologize for my shortcomings. So there on 5 through 8, you say that there's no scenario where a person could discharge treated produced water in a way that fulfills the requirements of the Water Quality Act and Produced Water Act in a predictable and reliably safe manner. Did I read that right?
Can you give me the page and line number again?
It's page 10. It's lines 5 through 8. And really I'm picking up at line 6, I guess, where you say there's no scenario. You see that?
Yes, that is what my testimony says.
Yeah. But you don't provide a citation there for that statement, right?
No, not there.
Okay, let's look at the requirements for 401 certification. And let's first look at that Water Quality Act, which is Exhibit 14. Let me know when you have that.
We have that.
Okay, and here's subsection 74-6-5E, as in elephant or echo. Now this identifies grounds upon which the department could deny certification of a federal water quality permit, right?
Correct.
And the first one is if the effluent would not meet applicable state or federal effluent regulations, standards of performance or limitations, right?
Correct.
Well, we talked about this earlier. There's no state effluent regulation, right?
So state effluent regulation in this means the surface water quality regulations at 20.6.4. So you have to meet.
So you'd have to meet that. And you think there's no circumstances under which produced water could be treated to such a level as to satisfy those federal standards?
Based on our current knowledge, no.
Now, the feds, I think there was some discussion about this yesterday. The feds would allow at least discharges or use of produced water for irrigation purposes. West of the, what is it, 90th meridian or something like that.
I'm We're going to see who's quicker, reading or searching.
I'm sorry.
We're going to see who's quicker, me reading or her searching.
Oh, got it.
So as I stated in my rebuttal testimony, go back.
I'm sorry. Can you give me the page and line?
It is page 12 and
12,
line 4.
page 12, line 4.
Oh, actually, it's line 7. Federal regulations also provide for direct discharge of produced water west of the 98th meridian if there's a beneficial use for agricultural or wildlife propagation in the immediate receiving waters.
Okay.
And EPA also has developed a beneficial use tool for agriculture and wildlife watering for such discharges.
But you haven't produced any or provided data indicating that all treated produced water could not meet the federal regulations, standards, or performance limitations, right?
No, but produced water has to meet, you can't just say, oh, it's west of the 98th meridian. As I testified yesterday, it also still has to meet all of the 401 certification requirements, which includes a full anti-degradation and other items.
Yeah, fair enough. In other words, the produced water couldn't cause degradation to the existing body of surface water, right?
Correct.
Okay. Now, if the commission were so inclined, it has the authority to adopt effluent quality standards for specific source categories, right?
Correct.
It could include technology-based requirements.
No,
I'm sorry, I didn't hear.
I'm trying to remember if T-bells are in technology-based effluent limits are called T-bells, and I'm trying to remember if T-bells are in the Water Quality Act.
Fair enough.
Yeah, so that's beyond what I testified to.
Well, I think you testified to a certification process, so certainly that's what we're talking about. You agree that the commission has not adopted effluent limits for most source categories?
Related to surface water, correct.
So other than dairies and copper mines, right?
Those are groundwater quality regulations,
true,
they're not
yeah.
surface water quality regulations.
And they're specifically required by what, 7464K or something, right?
That's outside of my testimony, so I cannot
Okay.
respond.
How about this? The commission has not adopted effluent limits for municipal wastewater treatment plants, right?
The surface water standards do not have effluent limits for municipal wastewater treatment plants.
To anyone's knowledge, so surface or ground, has NMED ever relied on a lack of effluent quality standards to summarily deny all 401 certification for a source category?
To my knowledge, no.
When EPA issues a NPDES or NPDES permit, it makes a determination that the discharge will not cause applicable federal standards to be exceeded, right?
The EPA determines that it will not exceed federal and state standards.
Do you agree that the department has authority to add specified or specific conditions to a permit to make sure the discharge will comply with applicable provisions of state law?
One of the options in the 401 certification process is to certify a permit with conditions, correct?
For example, the department can set numerical limits.
The department can set numerical limits based on applicable water quality standards.
It can also set monitoring, record keeping, reporting requirements.
The monitoring, reporting, record keeping requirements are part of the MPDS permit, and we normally do not set those.
Okay.
Those are in the, yeah.
Okay, let's talk about characterization of produced water. Yesterday we discussed that there are, and I guess we talked about it today as well, there are unknowns and other source categories, right? Unknown constituents.
Correct.
Despite not knowing all the constituents of municipal effluent, for example, the department does not categorically bar certification of permits for municipal treatment plants.
That is correct.
Now, yes, again, today and yesterday, we heard that the department believes that raw produced water is uncharacterized. Now, Ms. Murphy, pages 18 to 25 of your testimony contained a review of papers on characterization of raw produced water, right?
Yes, yes.
Will you agree with me that that's not a complete collection? In other words, there are other papers out there having to do with the characterization of produced water.
These are more specific to the Delaware Basin.
And in fact, there's other papers out there about the Delaware Basin, right? Or are those the only ones you're aware of?
No, they're some of the most common.
You noted that there's 3 different databases that contain water quality data, right?
And what pages is that on?
23, line 5 to 25, line 20. I think you testified those databases were the USGS, New Mexico Tech, and the consortium.
Yes.
And in one of them alone, this is the USGS database, you indicate that there are 7,478 databases for the Delaware Basin, 2,783 data points for the San Juan Basin, right?
Data points.
Yes.
Yes.
How many data points does ED believe are necessary for it to have enough information to develop a standard for produced water?
So these are from conventional wells.
Okay, my question is still the same. How many data points do you think you need for unconventional wells?
We need the water to be thoroughly characterized according to what the consortium has developed that they be tested for.
You would rely on the consortium and
That's a starting point. That's all we have, and that's the best available technology.
would you find it persuasive if the consortium considered there to be sufficient characterization for discharges of treated produced water?
I'm sorry, can you restate that question?
Yeah, my question is, would you find it persuasive? You just indicated you would rely on the consortium. Would you find it persuasive if the consortium said that we think there is sufficient characterization to be able to develop a standard for treated produced water?
I don't think they can say that.
Well, assuming they did, would you find that persuasive?
We would consider it. It's the best available technology at this time.
Before I leave this subject of characterization, both you, Ms. Murphy, and Dr. Hu relied on that Danforth study. This is NMED 133.
I see it.
And both of you relied on it, right?
Yes.
And Dr. Hu, you relied on that as well, right?
Yes.
The Danforth, that source was a review of papers related to produced water from the Marcellus Basin in Pennsylvania. Is that right?
A lot of it was the Marcellus, that's true, but 112 of the 173 sources were from horizontal wells.
Are you aware of some of the criticisms of that study?
I think we've heard some criticisms, but
What are the
there's,
criticisms you've heard?
you know, I can't elaborate.
You don't know what they were.
Not really. I think that when it doesn't propose someone's agenda, then it's criticized.
Did you take into consideration those criticisms?
No, it's a very useful study.
All right, let's talk about some of these unknown unknowns. You described these unknown and unknown constituents. I think multiple of you do that. How much research is necessary from your perspective to feel like you know enough about produced water to develop a standard?
I would like to point out that I think we've answered that question to Commissioner Zimlick.
Yeah, I wasn't sure of the answer, if you don't mind repeating it.
Sure. I think that my answer at that time, and it remains the same, is that we don't have that answer. That is not, we don't have a finish line in mind. We have, it could be one study. I'm sorry, actually may have been Ms. McWilliams, Commissioner McWilliams, but that it could be one study that does a comprehensive investigation into thousands of wells in the Delaware Basin, or it could be a conglomeration of 300 separate studies that did 10 separate wells. But I think the only relevant answer that we have right now is we do not have enough at this time.
It's sort of a, you'll know it when you see it.
No, I would not agree with that. I would not agree with that.
How will the public know when there's enough information?
I think I can try and help clarify things for you. As far as scientific research goes, there are quality assurances and data quality indicators that need to be considered when we're reviewing data and when we're reviewing research. It's not that we will know when we will know. The other thing I would also reiterate is that the adopting criteria and standards is a public and iterative process. And so there is feedback from industry, there's feedback from stakeholders, from the affected community, the public, and tribes. And that does help us formulate whether enough is enough and whether it's defensible. The Act requires scientifically defensible evidence for standards, and that has to undergo a public rulemaking process. So it is a statewide issue, not just the department.
Is there a standard that you would compare it to? In other words, you would say, now we know that we have sufficient information, we've checked it off, the things that we, the department, think are necessary, and now we're going to come propose that rule.
I don't believe the department is in a place, nor have we presented it in our testimony, that there is a definitive number or study that would be conclusive enough to present to the commission. If there are studies and there is data and other individuals find that to be scientifically defensible, they can present that to the commission and petition for standards themselves. But the department does not have that information.
You would invite industry, for example, to come in and propose its own standards for produced water.
The Water Quality Act allows for that, and so does 20.1.6.
Let's look at some of the information that we do have available in this proceeding. So I'm going to walk through and apologize, but because you guys are saying there's not enough information, I need to look at what we do have here. So I want to start with NMED 126.
Let me pull that up.
Yeah, and I'll be walking through a bunch of these papers. And so as you're looking for that, I'll just say NMED 126 entitled Analysis and Prediction of Produced Water Quantity and Quality in the Permian Basin Using Machine Learning Techniques. You have that up?
I do.
So what did you rely on this paper for?
I'm going to likely
Please.
do you have the individuals who cited these papers?
I don't, I apologize.
If you could provide me who cited them, we can have that witness bring them up and
I
they
just
can
don't
explain.
know. Yeah, I apologize.
Let's do a search.
We
I can't testify.
let me just,
No, I'll explain. I cannot testify and we can't have our witnesses testify to something unless we know who testified to it and what they gleaned off of it. So let me pull that up for you.
fair enough. Yeah. Yeah, if you wanted.
Madam Hearing Officer, I know we've been going a little while since the last break, and if this might be another opportunity to take a short break, maybe we could find some of that information.
Sure. It's been just an hour and a few minutes, but we do need a break because then we're going to go as close to 5:30 as we can. Mr. Wexler, do you have an estimate of the remainder of your cross?
Well, we're going to look at a lot of papers, and then I've got about another 40 questions or so.
Okay. All right. Let's take a short break if we could, just 10 minutes. We have about an hour, hour 5, maybe an hour 10 to go today. So we're going to press on, Mr. Wexler.
Thank you. So I'll try and short circuit this. I do want to at least identify each of these exhibits, but can I just get the panel to confirm if you identified an exhibit as a department exhibit, then that's something that you relied on for one purpose or another. Is that correct?
Yes.
And so for those, we can actually go and look at the testimony and identify where that is. Is that right? So I'll do that. I still want to identify some of these exhibits just for the record. But so we talked 126. I want to now look at 131. I'm sorry, not 131. It's 139. And this is a paper from February 21, 2024, prepared, it says, for the New Mexico Environment Department by Dr. Stoll, Dr. Wong, and Dr. Zhu. You see that, and it's entitled Treatment of Oil and Gas Produced Water Generated in New Mexico for Closed System Fit for Purposes Uses. And that's something that you relied on in wherever you identified it. Is that right?
Yes.
Yes. The next one will be 140, NMED 140. And this paper is entitled Characterization of Produced Water and Surrounding Surface Water in the Permian Basin in the United States. And it looks like this was from 2022. And that's also something that you relied on, correct?
Yes.
Yes.
And then 144, NMED 144 is entitled Produced Water Characteristics, Treatment and Reuse, a Review. And this is from 2019, and that's a document that you relied on?
Yes, it's a reference in my testimony.
The next one is 146, NMED 146. It's entitled The State of the Art of Produced Water Treatment. It's from 2018. And that's a document that, or a paper that you relied upon.
Yes.
152 is entitled Volatile Organic Molecular Characterization of Shale Oil Produced Water from the Permian Basin. That's from all the way back in 2016, and that's a document that you relied on.
Yes.
Okay, 157 is a paper from 2015 entitled Characterization of Hydraulic Fracturing Flowback Water in Colorado, Implications for Water Treatment, and that's a document that you relied upon. Is that right?
Yes.
158 is entitled Chemical and Toxicological Characterizations of Hydraulic Fracturing Flowback and Produced Water from 2017. That's a document you relied on.
Yes.
Skipping ahead to 166, NMED 166. And that document is entitled Treatment of Produced Water in the Permian Basin for Hydraulic Fracturing, Comparison of Different Coagulation Processes and Innovative Filter Media. And that's from March 2020. And you relied on that.
Yes.
168 is entitled Selective Separation of Mono and Divalent Cations in Electrodialysis During Brackish Water Desalination, Bench and Pilot Scale Studies. And that's a document you relied upon.
Yes.
169 is a document entitled Oil and Gas Produced Water Management, a Review of Treatment Technologies, Challenges and Opportunities from 2017, and you relied on that document.
Yes.
172, NMED 172 is entitled Multifunctional Photocatalytic Membrane Distillation for Treatment of Hypersaline Produced Water Using Hydrophobically Modified Tubular Ceramic Membranes from 2023. You relied on that document?
Yes.
Is there something about scientists that they can't use one syllable words? Let's see, 173, and this is the last of them. And this document is from 2020. It's entitled Current Advances in Membrane Technologies for Produced Water Desalination. And that also is a document you relied upon. Is that right?
Yes.
Okay. I want to switch over to some of the NMOGA exhibits and ask you about some of those papers and understand if those are things that you considered. And so I'm going to start with NMOGA 22. Just get that up. So this one is a summary report, 2021 summary report from the New Mexico Produced Water Research Consortium with a date of January 2022. It's entitled 2021 Summary Report of Operational, Programmatic, and Technical Accomplishments. Is that something that you've relied upon?
Ms. Fox. Thank you. Go ahead, Mr. Wexler.
So my question was, is that something that you all considered as part of your evaluation of the rules?
I have not seen this.
Okay, let's move on to NMOGA 27, and I understand Ms. Fox, I think all of the ones I will identify will be subject to her objections. The 27, this is another New Mexico Produced Water Research Consortium document dated January 22nd. This one is entitled A Gap Analysis and Research Plan for the Reuse of Produced Water Addressing the Technical, Economic, and Health and Safety Risks of Fit-for-Purpose Reuse. Is that a document that you considered as part of putting the rules together?
You're asking two questions. Is it a document and then that you've looked at, and then is it a document that you're looking at for rules? I've seen this document.
You've seen it.
Yeah.
Did you consider it as part of your work on the rules?
probably didn't have lab analysis in it.
I'm sorry, I didn't quite hear you. I apologize.
I said sometimes these are just, you read them. This doesn't have lab analysis in it.
I see. Okay, NMOGA exhibit 30 is entitled Produced Water Reuse, Current Drivers and Challenges, Technical, Economic, and Health and Safety Issues. And this has a date of January 2022, also from the consortium. Is this a document that you considered as part of developing the rules?
No, this looks like it's a presentation.
Is that right? Well, it's not a PowerPoint, right? It does have a table of contents and.
I haven't seen this.
Thank you. I'm going to skip all the way ahead to NMOGA 75. So this is entitled Oil and Gas Produced Water Reuse, Opportunities, Treatment Needs, and Challenges. It looks like 2022. Is that a document that you considered as part of your work on these rules?
I have not.
NMOGA 76 is entitled Produced Water Characteristics, Treatment and Reuse, a Review. This one from 2019. Is this a document you considered as part of your work on the rules?
Yeah, it's one from my exhibit. Because you just confirmed the same one.
Oh, it's a duplicate.
Yeah, yeah.
Okay, thank you for pointing that out. The next one is 77, entitled Produced Water Beneficial Use Case Studies. This is a document from all the way back in 2011. Is that a document that you considered as part of your work on the rules? Sorry to everyone, I just hit the microphone. That had much more dramatic effect than I was expecting.
I have seen this document.
And is that something, did you consider it as part of your work in this case?
Yeah.
Exhibit 78 is entitled Advances in Produced Water Treatment Technologies, an in-depth exploration of an emphasis on membrane-based systems and future perspectives. This one from, looks like 2023. Is this a document that you considered as part of your work in this case?
No, it's not in my testimony.
Exhibit 79, NMOGA 79, I think this is one that you all considered. I think you had a partial version of this, maybe. This is a paper from Reclamation entitled Summary of Current Research on Produced Water Treatment. It looks like it has a date of September 2016. Is this something that you considered as part of your work on this case?
Yes, I included this one in my testimony.
Yeah, I think it was partial, but I might be wrong about it. Let's see, Exhibit 80, Potential and Implemented Membrane-Based Technologies for the Treatment and Reuse of Flowback and Produced Water from Shale Gas and Oil Plays, a review. This one from 2019. Did you consider this as part of your work in this case?
I need to confirm. Yeah, I need to confirm.
Sure.
Yeah.
So that one maybe you'll confirm. 81, pilot plant evaluation of membrane distillation for desalination of high salinity brines, 2023. Is that a document that you considered as part of your work in this case?
No, it's not in my testimony.
82, laboratory and pilot scale studies of membrane distillation for desalination of produced water from Permian Basin. This one from 2022. Did you consider this document?
No, it's not in my testimony.
84, Can we beneficially reuse produced water from oil and gas extraction in the US? 2020. Did you consider this document?
Yes.
85. Beneficial use of co-produced water through membrane treatment, technical economic assessment. Did you consider this document from 2007? It looks like it was accepted.
I need to confirm.
Okay. 86. Oil field produced water treatment using conventional and membrane-based technologies for beneficial reuse, a critical review. 2022. Did you consider that document?
I also need to confirm.
87. IDST, an integrated decision support tool for treatment and beneficial use of non-traditional water supplies. Part 1, methodology from 2018. Did you consider that document?
I did.
88. Produced water treatment using forward osmosis membranes, evaluation of extended time performance and fouling from 2017. Is that a document that you considered?
No.
89. Potential for beneficial reuse of oil and gas derived produced water in agriculture. Physiological and morphological responses in spring wheat from 2019. Did you consider that document?
I have seen this article.
Let's see, the next one is 90, exhibit 90, entitled Membrane Bioreactor Pretreatment of High Salinity O&G Produced Water from November of 2021. That's exhibit 90. Did you consider that document?
No.
94. Reuse of flowback water from hydraulic fracturing for drilling mud preparation and secondary hydrocarbon recovery. Looks like this is from 2021. Did you consider that document?
No.
95. Review of oil field produced water treatment technologies from 2022. Did you consider that document?
Yes, I have this one.
Yeah, it looks like a duplicate actually, so I apologize for that. 97. Produced water treatment review of technological advancement in hydrocarbon recovery processes, well stimulation, and permanent disposal wells. See the date, but is this a document that you considered? Looks like 2023.
No.
And finally, 117, NMOGA 117. This is entitled Datasets Associated with the Characterization of Produced Water and Pecos River Water in the Permian Basin in the United States from 2022. Did you consider that document?
Yeah, I think you just confirmed the same paper. Yeah.
Oh, I don't remember this one being before. You think it was a duplicate?
I apologize. There were exhibits that were not posted, and so we don't actually have that exhibit available for us.
117?
Yeah.
Oh, I see. Well,
Can
here.
you read the title again, and
Yeah, let me just walk
Dr. Hugh may be able to confirm. She's answer.
Don't have this one.
I've seen this one.
Okay, thank you for indulging me in that practice. If you turn to NMED 199, and well, I'll let you get there first. I think you referred to this earlier, is that right?
Yes.
And will you Can you summarize, remind us what this document is?
This is the sampling procedure, and it has tells, I think table 2 is the list of analytes that you're going to sample for. It tells you the bottles, and it tells you the lab analysis.
Is this, I mean, in other words, it's a methodology for evaluating constituents of produced water. Is that correct?
It's what the consortium has come up with. It's the best available technology, and it's the result of 2 working groups, the 2 risk and toxicology working groups from the consortium.
And actually, that's my question is that a methodology that the department supports?
So the consortium is supposed to bring us the research and the data. This is a credible piece of research that they have brought us.
I see. And the methodology in there, is that one that you're supporting, I guess is my question.
Yes.
Okay. Is there, do you consider, like, we just walked through a bunch of papers, right? I don't know the exact number, 20 to 30 of them. Do you consider those to be credible scientific sources?
Yes, I consider the data from those papers in my testimony.
And Dr. Hu, while you have the microphone, pages 18 through 29 of your testimony covers various types of treatment for produced water, correct?
Yes.
So you cover primary treatment, right?
Yes.
And secondary treatment?
Yes.
And tertiary treatment?
Yes.
And post-treatment? Do you cover post-treatment?
Yes, I cover the advanced treatment and the post-treatment.
Do you cover pre-treatment?
How do you define pre-treatment?
Well, let me give you an example. So if you look at, let's look at NMOGA Exhibit 129. Do you recognize this document? I believe it was submitted to NMED.
Again, I apologize, but because of
Oh.
the way it was posted, anything after 111 or 110 on, I don't have. We can look in the hard copy though.
Everybody look.
I have to ask. Can you give me the exhibit number again?
Yes, 129. And the reason I say it looks like it was submitted to you is if you look in the upper right-hand corner of the first page, it says produced water treatment pilot project, background information for use in NMED treatment permit discussions 2023. I mean, have any of you seen this document before?
It's on our webpage.
Yeah, I think that's right. So I'm looking at, we were just talking about pre-treatment. And you look at page 3 of this document, at the bottom right-hand corner is date stamped NMOGA 003574. And there you can see it says pre-treatment. Raw produced water enters a newly installed above ground storage tank or is processed through a gun barrel to remove oil and solids. Raw produced water is then moved from the AST or gun barrel to the treatment plant where it is treated with chemicals such as hydrogen peroxide, a coagulant, and a flocculant. Water is agitated via a serpentine system of pipes. Water is then put into a dissolved air flotation unit for removal of the solids, and then the discharge of the DAF units has the same TDS as the water going in, etc. Anyway, so that's an example of pretreatment. Is pretreatment something that you testified to in your direct testimony?
I included some of those treatment technologies in my testimony.
The methods that we talked about, the secondary, the primary, the tertiary, the post-treatment, the pre-treatment, those are typically used in some combination. Is that correct?
Yes.
Now, I think you testified there are 7 pilot projects. Is that right?
Yes.
And I'll just look at a couple of them. We don't need to look at all of them. I'll represent, I think they're at NMOGA exhibits 120. It's like it's 128 through 136. But the ones I want to get you to look at are NMOGA 131. And I assume this is a document y'all are familiar with.
No.
You're not. Okay. So here it's entitled Final Project Report and says submitted to U.S. Department of Energy, National Energy Technology Laboratory, and executive summary says Zwitterco has successfully demonstrated the technical and economic feasibility of its Zwitter ionic superfiltration membrane technology for the treatment of produced water in the Permian Basin. But this isn't something that you all considered.
This is on our webpage.
And so
I believe this is a document from the consortium.
Okay. So
and it's a project that was done before probably most of us got here.
So not something you considered. All right, let's try just one more of these then. This one looks like NMOGA exhibit 134. And this may have been one of the ones you described earlier, the Canales bench scale project. Are you familiar with this pilot summary?
Yes.
And here you can see under treatment technology description, it says, Canales has demonstrated the technical viability of producing forage grasses using produced water treated through a conventional reverse osmosis desalination process at the Department of the Interior Bureau of Reclamation brackish groundwater treatment facility in Alamogordo. Have you all reviewed the results of this pilot project?
I'm sorry, what did you say?
Have you reviewed the results of this pilot project?
This is, they've submitted data and it was to the drinking water standards.
The conclusion that I just read about Canales demonstrating technical viability of produced forage grasses using produced water, is that something that you all have had a chance to evaluate?
So we all have actually reviewed that report, and we found that it was insufficient scientifically and not supported, and it did not support utilizing it in our decision-making process, as it was not a peer-reviewed journal article, and it did not follow the sampling and scientific procedures outlined by the consortium, and that would be valid to us.
Based on what you're saying, should I understand that you only considered peer review papers?
No, sir.
Okay, but this one you didn't consider because it was not peer reviewed? You didn't agree with the conclusions?
No, sir. That is not what I stated. I stated that it had a multitude of issues with it that made it less valuable in our evaluation process.
Any other of the, are there any of the pilot projects that you did consider as part of drafting your rules?
I'd like to clarify with all of these studies that we've gone through and with all of the pilot projects, all of that information was considered when we've developed our rule. And that's the result of the rule that you see before you today.
Well, not all of it, right? Because you identified multiple papers you did not consider.
Correct. We have 2 staff that work on doing research and permitting, and they did not review the full spectrum of papers. The papers that they did review are in part literature reviews that did consider these other papers. And I think that should be identified.
Those two people who were doing research and literature review, did they work with the consortium?
Yes.
And the consortium helped them identify the papers that they ought to be looking at?
No.
And how did they work with the consortium?
My staff attended consortium meetings for multiple years, at least 8 meetings a month. Worked with Mr. Hightower. Mr. Herman worked with Mr. Hightower. We were a part of many of the discussions. These papers were not provided by the consortium to NMED. We did our own independent research for literature review.
Did the department inquire with the consortium about papers that they ought to be reviewing?
I believe,
Yeah.
I believe the MOU.
Yes, I can state I personally have requested in multiple presentations any available information we would be happy to review and have invited that information to be submitted to us multiple times.
Okay, let's change gears a little bit. Let's talk about the multi-phase approach that I think Ms. Fulham, you testified to. And if I understand correctly, in a subsequent stage, NMED intends to propose different parts of the rule, right? There are other things that it intends to add into this rule.
Correct.
And one of those might be standards for treated produced water.
Correct.
And the department, as if I understood your testimony, please correct me if I'm wrong, you think it's more efficient to take a multi-phase approach?
Correct.
But that, I mean, I think yesterday you talked about how much effort goes into a rulemaking for the department.
Correct.
With a multi-phase approach, you have to do that multiple times, right?
Correct.
It also takes a lot of effort from the participants.
It does take a lot of effort from the participants.
Yesterday, during your summary, you identified summary from several of the parties that have expressed concerns that they can't fully evaluate or understand the rules without understanding the standards that are intended to be placed in there, for example, for treated produced water. Should the commission be concerned that several parties are telling them that they can't understand the rules without that information?
Can you rephrase that? I'm not sure I understand your question.
Assume with me that some parties, NMOGA included, have expressed concern that they can't fully evaluate and understand the rules without the standards being part of them. Is that something that you would be concerned about, that the parties feel like they can't really evaluate the rules?
I'm trying to recall NMOGA's testimony or comments in which they explicitly said they don't understand the rule.
I think it's probably in John D'Antonio's direct or rebuttal. I'm not sure which.
And he said he did not understand the rule?
That NMOGA has a difficulty evaluating the rule without understanding what the total rule will be.
I do remember D'Antonio's testimony and his statements that he felt that a full reuse rule needed to be presented and that he had concern with doing this in a phased approach.
If the parties can't understand parts of the rule, is that a concern for the department? That's my question.
Yeah, that is a concern.
Let me ask this. And maybe this is in your testimony, Ms. Murphy, I'm not sure, but I think you offered testimony about the quantity of produced water now and in the near future. Do you recall that testimony?
I do.
And given would you agree with me that those quantities are fairly large and increasing?
No,
You would not?
I would not.
How would you characterize them?
I would say that studies need to be done, and the Scanlon et al. Said that there is a 70 to 80 year feedstock for produced water in the Delaware Basin, and the Texas Produced Water Consortium said that produced water quantities would start to decrease in 2028, and those studies that they did were in adjacent counties to New Mexico. And so you have vastly different predictions for produced water quantity, and a good study would be well placed.
Does OCD track the amount of, say, water that goes down saltwater disposal wells?
It's not publicly available data to me, and that's the only data that I had.
You think that the volumes of water put into saltwater disposal wells is not publicly available?
It's not. It's split into enhanced oil recovery and SWD wells. It's not split out. So it's just one volume injected.
You mentioned one of the studies thinks that produced water volumes are going to decrease starting in 2028.
That is the Texas Produced Water Consortium,
Yeah,
page 34 in their report to the legislature.
At that point, 2028, if I understood the timeline correctly from you all, that's about the time you might be proposing new regulations for treated produced water.
I don't believe that we've provided a date of when we would consider.
I think you said you estimated around 4 years.
Objection. That misstates the testimony.
Well, we
Right.
certainly can see the transcript. You don't think you didn't testify to the number of 4 years?
I testified that upon sufficient information, scientifically defensible evidence to adopt standards, the rulemaking process, the administrative rulemaking process takes up to 4 years.
Let me ask you this, because you've had other questions, and I asked you how long and stuff like that. Instead of talking about the time frame, are there concrete steps that the department intends to take in order to work towards developing standards for treated produced water?
Yes.
What are those?
Is working with the Produced Water Research Consortium to enhance the number of demonstration projects, make this rule so that the notice of intent process for demonstration projects is clear and concise. Individuals that want to propose a study can refer to this. They can get a response from the department so they can move on quickly. Currently, it can take up to 60 days if we have all the information, and it could take longer if we don't have the information. So this will streamline that process, encourage the demonstration projects, which are done through the New Mexico Produced Water Research Consortium, not through NMED. And the research consortium can provide the data, and NMED under this rule is proposed to get a copy of the data as well, so that our scientists can evaluate it and do the quality assurance to determine whether it's fit for and mature enough for bringing to the commission.
Basically, I understand that to be work with the consortium, gather demonstration information, Those are the concrete steps.
Yeah, I think part of the answer to that is we don't have funding to do the research ourselves, nor do we have the staff time or resources in order to do it. So we are reliant upon industry to provide us with either the samples or the analysis and the research. And so concrete is a little difficult to get to. We are reliant upon other entities in our search for concrete.
In your answer, Ms. Fulham, you just said that you were going to encourage demonstration projects. Did I hear that correctly?
Yes,
What does the department intend to do to encourage demonstration projects?
this rule in part is designed to encourage demonstration projects and give the entities that want to conduct this research a clear path on how to get that started.
Let's talk about a few of the definitions. I think your most recent proposed version of your rule is NMED Exhibit 175.
Little? Okay.
Sorry, you beat me to it. Okay, and so I want to talk about the definition of proposed water, which is at 20.6.8.7 P5. Have that right?
Proposed water or produced water?
I'm looking for produced water. Did I
Okay.
get the number wrong?
Yeah, it's on 5. It's on page 3.
Yeah.
Number 5.
Okay, so we see there the definition of produced water.
Yes.
I think you had some discussion with one of the commissioners yesterday that this definition is not the same as in either the Water Quality Act or the Produced Water Act, right?
Correct.
Both of those definitions, I believe, end at the words oil and gas. In other words, those definitions, I can give you those sites if you want to look at them. It's
Yeah, I'm pulling them up.
yeah, it's like 74-6-2S in the Water Quality Act and 74-13-2B in the Produced Water Act. I believe those definitions both say produced water means a fluid wastewater that is an incidental byproduct from drilling for the production of oil and gas and ends there. Is that correct?
Correct.
And so you all added and includes formation water, flowback water, and any chemicals added downhole during drilling, production, or maintenance processes during the life cycle of an oil and gas well. And you added the sentence, produced water includes known and unknown water pollutants, right?
Correct.
And what did you rely on to add that language to the definition of produced water?
I believe it may be in Miss Murphy's direct testimony. So the first part is obviously from the Produced Water Act because that is the definition. And then we added some clarifiers. We have to implement this rule. And it is in the best interest of the regulated community and the public as to what the constituents are in produced water. So I believe Miss Murphy's testimony may provide the references or discussion on that, but I'll have to pull that up unless she has it available.
I understand you're looking for the citation, is that right?
Correct. That's correct.
We did add on to the very basic definition that was in the Produced Water Act.
And so, well, maybe you can take it in two parts, that the language about includes formation water to the end of that sentence. So what are you relying on for that definition?
So is that the,
About formation water, flowback water, any chemicals added?
To my recollection, being one of the writers for this regulation, it was likely part of best professional judgment and experience in oil and gas.
Okay, let's look at the next language then. Produced water includes known and unknown water pollutants. And I mean, you're essentially asking the commission to define produced water as pollution, right?
It is a water source that has pollutants in it.
Objection, that misstates the testimony.
All right, thank you. We'll let the witness state it correctly.
Can you repeat? Can you repeat?
Well, my understanding,
thought.
you are essentially there asking the commission to define produced water as pollution, right?
We're asking the commission to define it as a wastewater, which is also defined in this proposed rule, which has known and unknown constituents of concern for water pollution.
That appear in quantities and duration that constitute a harm to human health and the environment.
Correct. Similar to domestic wastewater.
Does domestic wastewater have that definition in it? That language in its definition?
I can read you the definition. So, did you want me to read wastewater or did you want me to read domestic wastewater?
My question is if, I think you were talking about municipal, or maybe you said domestic wastewater or something like that.
I can read the definition just for illustrative purposes. Domestic wastewater means untreated wastewater containing human excreta, I can never pronounce it, and water carried waste from typical residential plumbing fixtures and activities, including but not limited to waste from toilets, sinks, bath fixtures, clothes, or dishwashing machines and floor drains.
But it doesn't include that language that says that is, it contains known and unknown water pollutants, right?
No, it does not state that.
Because water pollutants has to be a water contaminant in a quantity and duration that is harmful to human health and the environment.
Correct.
When I asked you earlier what the basis for that was, you said, well, all of our testimony, you have to look at all of it. Can you point me to something specific that you would say establishes that all produced water contains known and unknown water pollutants?
I think Dr. Who has the most comprehensive summary of what water contaminants are and the variability. I think the testimony from all the parties has explained the variability. So I will caveat that with the word all. But in general, produced water in all the studies that we have looked at and the studies that you have referenced have contaminants of concern. And I will hand it over to Dr. Who to kind of summarize, give you some idea of what those contaminants in produced water tend to be.
Well, before you do that, because you caveated that with the idea of there's variability in produced water, and you said in general, I mean, will you agree with me that not all produced water contains known and unknown water pollutants?
No.
All produced water contains water and water constituents in a quantity and duration that is harmful to human health and the environment.
I'm going to respond in the fact that the source of the water it is a byproduct of extracting oil and gas. oil and gas has known contaminants that are harmful to human health. So I would expect that produced water being a component of that extraction process in general will almost always have components of the oil and gas extraction.
You say you would expect, again, what I'm asking you is to point me to the evidence in the record that shows that.
And that's where I'd like.
Okay, sure.
Sorry.
Yeah. Sorry. Yeah, I cannot make a conclusion for the water pollutant in producer for all producer water. So you ask the water pollutant in all producer water. I cannot make a conclusion for all producer water.
Let me ask you a different question, and that is the water, in your view, does produced water retain its character as produced water after reuse of treated produced water? Does that make sense? In other words, I'm trying to understand how long you think produced water retains its character as produced water.
I am really trying not to do that. I'm going to answer this question because in the reuse world and domestic wastewater, even after treatment, is considered treated domestic wastewater and can be used for applications. For produced water, I don't see that would be any different.
But at some point, you wouldn't be able to sort of track it. In other words, let's say at some point you do adopt, the commission rather adopts standards for produced water, treated produced water, and then let's say it's used for aquifer storage and recovery. I mean, at that point, you're commingling potentially with an aquifer, right? I mean, is that still produced water? I mean, I'm just curious. I don't understand how that rule works.
I'll take a stab at it. So oftentimes when I'm trying to describe different types of reuse and different types of waters, I refer to blue water and red water. And in many instances, there's cases where we will see red water mixed with blue water, and the resulting water is still red. So in the case of domestic wastewater mixing with a surface water into an impoundment, once that impoundment has received some level of domestic wastewater, all of the water in that impoundment needs to be treated as if it were domestic wastewater reuse. And with produced water, it will be the exact same. That if we're talking about a dilution factor of, and this is, I'm making up a number, this is not a hard and fast number, we're talking in hypotheticals. If produced water goes into a tank and it's 1 gallon, and there's 10 gallons of surface water from the Pecos River, we would still consider the resulting water to be produced water. And it would be not a hard and fast rule, it would be a best judgment that we can make at the time of whatever action is being proposed. Did that sort of kind of help?
Yeah, no, that's helpful. It's difficult. It's part of what I take from that. But I just have one actual last sort of subject, and I hope it's short. And it's a different definition here, and it's under definition of recycled produced water, which should be under that. In NMED Exhibit 175, this time it's at 20.6.8.7, I believe R2.
Correct.
Yeah. And we can read the definition there, but is this definition different from the recycled produced water in the legislative definition? In other words, I think that 70-13-3C defines recycled water or recycled produced water as, and I have it written down here, but you're welcome to check it. Well, produced water that is reconditioned by a recycling facility permitted by the OCD of the EMNRD. And so I'm just trying to understand why the different definition.
I can answer that question for you. This is, to the best of my recollection in your reading, this is the definition as provided. It was included in this regulation or proposed regulation very specifically because we currently use the term recycled water a lot. And there is a very clear difference between produced water that's recycled within the oil and gas field that's subject to OCD versus the produced water that this regulation specifically is addressing. And so we have to differentiate, and the individuals, regulated community, and the public that would be referring to this rule would not otherwise know the difference, or that there was even another definition that's explicit to recycle produced water. We need to make that delineation clear for authority and implementation.
I'm going to try and summarize that, at least is the way I understand it. So please tell me if I'm wrong. But in other words, the purpose for this definition here is to apply to that recycled produced water that would, that over which this rule has jurisdiction, it governs, as opposed to that produced water that's permitted by OCD and MNERD.
So recycled produced water is the water that is overseen by OCD. Treated produced water is the water that is being subject to this regulation.
I understand. Yeah. Thank you very much. No, I have no further questions.
All right. Thank you, Mr. Wexler. Mr. Maxwell? And
I'm here, Your Honor.
Thank you. And I want to thank you for sending the email earlier, letting the department know which documents you would be questioning them on. Please go ahead with your cross-exam, and we will have to break in about 10 minutes, but maybe you could get a good start.
Good afternoon, panel. Mr. Harmon, it's good to see you again. Today, my cross-examen will focus exclusively on Ms. Fulham. And with that being said, I anticipate 20-25 minutes of testimony. If it please Your Honor and Counsel Knight, the other at the table, I do not have questions for today.
I'm sorry. There was some beeping in here while they were changing controls. You have questions of Ms. Fulham?
That's correct. I do not have questions for the other witnesses, and I anticipate about 20 to 25 minutes for Ms. Fulham.
Well, no, that's fine. Just if you would please get started. And to the extent you don't finish, I'll invite you to finish tomorrow when we resume Department Cross.
Ms. Fulham, can you clearly hear me?
Yes, I can.
Are you serving as the department's technical expert on the hearing notice in this matter?
Yes.
Yesterday, did you testify before the Water Quality Control Commission in your expert capacity regarding how the hearing notice for this rulemaking hearing was provided to the public?
Yes.
Was part of that testimony that the hearing notice had to be posted, quote, on the agency's website, end quote?
Can you repeat that? I'm sorry.
Was part of the testimony that the hearing notice had to be posted, quote, on the agency's website, end quote?
I believe so, yes.
Your written testimony states that the hearing notice had been posted on the, quote, department's water reuse website page, end quote. Is that correct?
Yes.
I'll need some clarification as your written testimony does not directly make this connection. Did you post the hearing notice on the water reuse website page to satisfy the procedural requirement of posting it on the agency's website?
In part, yes.
Do personnel at the Water Protection Division of the department have editorial control over the content of the water reuse website page?
Yes.
Do you know who the editor of the page is?
Yes.
Can you tell us?
Yes.
Who is it?
It's Kathleen Murphy.
Just a moment. Does anybody else have editorial control over this page?
I think there are individuals that have access, but Miss Murphy is essentially our sole web author for that particular page.
Can you share with us an approximate date that the department's water reuse web page was created?
Mr. Maxwell, I actually would like to add some clarification to that last question, if you'll let me.
Please, we'll come back to this one.
I do recall we do have other individuals. I did state other individuals have access, but Miss Murphy is the only one. But I am incorrect. There are other individuals within the department and that can and do update that page. I don't have names for them though.
Thank you. That was another question. Let's go back to the other one.
Yes.
Can you share with us that the department's water reuse web page was created?
Did you ask when it was created?
Yes.
I don't have that in my testimony, but I believe that we proposed to do that this summer of 2023. I'd have to look for an exact date.
Thank you. To your knowledge, has the Water Quality Control Commission ever claimed that the water reuse page was their own?
No.
Ms. Fulham, did you state in your written testimony that the State Rules Act uses the phrase, quote, provide to the public, end quote?
Yes.
Does the legal definition of this phrase, provide to the public, include specific location where a hearing notice must be posted?
Under the State Rules Act, it does provide what provide to the public requires. It does not provide the specificity as to what page, just the department's page as applicable.
So your testimony is that posting this on the agency's website is necessary to meet one of the posting requirements, correct?
I think you broke up and I might have missed a part of that. Can you repeat that?
Yes. Your testimony is that posting a hearing notice on an agency's website, if it exists, is necessary to meet a posting requirement, correct?
Under the State Rules Act, correct.
In your written testimony, you stated that amendments must comply with the procedural requirements for rulemaking proceedings in 20.1.6 New Mexico Administrative Code, which I'll shorthand as NMAC. Is that correct?
Yes.
Are the rules in 20.1.6 NMAC specific commission's own rulemaking proceedings?
They are the WQC, Water Quality Control Commission's rulemaking regulations.
You'd agree that the Water Quality Control Commission adopted these rules?
I think so.
Do these rules require that the Water Quality Control Commission provide to the public 60 days notice prior to holding a rulemaking hearing.
Yes.
In your expertise of hearing notices, are you aware that the State Rules Act has a default rulemaking procedure that only requires 30 days notice?
The State Rules Act is a 30-day notice.
Again, in your expert opinion, does a 60-day notice provide for at least as much opportunity for participation by parties and the public as the default 30-day rule?
Yes.
Would you agree that a 30-day notice is insufficient for the Commission's rulemakings?
Yes.
Given your expertise of the State Rules Act's requirements for providing public notice, for providing hearing notice to the public, do the Commission's rulemaking procedures also define provide to the public?
Yes.
Does this provision use the specific language of Commission's website or agency's website?
I'm pulling up the citation now.
Take your time.
I don't believe I have the definitions in my exhibits. From my recollection, there is a definition in 20.1.6 NMAC for the WQCC's rulemaking that describes provide to the public. And I believe it states that it should be on the Water Quality Control Commission's website.
Thank you. So, is it true that the procedures adopted by the Commission in 20.1.6 NMAC require hearing notices to be posted on the Commission's website to fulfill this definition of provide to the public?
That would be correct.
If your procedural approach for the hearing notice relied on a 60-day notice, as per the Commission's rules, rather than the 30-day notice outlined in the State Rules Act, why did you opt to apply the State Rules Act's definition of agency's website in the term provide to the public, rather than the rules more specifically defined definition of Commission's website within the same context?
I don't know that I can answer why. I will provide some insight as far as you mentioned about author and who can change websites, and the department who is required to provide the notice does not have the authority or access to the Water Quality Control Commission's website to post that notice. But at the very least, we did provide it on our website in accordance with State Rules Act.
Be a good place for me to take a break on my questioning if you'd like.
Okay, thank you, Mr. Maxwell. We have nearly maximized our time today. It's 5:26. We will resume the hearing at 9 a.m. tomorrow morning with public comment.